Hello and welcome to Legal Bites. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we explain the law one bite at a time. We don't give legal advice, but we do talk about how the law works and try to look into our crystal ball to see how things might turn out. If you're enjoying this on YouTube, we'd love it if you could like the video, subscribe to the channel, share it with friends, all the great YouTube-y stuff. And if you want to listen while out and about, we're now offering our live streams in podcast form where you can leave a rating and review. Links are in the description below, as well as to our clips channel where you can find some of the best clips taken from our live streams. Otherwise, if you want to catch me elsewhere, you can find me on Twitter, Instagram, and Facebook. And if you want to support the channel, you can do so on Locals, Patreon, or by becoming a YouTube member, or by buying some really awesome Legal Bites merch. Again, all links are in the description below. And with that said, let's get into it. All right. Good morning, good afternoon, good evening, wherever you're coming from. I hope you're having a great day, a great week. And yeah, how about this trial? How about it, right?
This has been a trial, and I have to say the way that they ended yesterday was it's about the defense with their last witness. It's a dream. It's an absolute dream, because there's nothing better in this world than getting it from your opponent's mouth. That's the best.
Yeah.
And to finish off your own case, your last witness for your case in chief is your opponent, and to crush it that hard, it's like lawyers fantasize about such things. It never happens in the real world. What is this?
This is not the real world. I don't know. I feel like the travel photos could play either way. Personally, for me, I felt like I'm like, okay, I get the joke. Like a few in, after like 5 or 6 of them, to be like, okay, like you could show all these on a timeline, show a bunch of photos, ask about Machu Picchu, ask about like a few of these here and there, and be like, that's a hard trail, right? Like that kind of thing. You could do that, and then in a truncated way, just lightning round, and it's just as effective as spending as much time as he did. But I felt like if you weren't as convinced, if you were on the side of like, well, okay, like he also deserves to live a life, like he was traveling before, he's allowed to travel with other people afterwards if he feels like, he's capable with help or something, like if you believe his side on that justification, then you probably felt it was overkill, and then you were going to check out for the rest of cross-examination. What do you think?
He's doing intense whitewater rafting, Alita. He's climbing up and down stairs at stadiums, lifting heavy pieces of aluminum, riding camels.
I guess for me, I felt like at a certain point, I just got impatient with the time that he was spending, especially because I know that they have burned so much time on this case that we never got to hear Jenny's testimony. Like, obviously they said early on that they were trying to get Jenny in to testify, but they didn't know if she was going to be able to. So, but there was a possibility. I mean, they had her deposition. So if she became unavailable, there is a possibility of reading her deposition transcript into the record as well.
Yeah,
but
well, if we're going to be overall critical, I mean, overall the lawyer has been garbage throughout this case,
of course,
as we know.
Yeah.
Well, no,
of course.
So time management problems is the least of the problems.
Yeah,
that these two sides have had. But yesterday Owens, who of course hasn't been doing great, but yesterday Owens was shining, at least to me. Maybe it's just by the contrast. Maybe that's it. My expectations are so low.
Yeah.
This is brilliant. I love it.
You got so used to it that like anything below that like bottom baseline was better. But I mean, he was ziplining, he was scuba diving. I saw folks in the chat being like, wait a minute, like why did they just gloss over that? Why didn't they lean into the scuba diving? Because that is, I mean, you have to be in good health to do that. There are some risks with scuba diving, some pretty serious risks, especially if you don't do it right.
I felt it was effective. I liked it. It just went on and on. By the end, I was literally laughing out loud because it was just so absurd. I couldn't hold it in anymore. I lost it a little bit on
Sure.
stream with Ian last night. They broke me.
Yeah. Yeah.
And
Let's say
then, of
hi to some
course, we
folks in the
finish it
chat.
all. We finish it all by alludes to certain islands involving certain people.
Which just makes him look crazy. It just
Yes.
adds to this whole thing that he exaggerates for attention. It does not help
Yeah.
his case that he went there.
Yeah.
And that's what he landed on. That is the thing that he left the jury with in this trial.
Yeah.
Although there are rebuttal witnesses today. So there are supposed to be rebuttal witnesses
Oh,
today. So
good luck
maybe
with this plan. I'm sure the half hour that they have to call these 3 rebuttal witnesses is just gonna really bring their case back from the dead. I'm sure
I
they're just
think
gonna be the most effective half hour of testimony we've ever seen in our lives.
I think they're just hoping that like a little bit like they can just sort of like they can kind of dilute the bad taste in the mouth left by having Sanderson on the stand again at the very end. Just like kind of give a little bit of a buffer for the primacy recency effect. Oh man. But
Uh-huh.
let's say hi to some folks in the chat. Debbie Faison Cook, good morning from Florida. I am ready. Ready. Edward Lake, good morning from the UK. Mike NL, let's go. Elisa Axtina. Good morning, Alita. Good morning to you. How do you think actually, you know what? We'll save this question. We'll save this question for later. Give me 1 sec on that because that is a good question. Llama Green says, good morning, peeps. Good morning to you. Night Eyes. Hey everyone. Hey Kit Kat. Shireen, hey. Robbie Dobby. Hello, lovely people. I hope everyone is well today. Kit Kat, hey everyone. Mew0203. Hey, all from Tokyo. Looking forward to today. Awesome. I love seeing folks from all over the place. Morning, everyone. Beautiful, sunny, albeit cold day in New Jersey from Jessica. Good morning, Jessica. Ultramarine 2. Good afternoon from Switzerland. We've got we've got more folks here saying hi. We've got Genergy saying hi. We've got let's see. Danny Wallace. Hey, afternoon from Scotland. How are you all today? Doing well. So Genergy in Sicklerville, New Jersey. Janet AKM, good morning. Caitlin Ellison, hey friends. Girl Scout, hey peeps. Morning peeps. Jane Stoddard, good morning. Alita and Kurt. And Kennedy Cargo, good morning from New Orleans. We've got another friend from Switzerland, Stefan Gribby. And then, I'm so sorry if I mispronounced this. Probably Voin Despotovich or Despotovic. I'm not sure. Good morning from Southern Ontario. Good morning. So yeah. So let's talk a little bit about yesterday. What did you think of those 2 expert witnesses?
Well, I really liked I really liked the expert witness and the way that they handled it. I thought they started off the day really, really good with that
Yeah.
expert witness who was talking about the neurology. Although calling his own witness nerd twice wasn't really a great move.
Yes.
Objection cringe pretty hard. So not where I was just praising Owen about 5 seconds ago. Yeah. No, that was not that. Whatever you were trying to do, it was totally not working. But the expert himself, I thought did a really good job. And
Yeah.
he handled it really well. It's like the other expert who testified just simply didn't have the same information.
Mm-hmm.
So they drew a conclusion based on the information they had. I like them. I think they do good work. They just didn't have the same information. If they had the same information, they would have drawn the same conclusion. I thought it was a
That's a great
very yeah. And
It's a,
then
it's a great, very effective way of undercutting the other expert, but without coming across as unprofessional.
yeah, and then the psychologist was just brutal. You know, Princeton, Harvard, Case Western, and it's the Dr. Wong didn't review any medical records. I was like, oh, and just looked at self-assessment. It's like, oh,
Yeah,
and
yeah,
I was like, but it's just because they didn't apparently do the work, so their experts look foolish. I mean,
yeah,
if that's the truth, that's the truth. So that's not really the psychologist's fault. It's your fault for having someone who apparently didn't review any medical records because that was the testimony. I'm like, really? What
yeah,
kind of expert is this?
yeah, yeah. But I will say one of my favorite expert witnesses, because Dr. Scher is one of my favorite expert witnesses. Before yesterday, he was like undoubtedly one of my favorite expert. But yesterday, Dr. Angela Eastfold came in and just tore the Dr. Goldstein's testimony to shreds.
Mm-hmm.
Just came in with that chart of like, you know, what percentile Terry Sanderson is in for these various like testing categories, like working memory and what else is there? Organization, planning, all these kinds of things. Like, oh, he's in these low percentiles. And that came up, and it came up in the previous witnesses cross-examination. And I remember thinking like this, like they seem to be, the plaintiff side seems to be kind of hitting some points on this cross-examination with this chart, because like, yeah, these numbers do look troubling. And yes, he is admitting to that because he's a professional and he's not a hack. But, you know, so it's like, okay, yeah, I mean, it does seem like we do have to acknowledge these numbers here. But then she comes in and as the next witness, and she's like, by the way, all of those are self-reported. They are entirely subjective and they do not match with any of the objective data.
Yeah. You mean you didn't talk to the family? Well, no, I looked at, the medical reports by medical professionals okay, yeah.
Well, I mean, and she had a really good justification for not talking to him too, because she was
Oh,
like,
yeah,
he had
no,
been
that's my
talked to
point.
by multiple doctors, and so the conversation that he had with them would have been the same one that I would have had with him. It would have been duplicative. Like it's in thinking about it, at the back of my mind, I was like, you know, when he loses this case, that just means that she just saved him money.
Fair.
So yeah, I will say there was a little bit of critique of the next witness, Dr. Ashkenazi, because on cross-examination, there was a point where he asked about a certain part in her report that she had left out, a certain detail. And the thing is, he was not very clear in his cross-examination. Like if the cross-examination had been clearer, a bit more organized, a little bit smoother overall, it would have been much easier to follow where he was going and to not miss this detail. But he basically asked about how she left out of her report the possibility of masking. And her answer was apparently different from the question that he asked. And that also is on him for not getting the answer to his question. So I was confused about it while watching it and while commenting on it. But I got a great email from another attorney who has been watching and is a personal injury attorney who does a lot of these kind of cases, and gave an explanation of that the masking is in his cognitive. Sorry, hang on. Let me see if I can. I'm not gonna read it word for word, and I'm not gonna say who it is because I don't have explicit permission for that. But I should have pulled that up before starting to talk about it. So Dr. Ashkenazi responded by saying, like, you can't fake good. In other words, like if you are in a poorer state, you cannot fake being in a higher state. So if you are reporting yourself in a higher level, you can't fake that. You because you are not able to do those things. But the question was about his baseline as in the beginning. So him starting off before the accident as a higher functioning person. Like there are like medical reports apparently that he started off as a higher functioning person with his cognitive levels and his activity levels and all that kind of stuff, like well above average. That means that when they're comparing his state after the accident to before, they have to compare it to his baseline, not the average baseline, which might be lower. So if his after the accident, like where he lands cognitively speaking after the accident is like, say this is the average and this is him, but it lands somewhere in between, it's above average, but for him personally, it's still worse. So that's the kind of masking that he was asking about, and how
That's,
like that,
that's the
that can be
question he was
deceptive.
asking. I'm sorry for overspeaking you. I thought you were
No,
done. I apologize.
no.
I was just simply saying if that was the question that he was asking, it was not clear to me that was the question he was asking at all. So
Yeah.
then I
Yeah.
share the expert's confusion in the question.
Yeah. I mean, I definitely, and I understand. I understand what he was getting at, and that actually is an issue for her, but she's kind of lucky that he didn't really understand what he was asking, which is also why when you're going up against an expert, you've got to know exactly what you're talking about, because they are always going to be better, have a better knowledge of everything than you.
Mhm.
So, let's pull up so right now, I'm going to pull onto the screen the what's going on in the courtroom, because they are going through the jury instructions right now before we bring in the courtroom. I muted it. So that's what
It's
they're.
important, obviously, that one of the questions allows them to.
I'm going to mute it again, but only because I want to talk about a decision that came out this morning for jury instructions. Jury instructions, the fighting back and forth is not for everyone. Some people find it really, really interesting. Some people find it absolutely boring, because you're I don't know, there's just a lot of back and forth. It can be very technical. So yes, Cameron F, that's what I was getting at, is the GoPro instruction, the spoliation of evidence instruction. So the defense, of course, was gunning to get an instruction in front of the jury that if they believed that Terry Sanderson was responsible for making that evidence go missing, if they do believe that there was GoPro footage and that he made it missing, they are allowed to assume that he made it missing because it was bad for his case. So they're allowed to make that assumption. For the jury to make assumptions, they are only allowed to make assumptions for like specific situations. And this is now one of them. And that is absolutely damaging to Terry Sanderson's case, because there's a good chance. I mean, you can see it in the chat. I mean, I've seen some people that say that they believe the justification by his daughter Shay. They after having seen the link with the other, the photos that show up on the meetup page, they believe his side on that one, basically. But there are plenty of other people who do not. I mean, because of the way that she wrote her response in that email, there's no counter response from him to clarify that, like, no, that's not GoPro footage. Like, those are just pictures. Like, there's nothing like that. And there was no testimony to say that there was a further conversation after that to say that they were clarifying that or anything like that. So that is a huge, huge, huge deal. So
Yeah, so that's also known as an adverse inference, right? Because the inference is that the footage would be bad, and so it's adverse to the party. And to get that instruction is a huge deal. It's
yeah,
as a remedy. Of course, it's permissive. The court jury doesn't have to find it. You can even get a stronger instruction if the situation warrants it. But
yeah,
to get that instruction and allow the jury to reach that conclusion. Incidentally, for what it's worth, of course, that's not a thing in a criminal case, because, of course, it would be unconstitutional in a criminal case, but this is civil. So
yeah,
just a little point of legal knowledge there.
yeah, yeah. So yeah. Anyway, so this is it's a good move for the defense. Okay, so let me unmute this, and we will continue on.
Comparative fault, and we'll just call it comparative.
We'll see if we can airdrop in and see if we can find our way through this conversation.
May I go to 8 and 9 just for one moment?
Yes.
We're nitpicking, but Judge Tom Green used to say, if we don't get this right, we get nothing right. So number 8, it's
a packed courtroom today.
What amount fairly compensates Terry Sanders for non-economic damages? There's a bullet point that I don't understand.
Yeah, I took this off of the plaintiff's form. That's the way the standard MUJI does it, but it does it when there are more than one category.
True.
So yeah, that could simply be added to it.
That for non.
The only thing I thought about was that it clearly says non-economic damages, and there is a jury instruction that is entitled that, as well as the number 9 clearly says economic damage, and there is a jury instruction entitled economic.
And for the economic damages jury instruction, perhaps it should just say, Gwyneth Paltrow seeks $1. I don't think they need to even need this big instruction on economic damages.
What do the plaintiffs want on economic damage?
Volume is low. Thank you, Veronica B.
Well, I think as the court pointed out, I think we already have the instruction. We've been working on the instruction.
This is as
for a
high as
while.
it'll go. I might actually use
Have it
court
in there,
TV.
and
I mean,
clearly
long
it's
crime.
indicated here on the special verdict.
What I like about it, Mr. Owens, is that it distinguishes the non-economic damage.
Okay.
And
then number
CC's not.
9,
Yeah,
just
I'm gonna
say
put
what
on
amount
put on long
fairly
crime. They do
compensates
closed
Gwyneth
captioning too.
Paltrow for economic damages. Delete the bullet point and the ...
Okay. Is the plaintiff okay with deleting bullet points and the ...
and the empty space to the right, the blank.
This is on 8. I think it's just.
This is
supposed to
on-
align to
This
fill
is
out,
on
right?
9.
8 and 9, just take out the bullet point and the dots.
Yeah, this is going to be louder.
That guy was on and off in about 3 minutes because those were the only brand new issues that they couldn't have predicted. And so we asked that this rebuttal witness be strictly limited. It's not used as an opportunity for the plaintiff to just
Oh, sorry.
restate and sort of get the last word on things that
So we talked about this when the motion came up, and the court agreed that these are rebuttal witnesses. They're not to strike off into new territory. They're not to clarify. They're to respond
Correct. They're just
to issues that came up in the defendant's case. And then, of course, on the counterclaim.
Yeah, sure.
Brand new
That's
issues.
all. Basically, 3 questions, Your Honor.
And who's the next witness?
It's Richard Bain. We're just waiting for him to get on the Zoom.
Okay.
Richard
While
Bain
you
on
do that, then
Zoom.
we'll take a short recess. Thank you. As long, unless it takes longer to get him on the Zoom. Let us.
I was about to
let
say,
the
as long as
bailiff
it
know
takes.
As soon as you get him on the Zoom.
All right. Okay, so we're about to start with the first rebuttal witness. We'll see how this goes. I mean, they absolutely need to try to rehabilitate his testimony because Dr. Scher absolutely destroyed his testimony yesterday. I mean, not yesterday, the other day. So this is one that I think that they probably absolutely need to put back on the
Yeah.
stand, but I don't know. I mean, it'll be interesting to see if they're able to actually rehabilitate him. Because I mean, if they're able to end with him saying, like, actually he's wrong and here's why, then that could be a good way for the plaintiff side to end on a good note. We'll see.
Yeah, I mean, I don't know how they're going to try to rehabilitate this with the time they have left. See, this is where Johnny Depp's team, by contrast, was really, really smart because Johnny Depp's team, Camille Vasquez, they wound up with something like 5 or 6 hours left at the end. They had all this extra time. One of the
Yeah.
reasons they had all that extra time was for these kinds of contingencies because they don't necessarily know what the other side's case is going to be or what's going to happen. And they want to be prepared for the possibility that maybe, oh, geez, we need to call someone,
Yeah.
that we weren't planning on. And, it's going to take 3 hours. Well, where are we going to get that 3 hours from if we haven't saved it in reserve? So they saved themselves this nice reserve buffer. And then they wound up not needing it. But, nice to have it in case you don't. And instead of this situation where you've burned through all your time.
Yeah. No, sorry, I didn't mean to cut you off.
I'm sorry. You just leave your starter talk. I will stop talking now.
No. Finish what you were saying. Finish what you were saying.
No, it's just good trial tactics. They were much better about their time management. Just overall, they just handled their time better. And you saw also where that was a problem for Amber Heard's side with Elaine's like, what do you mean I only have 40 minutes left? Did you
I'm trying, Your
properly
Honor.
account for the did you properly account for the time? I absolutely 100% did. This is all you have left. Deal.
Yeah.
Like, it's
Yeah.
not my fault you weren't paying attention to your clock. Your clock
Time
is your new god now.
Yeah. Time management can make or break a case as well. I think it's absolutely necessary for running a smooth trial, because you can definitely run into problems. We saw that with Amber Heard's case. We saw that, we're seeing that here with them missing out on potentially getting some more testimony. Gwyneth Paltrow's side, really, with Jenny's testimony, it sounds like it would have been really good to get in. Now they are lucking out a little bit because they can still reference it in closing arguments because of the fact that it has come up in the testimony of her sisters, because they asked them to comment on her previous comments about their dad. So, they are able to comment on it, but I really hope that they don't try to lean too hard on it, because I don't think that the jury's gonna be too receptive to that, because of the fact that they haven't actually heard from Jenny herself. Like, they can only just, they know that exists out there. At least, that the one side says that exists out there, but they have not been able to really evaluate that themselves. So
yeah, and it's just a complete fault of how they went about going about things, because they could have called all the witnesses they did and asked all the questions they did if they'd just been more efficient about it. And I think Owens, for example, yesterday was a hyper version of that. Like, that's the, like, just boom, 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 which is very, very effective. But it doesn't necessarily need to be that. The problem was that they just were lollygagging around and seemed uncoordinated, undisciplined. They didn't know seemed unprepared, like they hadn't prepped things, especially on some of the crosses, where it seemed like they didn't really prep things or know what questions they wanted to do, and were inefficient about it. Like Clark Kent with the expert at the start of yesterday, where the guy with the guy expert with the contrast of the films, it's like, here's the old film, here's a new film, and the other expert just simply didn't look at things. That was a very efficient direct. All
of his have been like that.
No, that's kind of what you're looking for, right? That's model. Owens was a hyper version of that. That's also effective if you can do that, but that's not necessary to do all the time. But like what Clark Kent was doing, that's what you're aiming for.
But also he could have done it, I would argue, more effectively if, with that cross-examination of Terry Sanderson yesterday, if he had limited the number of things that he showed and lowered the pace just a little bit, because at a certain point he's just like throwing them up on the screen, like, you went here, you went there, you went here, you went there, you went here, you went there, and it's like sometimes it can be hard to process, and there is a possibility that the jury, if they're not really feeling it, they could just look at that and say, like, I think you're trying to maybe manipulate things a little bit here, there's a chance here that you're going so fast that maybe you're trying to slip something in. I don't know. But where was I going with that? So I don't know. I think that's like an overcorrection that also can have some negative impacts potentially. So, but I mean, with the Depp trial, them having 5 hours, and by the way, that was after they called like 2 extra witnesses that they didn't anticipate, that just like found them during the trial. That was really, really good. So, folks in the chat saying hi to Indy. Yes, she does have some opinions on this trial. She is very judgmental about the lawyering going on here.
I think
not enough treats.
I think your point about the presentation style potentially not working for some jurors is well taken. Obviously, it worked well for me, but I think you're right. If you were in a completely different mindset, it could come off completely differently. I think that's fair, which is also one of the reasons that I think that Clark Kent's style on the whole is more what you're aiming for, because I think it runs runs less into those problems. It's just very efficient. You got through the questions. You didn't overstay your welcome, which is such a problem for so many people in the experts. Just in general, in most trials, it's like, let me spend an hour and a half qualifying you as an expert so everyone knows just how fantastic you are in every way. And then just go through
But did
this
you
and
know
let
that
him
our expert is in the Netherlands right now? She's in the Netherlands right now. And then she's going to Spain.
that's not quite the distant foreign land it might have once been. It's like, ooh, she's in Spain. It must be at the invitation of the Queen. It's like, it's like
Exactly.
how nice.
Exactly. Let me get some questions here because there were a number of them in the chat. Okay, so we've got, we have this one from Debbie Faison on Cook. How long do you think the jury will be out? I should put a poll. Today's a good day to make some polls on that. Because I think it's less than a day. I think that they're going to make this decision relatively quickly.
Especially if they're going to rule for Gwyneth, because they don't have to argue about money. There's only one decision they can make. So if they don't believe, if they were going to rule for Gwyneth, this could be 5 minutes.
Yeah. I definitely think so. But then again, I also feel like I often underestimate how long the jury takes in these, like that's the one area where I feel like I'm the least good at predicting, because I don't know. I always feel like I've made up my mind. I feel like they should have made up their mind too at this point. But I don't know, no more than a day, I would think.
I think Terry's going to be sad, but then he can go right back to skiing, because apparently that was what he was going to do yesterday. Remember? Because they had a big thing about how Terry, they released Terry, and we didn't know they were going to call Terry back to the stand, and someone said, "Oh, I thought he was going to be skiing today."
I missed that comment.
Yeah,
I
it
missed
definitely
that.
happened.
Well, I guess
It was outside the presence of the jury. Yeah, it was outside the
yeah.
presence of the jury, but yeah.
Yeah. By the way, yeah, there's questions. What's Indy eating? She's eating a treat. Mr. Bites came home, and then he sent her over here with a treat. So yeah. Okay, let's see here. We've got Ellen, not Sarah Lee. Do you think Terry will let this go if he loses?
I don't know how he's going to not let this go, because I can't imagine who would take this appeal, because you're going to have to pay up front, and it's going to be expensive for nothing. I don't know. Yeah. It's like, it's over, guy. It's over. Just pay. But that's okay. That's okay. You get to feel like a martyr and a victim, and you get to say how you were done wrong by the justice system, and how the rich and Illuminati have conspired against you to deprive you of your just and true
Gwyneth Paltrow
verdict.
is on Epstein's Island.
Yeah. So I look forward to your absolutely bitter, unhinged rants. Do you remember the time, kids, I got completely destroyed by Gwyneth Paltrow because she used her Illuminati connections against me?
Oh man.
You don't have a case, Terry.
Yeah. I wouldn't put it past him to try. From what it sounds like, it wouldn't help with the whole obsession idea, but hey, look, if somebody truly feels strongly in their case and there's an attorney that is willing to take it on, sure. But I don't think it's
not me.
A good idea.
1, 2, 3, not it.
Nose goes. Kitty McScratch. What witness do you think has done the best and who the least? I mean, I think they've all done different things a little bit, like at least slightly different things. So I have a hard time deciding that. Although I will say, I think that there really is a very strong 1-2 punch between Dr. Scher and Dr. Angela. What was her name? Let me pull it up. I've got Eastfold. So Dr. Eastfold and Dr. Scher, I think that the two of them give such a strong 1-2 punch, because he's like, the physics of the way that he says that it happened is not possible. And it makes more sense for it to be Gwyneth Paltrow's way of like how it happened. So that gets to like the duty breach elements. And so then you have Dr. Eastfold who came in and was talking about basically the injuries and the causation elements, because she's talking about how, you know, his supposed percentiles of his ability to do these functional executive functioning sort of mechanisms, this is all self-reported and completely unreliable, and also it doesn't match the objective data. I think that is just like, if the jury walks away with the reasoning and the conclusions for those two witnesses, it is very, very difficult for them to come away in favor of Terry Sanderson.
Yep.
That, alongside the fact that Sanderson's case is very heavily reliant on believing the credibility of Craig Ramon as the only eyewitness, and believing that not only is he unbiased enough that he wasn't changing his testimony to fit the needs of his friend, but also that he doesn't have perception issues that get in the way of the reliability of what he says he saw. So, yeah. But yeah, what do you think?
Yeah, I mean,
As far as
that's basically the bottom line. It's like there's just not simply enough evidence to really conclude that Gwyneth Paltrow is responsible for this, at least in my humble opinion, and that there's really no long-term damage that she's responsible for. So even if they're going to rule for him, which seems unlikely, I think the damages are going to be much less than he's asking for, because it would, I mean, the proper amount of damages, at least in my view, if you think that she caused the accident, would be relating to the medical bills relates to the broken ribs, because that would be what she's responsible for. There's no long-term loss. And I don't buy this emotional stuff at all in this particular case. So
that was the other thing from Dr. Eastfold's testimony, was when she was talking about how, you know, all of the previous witnesses, all of the previous expert witnesses from the plaintiff side, they were all saying, I was relying on the before and after testimony of the family members and the close contacts of the plaintiff here, and on their testimony. So they were basically just accepting what they said is true, using that as data for their evaluations. And so with Dr. Eastfold, she gave such a clear explanation of why it is that you really can't put that much weight into what it is that they say. Although, yes, they are around and they are there to pick up information. And sometimes that can be helpful. And especially I can't remember if she said, especially in the context of litigation, but like, that's what I'm thinking is, especially in the context of litigation, you have people that have very strong emotional connections to this person, and they want the best for this person. So they are going to say things in a way that is most beneficial to them, but also they might have a skewed perception of this person's abilities based on their past memories of this person. I mean, you think about the daughters, they were talking about how he's always been this guy that can do everything. He's like their hero, so to speak. I don't know if they actually believe that, because they don't seem to really be that close, although they said that they were. So they oh, okay. I guess we're going back. So, okay. I thought they were shifting to come back into the courtroom. You know, like they said in their words, like, yeah, we're close. We love him and we see him from time to time and all this kind of stuff. But like, then when questioned of like, well, how many times did you see him afterwards? And when was the last time that you saw him before the accident? So just how, and also, how did you didn't know about all of these things that he's been dealing with, all of these medical issues that he's been dealing with. He didn't tell you. Like, I understand that not every family is like super, super close like that, but it is strange to me that a father wouldn't be open about his medical issues with his own adult children, if that is a relationship that is as caring and close as they wanted to make it seem that it was.
yeah, I mean, I don't know how people react to all kinds of things. Some people want to deal with it privately, and some people just don't want the attention. You know, I think of like like Breaking Bad, when you're bringing that to mind, how Walter White, like he didn't want to initially tell his family and stuff like that, and then based on the way that the like Hank and his wife responded, you kind of understood why. It's like, he didn't want that response, and
Yeah.
there are people who just, there there are different people of different styles. It's one of the reasons that there's medical privilege in the first place. It's like, Norm Macdonald, of course, quite famously, by way of example, he died without people knowing that he was sick publicly. I mean, I
Yeah.
can't speak to what his family knew, obviously, but I'm just saying that a
Yeah.
lot of people who get ill and make a deal of it and don't do it.
May be seated.
So,
Yeah.
Are we ready to bring the jury in?
No, Your Honor, we're having some.
Okay. All right.
Not ready yet. Okay.
I just
That's
look
a,
forward
that's a
to.
good look.
Oh yeah, no, I like that. It's sharp.
I like that
I
look.
just-
She's had good fashion this entire time.
Yeah, I just look forward to, if I'm ever on the stand, people talking about my issues and stuff, and just relaying all my issues out there for the world. That'll be exciting.
Well,
Here's
if
you on this
you-
stream. Here's you on this stream. Like,
I mean, if you do bring a lawsuit against someone and you are making those kind of claims that your whole life has changed for the worse, then yeah, that kind of stuff is going to come out.
at least Alita's got my back. I got that going for me.
Of course. But yeah, there was that point yesterday at the end that he was going into, like, basically how he's been like steamrolled by this trial and all this kind of thing, which it would have been better if he had just limited to how he subjectively felt throughout the trial, because anyone can have empathy for how something feels to go through, even if you disagree with them. But then he expanded on it a little bit too much by saying like, oh, and I understand that, like, that's what they're going to try to do is to try to destroy me. That's what they're, what they're going to do in response, almost like as if like the other side is retaliating against me. And to that, I was like, I remember thinking like, man, one of his attorneys should have explained to him the purpose of that process and how uncomfortable it's going to feel, but how the other side is not necessarily doing it to be terrible, but because
Ready
that
for the
just
jury?
looks like he's complaining on the stand for bringing a case that he chose to bring.
Yeah.
Okay.
Test.
Okay.
I hear you guys.
Heather Green, no, the camera's not allowed to just zoom in on Gwyneth Paltrow's face like that. There are some rules about that, and they have not always been followed.
Thank you.
Prior to that.
And also the question about his VA medical bills. He probably still does have medical bills, even though he's been getting treatment at the VA. Even if you are active duty and you have TRICARE, that's the medical program for the people that are active duty, as opposed to VAs for folks that are out. Folks that are actually retired from the military oftentimes still get TRICARE. I don't know the exact specifics of it. Anyway, even with TRICARE, which is supposed to be better than VA, you still have co-pays and things like, I can tell you from personal experience. I have TRICARE, and you do have some expenses from time to time that you have to pay. So with the VA, it wouldn't surprise me if he actually does have some
Say, would
bills,
counsel
but even
approach
if
the
he has
bench?
gotten them substantially reduced by the fact that he got that care at the
Need to show
VA.
you.
So, all right. Looks like we are almost set up.
I love the fact that it's called TRICARE. It's like we're going to give it a try. I know the try means 3, but still.
I will say though, I have no complaints about TRICARE. It has done us well. And it's one of the reasons why I'm like, I told Mr. Bites, I'm like, I I don't want you to get out before we have kids. Because I know people who have, and then they have like normal health insurance, and then they were like, oh no, this is so much more expensive. So yeah.
Can you adopt me? I'm in need of a new healthcare plan.
You might be a little bit too old for adoption.
No, I'm not. No.
Yeah. And yeah, Heather Green. Yeah. I know your question was about the rules, and I only answered so quickly because I thought that we were getting started, but I guess we can elaborate a little bit more on your question about the camera zooming in on Gwyneth Paltrow. Some people feel like that's very ticky-tacky because it's like, oh, this celebrity wants celebrity treatment, like, oh, she doesn't want the camera on her face. Well, this is an actual court order that the judge made a decision on. Both sides argued it. So this was something I don't know what the arguments were back and forth on it. I just know that the order exists. And so this judge, weighed the pros and cons of it, just like any other argument that we've seen, in these sidebars when the jury's out of the room. Obviously, we can't hear what they're talking about in this kind of a sidebar, but he's a pretty well-reasoned judge, and so I assume that whatever back and forth happened, the judge gave the same amount of reasonable credibility to both sides and determined that this was the best way to move forward. Possibly also because, it can become disruptive in the courtroom. It can be, there's all kinds of reasons why he may have had this standing order to move forward. So it rubs some people the wrong way, but honestly, I don't have a problem with it.
Good morning, members of the jury. Sorry for the delay. Just be assured that we've been working very hard, and I think the rest of the morning, as a result, is going to go much smoother and much faster. So,
Lord, I hope
thank you.
so.
Mr. Bueller?
Plaintiff Terry Sanderson calls Dr. Richard Bain on rebuttal.
Mr. Boehm, I'm not sure if you can see me. This is Judge Holmberg speaking. If you could please raise your right hand to be sworn in as a witness.
Your Honor, I do not see you. I just see myself.
No, he's frozen.
Do you swear that the testimony
He's
you are
got a
about to
bandwidth.
give in the case now before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, reporter.
Once again,
Dr.
Dr.
Bay,
Boehm, if
Matthew.
you could state your full name and spell it,
Did you see
please.
the closed caption? They said Dr. Bay.
It's Richard Bain, spelled B-O.
Oh no. This is like that time that I
think
did a
that's
members only live stream
BOEHME.
from a hotel.
Can you hear me, Dr. Bain?
That's affirmed. I can hear you loud and clear.
Okay. Thank you. I understand you're on vacation, and we appreciate your time. Dr. Bain,
Yes, I am.
Dr.
There's a
Bain, in
delay.
trial testimony this week, the defendant's expert, Dr. Irving Scher, disputed your findings regarding the ski collision between Terry Sanderson and Gwyneth Paltrow on February 26, 2016. Have you had a chance to read his trial testimony? Did you say something?
Yes, I have. I read it.
Oh
Okay.
no.
Doctor,
We're losing a few of your words there.
yes.
Oh
So
no.
maybe Dr. Boehm, if you would start off your speech with something that will then kick in the audio so so here's my answer, something like that before you answer.
Roger that.
Okay. Dr. Scher suggests that you made an error in your calculations. How would you respond to his suggestion?
Here is my answer. Dr. Scher mischaracterized my analysis analysis, which led to his analysis being misleading and incorrect.
Okay. Could you explain that in more detail, what the analysis is that you want to correct?
Sure. Well, Dr. Scher first wrote up the impact force formulas, and he labeled one of them wrong and one of them correct. And both of them are wrong. And why? First of all, the equation F equals 1/2 mv squared over d, where he substituted 1/2 AT squared or 1/2 AT and then AT in the parentheses for velocity. You can't do that without solving for time or t first. Basically what you have from a
Oh my God,
mathematical
are we really doing
standpoint,
this?
you have force
Without visuals.
and time, which you don't know. So you have two unknowns in one equation. So basically the equation is unsolvable. So you have to first solve for time. And you guys have there. So
Are
if
we
you
really
go over to
debating
the
math
first one where
formulas
you
right
have
now? Is
x
this what we're doing?
equals x0 plus b0t plus 1/2 AT squared, you have to know the height at which Mr. Sanderson fell to the ground.
Dr. Bain, could you share your screen and show us your calculation? Let's see if I can.
I don't here, and I'm trying to figure
Oh yeah, that's definitely going to work.
Oh no.
Let's
This is a disaster for his side.
pull it up.
This is a
Go over
complete
here.
disaster for his side.
Do you have it?
Not yet. We'll try to share it. Here.
You see that? Your internet connection is unstable. Oh, comedy
I
hour
have dealt
brought
with
to
this.
you on
I have
Legal
dealt with this many
Bites.
times.
Oh, no.
I can empathize with this. Oh God, if this were me, I would be panicking. I would be absolutely panicking.
See that better?
This was
This is
actually
all-
this was like me the first day I live streamed this trial because my
Blur
internet
our
wasn't working, and I was
screen.
like, oh
Just a
no.
second.
I'm going to show it to you.
Clock is ticking. Tick, tick, tick.
That sucks.
All right.
But this is why when it comes to tech in the courtroom, you've got to test it out before.
Okay.
Oh,
But that's still grainy.
All right. I'm
This is
just
not as effective as
had to
what
unblur my
Dr.
screen.
Scher did.
show it to you.
what is it?
but
T equals
my
the
exhibit.
square root of
0 plus b
0.20408
for time.
What?
So the height at which
Stephanie Olson, welcome back to Bite Club. So happy.
Sanderson
Thank you
fell
for becoming a YouTube member.
Your
Which is
network
F.
bandwidth is low.
over T, and you can see that less than a 0.46.
Yes, this counts against their
Okay.
time, plaintiff's time.
The second, are you substitute time in for?
Oh my God.
Determine
Oh
the
yeah, a jury's definitely going to be able to
Fine.
understand that. Holy God!
No.
In the time you've got to work with,
We know
they're definitely going to. Oh
because
yeah,
for
that's. I totally see that.
Dr. Bain?
everywhere on this gravity is time.
Oh God.
Oh,
I haven't seen
If you-
equations like this
Dr.
in
Bain, we're having trouble hearing you.
20 years.
If you could avoid the
You know?
pauses, it might work better.
No, I
Uh,
don't think it has anything to do with his
Hear that.
pauses. Oh
so
God.
you see the 1/2 with it there.
Your
Now,
Honor, we're getting about
been
a
working
fourth of what he's saying. So this either needs to
Dr.
be
Bain?
fixed or stopped is our motion.
Yeah, Your Honor, let me just try one last thing.
Yeah,
Okay.
I've got nothing
Dr.
from
Bain?
this.
Could you stop your video and then
Other than
just talk
Dr.
once
Scher's
you've shown the
analysis is
formulas?
incorrect. That's what I got from
That
it.
way the
move to strike
signal might be clear.
unintelligible.
right, IT guy. Well,
It could be the connection in the courtroom, or it could be the connection at the hotel. I have live streamed
Now-
from many a hotel,
What-
and some have been good and some have been awful.
What
As
the
members of
hell's the
Fight
court
Club know
reporter
well.
supposed to do?
Sorry, counsel, but it doesn't sound like
What
it's.
the hell's the
Yeah,
court
the court-
reporter supposed to do? Can you explain
I
that to
don't know
me?
what court reporters do. I don't know.
Just
know.
question mark,
I mean,
question mark, question mark.
Yeah. Dr. Bain,
gobbledygook letters and numbers.
Dr. Bain,
Sir,
can you hear me?
yes, here.
Can we call you on your phone? And because we're having technical difficulties with.
Oh,
video.
let's get it on a phone call without visuals.
Roger
That's
that.
definitely gonna work.
Hey, should I call your cell number?
On the iPad, if that gives you,
Objection, unintelligible, move to strike.
Objection. Dr. Bain is on the International Space Station. Don't know why he's vacationing there, but there is no connection. Oh boy. This is, I mean, it's, I don't like to see this because I want to see both sides like put on their best. You know, I want to see what Dr. Bain has to say to respond to this. So it sucks if they have him there, they're, you know, they've got a plan and they want to put it forward. I want to see what they're going to do with it.
Yeah, but if I don't know what it says
they're
about
going
my
to video conference.
I don't know
or
what it
they're
says
gonna-
about my
they're gonna call
person.
him.
I don't know what it says about my personality, but if I'm the court, I'm like, this is distinctly not my problem. So sit down and shut up, because this is on you.
Some judges are like that.
I gave you the opportunity. You screwed it up.
Yeah. I was being sarcastic about the International Space Station comment, by the way.
It's okay. Now we're gonna try. Now we're gonna try FaceTiming this or something.
Removed from the jury's view until it's discussed.
We're in court. We're trying to talk to him on the phone.
Okay, they're gonna call him on the phone.
What number should I call?
This is definitely gonna translate on a cell phone quality call.
This
Let me
is
tell
such
you
a
what.
disaster. Yeah, I honestly I empathetically feel for plaintiff's team right now for this problem, because that sucks. And I've been there with live streams and you know, like that kind of thing. But like I said, this is why any tech in the courtroom has to be tested ahead of time. They've been there for well over an hour arguing about these jury instructions and things like that. So they could have had someone on their team testing the connection to see like, hey, like, is this going to work, or do we need to fix something? Because right now they might be using up their precious time.
Oh, I would definitely 100% at a bare minimum count this against their time. 100%, I'd count this against their time if I allowed it to continue at all. I probably would have lost my shit long ago and gone viral at this point.
As a judge?
Yeah.
I mean, they know what their time is that they have left. So.
Okay.
You want me to FaceTime or what?
No, we're just going to do it by audio.
Oh, no.
But then we
Yeah,
can't
just,
see
you're
his
live in
calculations,
court,
his math problems.
The jury can hear you.
This is just straight up math.
That. And so do you have my equations up?
Shireen, this judge has a patience of Job.
Yeah, no. Yeah, he and I would have distinctly different styles.
Okay, Dr. Bain,
Sure.
we've got your equations up.
Stop wasting my
Dang,
time.
okay.
Stop it.
So
Same.
do you have the sheet where it starts off with x equals x0 plus v0t and so on?
Yes.
Okay, perfect. All right, so as I was saying, should I continue, sir?
Yes, please.
Roger that. So in order to make the equation work, you have to solve for time, which is t.
Oh no, the call dropped. Oh no. Oh no. Why? Why is this happening? There's Craig Ramon in the courtroom.
Would it make sense to
Help.
take your next witness while someone is outside trying to reestablish? Okay.
Only witness. Okay, so I have that. So no Dr.
For
Goldstein.
one moment, I'm seeing a potential problem. I guess I could just bring it out while they're calling. I was prepared in cross to maybe show Dr. Bames some documents or even draw some things. I wasn't sure whether I'd get into that.
I don't think you're going to
depending
need to
on what I hear,
cross-examine
I was
him.
going to do that. I know I don't have a ton of time, and maybe I decide not to, but this obviously makes it so I can't do that, which is a problem. If I decided that I
both
wanted
parties
to.
are going to be hamstrung on this.
Yeah.
So why don't we take it as it comes?
Yeah, but they're the one creating the problem. So both parties are hamstrung is really not a fair response.
I don't know. Kind of is, though. Andy the Game Maker, thanks for the super chat. Uncivil Law, OnlyFans wears pictures of Kurt in a judge's robe.
A judge just lost their job in New York because of this.
I did
There's
see
a
that.
there's a video on Nate Brody's channel about this.
An
A judge in
ALJ,
New
right?
York.
An
Yeah.
administrative law judge.
Once you get the time, 0.466 seconds, that's the time it takes
This is a
to
disaster.
free fall from a specific height, X, which is measured on Mr. Sanderson, which is 3.5 feet to his ribs. And then you substitute T into the equation velocity equals 1/2 AT squared. In this case,
Illegal.
typically for
The hottest gavel action.
equation, it's V equals AT. Now, the reason I put the 1/2 in there with the asterisk, and keep in mind, I've been on this case for 2 years, and up until this point, no one has ever asked me why that asterisk is there with the 1/2. Well, keep in mind that those equations are for free fall events. So if you're suspended in the air by X, 3.5 feet, and you are dropped to the ground, that's the velocity that you would get. However, we know that Mr. Sanderson is not suspended in the air when he collides or when he makes contact with Ms. Paltrow. So he's actually standing on his skis, so he's standing upright. So when he falls to the ground, it's not a free-falling event. And you can appreciate that because when he falls over, the speed of his feet that hit the ground is 0, whereas the velocity of his head is certainly much greater than the velocity at his feet. So you have to know, which I took his measurement in the office, how high the point of interest is, which is his ribs, because that's what he fractured in the collision. So once you do that, you substitute the 1/2 AT squared asterisk into and that turns out to be 2.29 meters per second. And you put that into the impact formula, and then you obtain what the impact force is. So the equation should be written Fi, impact force, equals 1/2 in parentheses V sub T asterisk all squared, and then over D, the distance through which the energy is transferred from the ground to his ribs, which I measured in the office. So you have to know those quantities and understand that this is not a free-falling event. So that's the big difference here. And once you have the 2.29 meters per second and you substitute that in, and you just use Mr. Sanderson's weight as the mass in that equation, you realize that there is not enough impact force to fracture those ribs. So there has to be a mitigating circumstance, i.e., something fell on top of him in addition to him falling to the ground to cause those ribs to fracture in an otherwise healthy male. And so when you do the calculation, the object, and typically to fracture ribs on the lateral side, which is where he fractured his ribs, takes about 4,000 newtons, thereabouts, plus or minus 400 newtons, 4,000 newtons plus or minus 400 newtons to fracture those ribs. And when you work backwards, the mass required to do that indicates that the object that fell
Actually,
on
House and Habit.
Mr. Sanderson had to weigh at
That's
least
House and
100
Habit in the middle
pounds.
there at the back.
So, based on what I know about this case,
That guy with his hand on his face.
any human that weighs greater
Venture to
than
guess that's what the
100
jury's
pounds
thinking.
falling on Mr. Sanderson onto his right side, fracturing those ribs, would qualify as a traumatic event from an impact force calculation standpoint. Now, so once you understand that, then you start to consider other possible scenarios as to, is there any other way he could have fractured those ribs? The only other way he could have, if you consider him striking Miss Paltrow from behind, is that if he were to do that, he would have to generate a rotational force on him and Miss Paltrow, resulting in him falling on the ground and Miss Paltrow falling on top of him. Okay? Now, keep in mind, as I already calculated, you look up there, it took less than half a second to fall to the ground. And so for him to ski into Miss Paltrow and then rotate 180 degrees to the ground in less than a half a second requires a rotation rate of greater than 400 degrees per second. Now, Olympic divers, that is, when they do their twisted and turnings on their competition dives, don't generate any greater than 400 degrees per second.
I remember him
on their
talking about this
dives.
the first time he was up.
And then when you take into consideration Newton's first and third laws, you know, Miss Paltrow is certainly not twisting and turning if she's struck from behind. So in order for her to rotate around with Mr. Sanderson has to, according to Newton's first and third laws, grab her and then take her to the ground in a twisting fashion where she lands on top of him. Now, Olympic swimmers, if they were to grab 100-pound weight or more and try to do those rotations, that's just not going to happen because the center of gravity is too far away from the moment or the inertial point for rotation. So that's probably not going to happen. But let's hypothesize.
Oh no, he's got
that
pause.
this did in fact happen, which is highly unlikely.
There's no
If
way the
Miss
jury is
Paltrow
following that.
landed on Mr. Sanderson.
Kurt, you're a math guy.
and
What are
he
you
landed
thinking?
on his back, that means he landed on his chest. And if that were to happen, the ribs would not fracture on the lateral aspect
That would
of
be
his
my
chest,
thoughts.
as we see in the medical records. So we know,
Yeah.
based on that and the low probability of the rotational or the angular velocity, that
House and
not
Habit with the
happen.
sunglasses
So
on.
that only
He's
leaves
here.
one possible scenario to satisfy Newtonian physics.
No way.
The
Look at this. This lady's sleeping. The other one's
Sanderson's,
checking her nails. That guy's
measurements
texting.
and his medical records, and
Got
that
people
means
falling
that he
asleep.
was struck from behind, went down onto his right side, made contact with the ground with his elbow. The energy was transferred into his ribs that fractured the ribs. Now, I would like to add that had the rib fractures not occurred, no one would be able to do this analysis, period. And that's all I got to say about it.
Thank you.
That's all I have to say about that. That's basically how that feels.
Roger that.
Like when Forrest Gump, when he's talking at the Lincoln Memorial at the pool, and then the mic
Yeah.
gets
Your Honor,
pulled and he keeps
am I
talking.
to talk through this?
That's
Can
all I
you
have
hear me,
to say
Dr.
about
Boehm?
that.
Barely. Is this Mr. Egan?
Yes, it's Mr. Egan.
Hi. Good morning, Mr. Egan.
Good morning. Given the limitations we have. I'm not going to ask you some things I prepared.
You don't need
I can't show you a number of things.
Save your time for the next.
So
Well,
this may take a second.
I guess you do have time.
Less than we'd planned here, but let me start this way. Dr. Scher, you watched Dr. Scher's or read Dr. Scher's trial testimony, right?
Yes, I read it. I did not watch it.
And so you didn't see him writing up the equations on the board for the jury and discussing those for them?
Without
I
visuals
did
to
get
help,
a text picture
DMNMT,
of his equations.
no way that
Okay.
anyone was following that.
But did you get a text picture of the drawings that he drew for the jury?
Yes, I did.
And Dr. Scher has significant experience applying the principles of
Supposed to protect
biomechanics to skiing, correct?
To my knowledge, he does. I don't know him personally or professionally.
And you do not have that kind of experience, correct?
With regards to what, sir?
Applying the principles of biomechanics to skiing?
I have not worked on skiing problems, if you will.
Okay.
But certainly.
And Dr. Scher has studied the physics of skiing and ski equipment, correct?
Oh, yeah, that's my understanding of primarily
Literally what he does.
bindings with skis.
Yeah, I think it goes beyond that, but that's right. And you have not done such studies, correct?
No, not on ski bindings, sir.
And did you learn anything from Dr. Scher's testimony, given his experience with applying biomechanics to skiing and your lack of it? Did you learn anything from him?
Did I learn anything? I mean, all I learned was that he assumed a free fall event, and it's not a free fall event. That's what I learned primarily, and that's why that basic assumption flaw is analysis.
And that's the only thing you learned.
I'm sorry, I didn't hear that.
And that's the only thing you learned.
Talking to the.
Yes, that was basically that's why I'm here today.
Do you know? Is this
Oh,
better?
I hear you much.
Can you hear me better if I do this?
Absolutely,
Okay.
absolutely.
I'm just leaning in front of the jury here.
No, I appreciate that. I can hear you really good now. 5 by 5.
Thanks. Yeah, it's a first. Okay. So, do you know anything about DIN settings? Those are the settings that dictate when ski bindings release.
No, I do not
Okay,
know
so-
anything about that.
So
I haven't skied in 40 years.
Right. Okay. And also that means you wouldn't know how much force it would have taken to release Mr. Sanderson's boots from his skis, correct?
I did not calculate that.
Not just that you didn't calculate it, you don't even know what force it would require. Is that right?
No, that is correct. It's not required for my analysis.
Okay. Did you catch in Dr. Scher's testimony that he's read the voluminous literature on rib fractures and the biomechanics of rib fractures?
I'm sure he has, but we did experiments in the lab in the military doing that. So
Okay, but my question was just, did you see that part of or read that part of his testimony?
That's what he portrays.
Okay, and it sounds like you dispute his reading of that literature.
No, I don't. I mean, he portrays that he knows a lot about biomechanics. I don't know. I've never been in a discussion with him to familiarize myself with his level of knowledge in that field.
You said earlier that part of Dr. Scher's mistake in your mind is that he didn't acknowledge that he didn't solve for T. Is that what you said?
Well, that's one of them.
Okay, so that we're just going to stay on that one for a second.
Roger that.
Did you
Objection. Let the witness finish his answer, counsel.
It was a yes or no
He
question. He
answered my
answered.
question. I was just going.
Mr. Bame, did you have anything else that you
Oh.
needed to
Oh my God.
say to respond to the
God,
previous answer?
no.
No, we can move on, Your Honor.
Whew.
Okay, thanks, Dr. Bam. I don't mean to interrupt. I'm just trying to be quick because I don't have much time.
I understand, Mr. Egan.
So did
I'm
you?
in a hurry too. I'm trying to make a luncheon.
I got it. Yeah. Well, we appreciate you making time during
I'm on
your
vacation.
So
I've got a spa coming up.
did you miss in Dr.
I need a
Scher's
spa.
testimony where he pointed to the pages in
If you'd
your
like to donate
equations
to
where you
Alita's spa
solved for
fund,
T
please
and
make
he
sure to
just
send her a couple
assumed
super
what you
chats.
had done?
She could use a spa day.
He did an analysis or a critique, I might add, on my analysis. I don't see where he calculated it himself.
Right. He was just working off yours, just assuming what you had done and then doing his own calculations.
That is correct.
Okay. Thanks. That's all the questions I have. Thanks.
Thank you, Mr. Egan. Appreciate it.
Mr. Bueller?
Bueller. Redirect.
Dr. Bain?
Yes, sir.
Okay.
I was born into the math equations.
So you did see the calculations from Dr. Scher.
Well, I saw what he did, which was critique my analysis, and that was it. I don't know if he did any calculations based on what I saw in his testimony.
If you could quickly focus in on what is the error that you think Dr. Scher made?
Well, the biggest one, well, there's two of them. First of all, with the rotational aspect, he did not consider Newton's first and third laws, so that's a violation of classical physics. And then second of all, he assumed a free fall, and we know that Mr. Sanderson did not free fall to the ground because he was standing up and he fell over, and it's the velocity when you hit the ground, when you fall over, is much less than a free fall. And we did those studies at the Naval Under Research Laboratory because we were interested in that research for our military personnel. So knowing because you can appreciate standing up, when you fall over, the speed of your feet is 0, whereas the speed of your head is something else. And it's much different than a free fall event.
Okay. Thank you. That's all I have. Counsel?
Thank you. And am I allowed to leave? Over?
Just have one question,
if
that's okay, Your Honor.
James Egan has one more question.
Oh, okay. Mr. Egan.
Yeah.
Hold on.
Oh, thanks. Yep. Thank you, Lawrence. I'm back, Dr. Bame.
That's great.
One last
great.
question. You were talking about free fall. Do you recall the testimony from Mr. Sanderson that he went airborne during the accident?
I don't recall that.
Okay. Thank you.
You're welcome. Anything else?
Just one question. Is it possible for Terry Sanderson to have gone airborne when his skis were on the snow?
No.
Yes.
No, that's not going to happen because
Terry Sanderson
the skier
lied.
would have to go, that hit him from behind would have to be going in excess of 50 or 60 miles an hour, which I think is highly unlikely unless we're dealing with an Olympic downhill skier here.
Okay. That's all I have. Thank you, Dr. Bain. No more questions.
Thank you.
That was a terrible last
Your
question to
Honor,
ask.
am I excused?
Yes, you are. Thank you, Mr. Bame.
Thank you.
Thank you, Your Honor. Thank you, guys. You guys have a great day out there in Utah.
Thank you.
Never ask a question to which you don't know the answer.
That's all we have.
That
No
last
more
question was
So you
absolutely
rest
not
your rebuttal
good
case?
for his side because his own expert just said, well, he lied.
So you've now
Plaintiff
received
lied on
all
the
of the
stand about
evidence.
We were thinking of calling somebody, but we decided not to.
Okay.
That would
Yeah,
mean
Master,
Now
that
you-
received
someone
all of
who's
the evidence.
had-
I just need to ask the lawyers a couple questions and then we'll proceed. So could you approach the bench, please?
Zen Master, thanks so much for the super chat. This Legal Bites Live takes me back to the JD trial. So much fun. It's been a while. It has been a while. It has been a while. I was hoping to get back to doing some more trials, and I'm happy to be back at it. So yeah, so that last question, in case you guys missed it, it was pretty quick. There was that, James got up and asked that last question about, are you aware that Terry Sanderson testified that he went airborne, and then the expert said, Dr. Bain said, no, I wasn't aware. It's not really possible unless she's like some Olympic skier and she's going like 30 or 40 miles per hour. Not plausible from a physics standpoint. That on its own is bad, because you have his own expert saying like, or no, well, sorry. Actually, no, he didn't even give that explanation yet. It was just, no, I wasn't aware. If Terry Sanderson's attorney had just let it die and just not asked that last question, it would have been like, okay, yeah, you have that suggestion of like, oh, like maybe that doesn't make sense. But he just had his expert clarify to the jury why it was absolutely unreasonable for Terry Sanderson to say that he went airborne. And he was so convinced, just like he was convinced about all the other details of that incident. So it's just, yeah. Anyway, so I don't know how much of that is going to stick with this jury, because
I object to all that testimony in every possible way. It is completely ineffective. It's ineffective in the time frame that you're trying to do it in. It's ineffective in the methodology you're trying to do it in. It's one of the reasons that, technology isn't always a cure-all. Zoom, as we've all learned, Zoom meetings are not necessarily the same as them being in person.
yeah,
And this is testimony to that. There's something different about being in the room, not for the least of the reasons, for the jury too. And it just seems like, let me just go through these equations super fast. And it's this equation, not this equation. I'm like, the last time I saw equations like that, I was in undergrad. That was a long time ago. That was 20 years ago, the last time I saw equations like that. It's been a hot minute.
Yeah.
So I can get there, but you're going to have to take me through it a little bit so that you refresh my somewhat distant recollection at this point. And I can't follow that. And I'm someone who at least has been exposed to that at some point in my life.
And I'm someone that says math is magic, science is sorcery.
Okay, members of the jury, you have
Even
been
worse.
handed the closing jury instructions.
Oh, they're gonna.
There's
go
one more
instructions.
document you'll get before the parties argue, but we're gonna give that to you right after the break. I'm gonna read through these and then we'll take a short break.
Okay, we'll
So
talk
these
about
are jury
this
instructions
in the break.
18 and
But
22 through 42.
This last testimony.
If you turn to page 2, and you can make notes on these if you'd like. So page 2 is jury instruction number 18, which has already been read to you, most of it, as modified, because I did modify it during the trial, and I read it to you during the trial as it stated right here. So now you've got the complete 18, the modified 18. Turning then to jury instruction 22, which was also read to you during the trial on limited purpose evidence. Turning then to 23, a closing roadmap. Members of the jury, you have now received all of the evidence. 3 things remain to be done. First, I will give you additional instructions that you will follow in deciding this case. Second, the lawyers will give their closing arguments. The plaintiff will go first, then the defendant, then the plaintiff may give a rebuttal. Finally, you will go to the jury room to decide the case. In the jury room, you will have 2 main duties as jurors. First, you will decide from the evidence what the facts are. You may draw all reasonable inferences from that evidence. Second, you will take the law I give you in the instructions, apply it to the facts, and reach a verdict. Instruction 24, closing arguments. When the lawyers give their closing arguments, keep in mind that they are advocating their views of the case. What they say during their closing arguments is not evidence. If the lawyers say anything about the evidence that conflicts with what you remember, you are to rely on your memory of the evidence. If they say anything about the law that conflicts with these instructions, you are to rely on these instructions. Counsel, could you remove that easel? It's kind of blocking my view of the jury. Number 25. You can just shove it over next to the screen. Legal rulings. During the trial, I have made certain rulings. I made those rulings based on the law and not because I favor one side or the other. However, if I sustained an objection, if I did not accept evidence offered by one side or the other, or if I ordered that certain testimony be stricken, then you must not consider those things in reaching your verdict. 26, fault defined. Your goal as jurors is to decide whether Terry Sanderson was harmed, and if so, whether anyone is at fault for that harm. You must also decide whether Gwyneth Paltrow was harmed, and if so, whether anyone is at fault for that harm. If you decide that more than one person is at fault, you must then allocate fault among them. Fault means any wrongful act or failure to act. The wrongful act or failure to act alleged in this case is negligence. Your answers to the questions on the verdict form will determine whether anyone is at fault. We will review the verdict form in a few minutes after your break. Instruction 27, negligence defined. You must decide whether Gwyneth Paltrow or Terry Sanderson was negligent, or whether they were both negligent. Negligence means that a person did not use reasonable care. We all have a duty to use reasonable care to avoid injuring others. Reasonable care is simply what a reasonably careful person would do in a similar situation. A person may be negligent in acting or in failing to act. The amount of care that is reasonable depends on the situation. Ordinary circumstances do not require extraordinary caution. But some situations require more care because a reasonably careful person would understand that more danger is involved. To establish negligence, Terry Sanderson has the burden of proving that 1, Gwyneth Paltrow was negligent, and 2, this negligence was a cause of Terry Sanders' harm. If you find that Gwyneth Paltrow was negligent, then you must determine whether that negligence was a cause of Terry Sanderson's harm and whether Terry Sanderson sustained damages. Gwyneth Paltrow claims that Terry Sanderson was negligent in causing his own harm, and that should read, and in causing her harm. To establish Terry Sanderson's negligence, Gwyneth Paltrow has the burden of proving Gwyneth Paltrow has the burden of proving that 1, Terry Sanderson was negligent, and 2, that this negligence was a cause of Terry Sanders' harm and her own harm. I'll send in a corrected instruction 27. If you find that Terry Sanderson was negligent, then you must determine whether his negligence was a cause of his own harm and her own and Ms. Paltrow's harm, and whether Paltrow sustained damages. Instruction 28, allocation of fault. If you decide that more than one person is at fault, you must decide each person's percentage of fault that caused the harm you determine was suffered in this case. This allocation must total 100%. Mr. Sanderson's total recovery will be reduced by the percentage of fault that you attribute to him. If you decide that this percentage is 50% or greater, he will recover nothing. The same is true of Ms. Paltrow's recovery. When you answer the question on damages, do not reduce the award by Mr. Sanderson's or Ms. Paltrow's percentages. I will calculate that later. Instruction 29, violation of a safety law. Violation of a safety law is evidence of negligence. Terry Sanderson claims that Gwyneth Paltrow violated parts A and B of the following safety law, and Gwyneth Paltrow claims that Terry Sanderson violated part A of the following safety law. This is Summit County Ordinance Section 523, reckless skiing. A, reckless skiing prohibited. No person shall ski in a reckless or negligent manner so as to endanger the life, limb, or property of any person. B, skier's duty to injured party in the event of collision. Any skier involved in a collision resulting in injury to any person shall immediately stop at the scene of such collision and render to such person injured in such collision reasonable assistance, including the caring or the making of arrangements for the caring of such person by a physician, surgeon, or hospital for medical or surgical treatment, if it is apparent that such treatment is necessary, or if such caring is requested by the injured party. If you decide that Mr. Sanderson and or Ms. Paltrow violated the safety law, you may consider the violation as evidence of negligence. If you decide that Mr. Sanderson and or Ms. Paltrow did not violate the safety law, you must disregard the violation, disregard the safety law, and decide whether they acted with reasonable care under the circumstances. Jury instruction 30, I've already determined that Gwyneth Paltrow did not leave the scene of the accident without giving her contact information. Jury instruction 31, spoliation. Ms. Paltrow has presented evidence that a GoPro video of the ski collision may have existed. Sanderson asserts that the GoPro video of the ski collision never existed. If you find that 1, a GoPro video of the collision likely existed, and 2, that any such GoPro video was in the possession or control of Sanderson, and 3, that the plaintiff intentionally or negligently disposed of or lost the GoPro video of the collision, or otherwise failed to offer a reasonable excuse for failing to preserve the GoPro video of the collision before a defendant had an opportunity to review and evaluate it. Then you may, but are not required to, conclude that the evidence would have been unfavorable to Sanderson. Instruction 32, Introduction to Tort Damages, Economic and Non-Economic Damages introduced. I will now instruct you about damages. My instructions are given as a guide for calculating what damages should be if you find that either Terry Sanderson or Gwyneth Paltrow is entitled to them. However, if you decide no one is entitled to recover damages, then you must disregard these instructions. If you decide that Ms. Paltrow's fault caused Mr. Sanderson's harm, you must decide how much money will fairly and compensate him for that harm. If you decide that Mr. Sanderson's fault caused Ms. Paltrow's harm, then you may award Ms. Paltrow $1, which is the maximum amount she seeks. There are 2 kinds of damages, economic and non-economic. I will explain the difference between them. 33, proof of damages. To be entitled to damages, a party must prove 2 points. First, that damages occurred. There must be a reasonable probability, not just speculation, that a party suffered damages from the other party's fault. Second, the amount of damages. The level of evidence required to prove the amount of damages is not as high as what is required to prove the occurrence of damages. There must still be evidence, not just speculation, that gives a reasonable estimate of the amount of damages, but the law does not require a mathematical certainty. In other words, if a party has proved that they have been damaged and they have established a reasonable estimate of those damages, the other party may not escape liability because of some uncertainty in the amount of damages. 34, economic damages defined. Economic damages are the amount of money that will fairly and adequately compensate a party for measurable losses of money or property caused by another party's fault. Mr. Sanderson is not claiming any economic damages. Therefore, you should not award Mr. Sanderson any economic damages. Ms. Paltrow is seeking $1 in economic damages. 35, non-economic damages defined. Mr. Sanderson is seeking non-economic damages. Non-economic damages are the amount of money that will fairly and adequately compensate Mr. Sanderson for losses other than economic losses. Non-economic damages are not capable of being exactly measured, and there is no fixed rule, standard, or formula for them. Non-economic damage may still be awarded even though they may be difficult to compute. It is your duty to make this determination with calm and reasonable judgment. The law does not require the testimony of any witness to establish the amount of non-economic damages. In awarding non-economic damages, among the things that you may consider are: 1, the nature and extent of injuries; 2, the pain and suffering, both mental and physical; 3, the extent to which Mr. Sanderson has been prevented from pursuing his ordinary affairs; 4, the degree and character of any disfigurement; 5, the extent to which Mr. Sanderson has been limited in the enjoyment of life; and 6, whether the consequences of these injuries are likely to continue and for how long. While you may not award damages based on speculation, the law requires only that the evidence provide a reasonable basis for assessing the damages, but does not require a mathematical certainty. I will now instruct you on particular items of economic and non-economic damages presented in this case. Instruction 36, pre-existing conditions. Terry Sanderson is alleged to have had physical, emotional, or mental conditions before the time of the ski collision. He is not entitled to recover damages for those conditions. However, he is entitled to recover damages for any aggravation of the conditions caused by Gwyneth Paltrow's fault, even if those conditions made him more vulnerable to physical or emotional harm than the average person. This is true even if another person may not have suffered any harm from the event at all. Gwyneth Paltrow has the burden to prove what portion of the alleged harm is the result of pre-existing conditions. If you are unable to make such an apportionment, then you must conclude that all damages, if any, you find were suffered by Mr. Sanderson were caused by Ms. Paltrow. 37, mitigation of damages. Each party had a duty to exercise reasonable diligence and ordinary care to minimize the damages caused by the other's fault. Any damages award should not include those that could have been avoided by taking reasonable steps. Terry Sanderson has the burden to prove that Gwyneth Paltrow could have minimized her damages but failed to do so. Gwyneth Paltrow has the burden to prove that Terry Sanderson could have minimized his damages but failed to do so. If a party made reasonable efforts to minimize damages, then your award to that party should include the amounts that he or she reasonably incurred to minimize them.
Your Honor, my memory is that jury instruction 38 was stricken by both parties yesterday.
Okay. It wasn't.
It was not.
It was not stricken.
I apologize. Please proceed.
Okay,
Why do they keep
38,
doing
collateral
this?
source payments.
Both sides have been doing
You
that.
shall
like
award
that.
damages in an amount that fully compensates Terry Sanderson.
My mistake.
Do not speculate on or consider any other possible sources of benefit Terry Sanderson may have received. After you have received your verdict, I will make whatever adjustments may be appropriate. 39, four-person selection and duties and jury deliberations. Among the first things you should do when you go to the jury room to deliberate is to appoint someone to serve as the jury foreperson. The foreperson should not dominate the jury's discussion, but rather should facilitate the discussion of the evidence and make sure that all members of the jury get the chance to speak. The foreperson's opinions should be given the same weight as those of other members of the jury. Once the jury has reached a verdict, the foreperson is responsible for filling out and signing the verdict form on behalf of the entire jury. In the jury room, discuss the evidence and speak your minds with each other. Open discussion should help you reach an agreement on a verdict. Listen carefully and respectfully to each other's views and keep an open mind about what others have to say. I recommend that you not commit yourself to a particular verdict before discussing all the evidence. Try to reach an agreement, but only if you can do so honestly and in good conscience. If there is a difference of opinion about the evidence or the verdict, do not hesitate to change your mind if you become convinced that your position is wrong. On the other hand, do not give up your honestly held views about the evidence simply to agree on a verdict, to give in to pressure from other jurors, or just to get the case over with. In the end, your vote must be your own. In reaching your verdict, you may not use methods of chance, such as drawing straws or flipping a coin. The verdict must reflect
Ouija
your
boards.
individual, careful, and conscientious judgment. Instruction 40, do not resort to chance. When you deliberate, do not flip a coin, draw straws, choose opinions at random, or use other methods of chance. Instead, you must weigh the evidence carefully and come to a decision that is supported by the evidence. If you decide that a party is entitled to recover damages, you must then agree upon the amount of money to award that party. Each of you should state your own independent judgment on what the amount should be. You must thoughtfully consider the amounts suggested, evaluate them according to these instructions and the evidence, and reach an agreement on the amount. You must not agree in advance to average the estimates. Instruction 41, agreement on special verdict. After the break, I'm going to give you a form called the special verdict that contains several questions and instructions. You must answer the questions based on the instructions and the evidence that you have seen and heard during this trial. Because this is not a criminal case, your verdict does not have to be unanimous. At least 6 jurors must agree on the answer to each question, but they do not have to be the same 6 jurors on each question. As soon as 6 or more of you agree on the answer to all of the required questions, the foreperson should sign and date the verdict form and tell the bailiff that you have finished. The bailiff will escort you back to this courtroom. You
6
should
out
bring
of
the
how many?
completed special verdict form with you.
Out of 8.
And then jury instruction 42, I'll read to you at the end of the trial.
And I think
So
they have
that,
like 2
that
alternates.
completes these instructions.
But yeah, they have 8 jurors.
I wonder if you could write your names on the top of that, because as you noticed, I did make some changes to a few of the instructions as we went along. And I'll have the bailiff insert the new and take out the old, if you could do that, the new instructions before they're given back to you. Yes. Pardon me?
Names and numbers or just names?
On the verdict form, the foreperson will write their number and their name when they sign it. And there's only be one signature on it, which would be the foreperson. And when I select the 2 jurors that will unfortunately have to leave us before deliberations, I'll just tell you your juror number. I won't say your name, and I'll give you further instructions about those 2 individuals. So I'll do that in a few minutes after all the arguments are completed. So at this time we'll take a recess, and thank you.
All rise, the jury.
Yeah, cool.
All
So yeah,
right.
6 out of 8. Of course, Johnny Depp was a bit unusual because in Virginia they required unanimity. So there was a 7-member jury in Virginia where they had to be unanimous. But this is pretty typical, where you have 6 out of 8 or 10 out of 12 or something in a civil verdict. And of course, you only have to reach a 51% conclusion. So as a result of that, hung juries in civil cases are basically never happen.
I don't know what the rate is. Like what the numbers
Defendants?
are.
No, I would like to get a hard copy of the special verdict form just so I can read it one more time.
We've got some issues with the verdict form. I wonder if you could come into chambers and we can kind of go through that.
Really?
Thank you.
Still?
And
Step
then
into my office.
Could Peter Jensen have the defense binder index? And certainly one of the plaintiff's lawyers is welcome to be present to do the final swap out with the new index. He's
Sure.
not adding one thing. He's
And is
deducting.
that something we need to do before closings?
No. He could do it at the moment they're discharged to deliberate.
Normally,
Sure.
well, if you want to get those into evidence, I suggest you try as soon as possible.
Well, I do move to admit the new index, all those documents on the new index, which they have. Any objection?
Are there any objections to the index of defendants' trial
Plaintiffs'
exhibits? All of the exhibits been received?
So that's
Okay.
on the new index. And now he just needs to make the changes, including blacking out Mr. Sanderson's
Contact information?
contact information.
Social
Usually a good
Security,
idea,
Birthday,
Address is the one that's
Address.
most common.
okay.
especially
so
so
take
we
a
can
quick
look him up
break and then
and
have
see if he has a
They'll
VRBO.
bring you back to my chambers on the special verdict form.
Thank you.
All right, we've got some questions that we can answer here while they're on the break because we got some questions from.
I have
from some
questions you
folks
can
that-
answer, mostly in the form of what?
So, okay, let's see here. Let's see. We already got this one from Kitty McScratch. Andrew Farrell, why are they time limited anyway? Because lawyers know how to bloviate. We can waste time like no one's business. So the judge here, I mean, we see most of his time in the day here in this case, but he has other cases that he is also basically managing a whole docket of cases that are in pre-litigation. He's got hearings, he's got other trials that are coming up that he's got to prepare for. So he's got to run a bit of a tight ship himself. So the judge is always going to set a certain time limit and say like your trial needs to go for this long. This is what is reasonable for the kinds of issues that are in your case. It'll be some will be shorter, some will be longer. Johnny Depp versus Amber Heard was 6 weeks. It was a bit longer. There are some trials that'll only be like 3 days. So it really depends on the subject matter and the issues involved and how complicated they are. But yeah, they limit it to make sure that things run as efficiently as possible. Because everything is it's all using up court resources, which are taxpayers' money. Dan the Man, do the expert witnesses get compensation for giving their testimony? Yes, they are compensated for their time, not for their testimony. So, yeah, but yes, they do get compensated. Psycho Boy says falling over slower than free fall, but collision where lateral movement translated into rotational downward can be faster. Yes, that's it. That's an interesting point there. But yeah, and I think that's an interesting point for Gwyneth Paltrow's side. And also the issue of, the rotational force that like even Olympic divers don't have that amount, that ability to spin at that rate. He's kind of ignoring the point that Dr. Scher had, which was if you just hit someone not on their center of gravity, a little bit off from that, you can cause them to spin with that movement. And the fact that the ribs fractured on the right side and like not squarely, I mean that suggests that rotation could have been possible. So yeah, anyway, but yeah, your point is noted. Dan the Man, thanks so much for the super chat. Says, doesn't a phone/Zoom witness make it possible to impersonate someone else? Why is it admissible in court to give testimony like that? They have his contact information. They have his cell phone number. This is someone who has regular contact with the attorneys involved in this case. Everyone involved has his contact information. So faking it is in a court of law is the risk of that, I think, is very, very low. Jamie Bruce is very broad newbie question. What are jury instructions? I'm guessing they're not standardized since they seem to be getting changed and debated. Yeah. So jury instructions are just this is the judge giving the marching orders to the jury to say, when you go into that jury deliberation room, this is how we want you to go about it. I mean, they don't tell them like specifically how they need to discuss these matters and like that, but basically giving them ground rules for like, these are the issues that you have, these are the questions that you need to answer, yes or no, on this issue, yes or no in this issue, and if you found yes on this issue, then you have to decide that one. There's like a whole flow chart of stuff, as you heard through that reading. And that was actually a relatively painless jury instructions reading. Some of them can go on for a very long time and they can be very just long and dry. But that one was actually relatively painless in my opinion. but yeah, it's basically just giving the ground rules for the jury and also kind of telling them like what to expect when they're going to be going back there and what is expected of them.
But they are for the most part standardized.
For the most part.
They are for the most part standardized. They're the model instructions, and
Yes.
that's what you start with. And then so there's an argument over which instructions to give, and then sometimes they want a wording change, for the individualized case. But they are 90% standardized. So
Yeah, so they're based on model instructions for that state or for that jurisdiction. And then also like case law will inform it. So you can have some where they might want to fight over some wording because it can create an inference one way or another based on how a certain instruction is worded. And that's oftentimes like where that fight will come out. But by and large, like, the instructions for negligence are going to be, the elements of negligence as we understand them in that state based on their case law. So like the Supreme Court of Utah probably has some case where they've outlined, the 4 or 5 elements of negligence of a negligence claim. So they will be, they'll come from that. They'll come from the model rules, all that kind of stuff. So yeah. Llama Green, going to be 2 hours of closing. Yes, it'll be 1 hour per side, which that was actually something that Gwyneth Paltrow's won on a little bit too, because, they were so limited in their time. They basically had like 1 hour or 50 minutes total, I think, after yesterday. And the
53, I
judge,
think, was the magic number. Yeah, but they gave him a little extra time to round it up. So, hey, a little extra bonus time. All right.
yeah. So the judge was a little, he relaxed the standard a little bit there to allow them to have a full hour for closing and 5 minutes for cross-examination of each witness that came up on rebuttal. So yeah. Let's see. Love Claire. Legal Bites, which case are we covering next? I don't know. I've got to take a look
I'm going to
at
try to cover the Lori Vallow case next week, but that's going to be a bit of a nightmare, unfortunately, because it's audio only, and they're only releasing the audio at the end of each day.
That's rough.
So we're going to give it a shot and see how that goes. If not that, then probably the OnlyFans murder case, Courtney Clenny, is probably the next case that looks good on my docket.
Yeah, there's also the Courtney Clenny case is one that I'm totally dialed into. Although the next hearing is May 9th or something like that. So it's not exactly soon. I think before then probably will be the Sarah Boone trial, the suitcase murder trial, where she was playing hide and seek with her boyfriend.
So they say.
And he suffocated in a suitcase. That one sounds interesting because it's just like so weird and different. But yeah, I'm open to suggestions if folks have them. Because I do love covering these trials. Christina B says, legal bites in civil cases, can the judge throw out a jury's verdict and findings? Yes, but limited. And by that I mean it takes a lot for a judge to throw out a jury's verdict, because our American judicial system relies very, very, very heavily on the idea that the jury is like the ultimate fact finder. So they are the ones that are most trusted, and most I don't know, like most likely to come to the correct decision. Oh, I do see it. Yeah, Sandra Ramirez asking if I can cover the Masterson case. Oh, there are new rulings this week. That's interesting. I hope I want there to be cameras in the courtroom, because I covered it the first time around and there weren't any cameras in the courtroom, and that makes it so much harder because you're relying on the people that are actually in there. And so relying on other people's like analysis, conclusion, sometimes can get tricky. I prefer to actually see the trial itself and give my own comments on it there. But yeah, we'll see. LSX Tina, thanks so much for the super chat, says he has VRBO because a renter threw a backyard party. Yeah, that may have been a long-term renter though. So we don't know if that was a long-term renter or a short-term renter. But yeah. Let me see if I can. I Cyrillic I can kind of read just slowly. Let's see. Dmitry Kiselev. Okay. Can you submit a physics book as an exhibit, because equation for velocity is v equals a times t without any coefficients, and that would be in any book. You don't need to, because if you have an expert, the expert will testify to that. So, you know, they had some differences of the equations to be used here, but yeah, you wouldn't need to use some kind of a treatise like that. All right, let's see here. Are there any other questions here that I missed? Oh yeah, Gregor Bauer. We seem to think that Sanderson will lose his case, but what do you think? How likely is it that GB will get her $1?
I think very likely.
I think it's pretty likely. The question really is on those attorney's fees, in my opinion.
Yeah, this is going to be the most expensive dollar of his life.
Yeah. So
the Epstein Island thing, definitely kick that into overdrive. So I think those attorney fees are looking pretty good right about now.
Yeah, that's true. Okay. Were there any questions that I missed?
How are you doing, Alita?
I'm good. I'm really good.
Right.
I'm wondering if opening or if closing arguments are going to be before or after lunch, if they're going to start before or after lunch. What do you think?
Yeah. Well, oh yeah. Someone said something was cringe. What did I miss? Did I do a cringe?
I don't know. I may have done a cringe.
Okay.
I have no idea. I missed it.
All right. Okay. I'm confused. Sometimes I'm sensitive to that kind of thing. Yeah, I think the jury's going to get the thing pretty fast. I mean, it's an hour each, and it's 10:41 right there now. So they'll probably get that and then go to lunch and then come back after lunch, call it a day.
Or actually, well, now probably what they'll do is do plaintiffs closing, lunch, and then defense closing.
Oh yeah, okay. The comment by Terry Sanderson was cringe. Yes, it was one of the many things that was cringe yesterday. With the nerd comment also being cringe, there was much objection cringe yesterday.
Yeah. That was. Yeah, that Epstein comment was the equivalent of a Hitler comparison. You could almost hear the courtroom groan. Yeah, I mean, especially because it's like now he's just sort of revealed his outside thoughts on some of these other things that some people, have some very strong feelings, some very strong opinions about Hollywood and Hollywood, members of Hollywood and their connection with people like Epstein, and matters like that he referenced. But to go from that to Gwyneth Paltrow skiing down a hill with her family, that connection is really invisible. Like I don't quite know where you make that connection. So it's one of those things that he just left the jury with the impression that he does not have a very reasonable mind, that he is someone who is willing to see one thing and find something that is much bigger and much more fantastical, which can be attributed to all of the other things that he said about this case, about what happened to him and what happened with Gwyneth Paltrow, and also all of his medical diagnoses afterwards.
Yeah.
Sandra Ramirez, thanks so much for the super chats. This question for you both. Should Sanderson lose, do you see any solid appealable issues? None.
No.
Yeah, there's nothing that jumps out to me. There's nothing that jumps out to me about that. Yeah.
No.
Yeah.
Short of them, like, I guess they can, because the jury can also split the difference in terms of responsibility. How does that work with the dollar award, though? In terms of calculation of damages, I guess she gets the dollar no matter what, because you can't adjust that. So I guess it would only adjust on Terry's side. I mean, you can't word
Yeah.
him like 80 cents. I mean, that doesn't make sense.
Yeah.
Yeah. But
Like,
I'm
like what would you think if the jury came back and said, yes, Gwyneth Paltrow wins, Terry Sanderson loses, Terry Sanderson has to pay Gwyneth Paltrow 50 cents?
yeah, no, I think they pre-wrote in $1 on the jury verdict form for exactly this reason.
Yeah.
Yeah. So it's like, yeah.
Yeah. Is the Jenny stuff appealable? No, I don't think so. They had a there was an objection when they were talking outside the presence of the jury about her. I guess she does have a mental health condition, a diagnosis, and I was talking about it yesterday. At the end of the day, they actually said what it was. I don't want to say it because it's a private health matter that I don't think that they meant to say publicly in front of the cameras, or afterwards. I think they regretted it. So anyway, if that diagnosis had been said in court, in open court, then there would have been a mistrial, and so maybe that would have been some kind of fodder for an appealable issue. But I don't think so. I mean, that was all very well documented, very well placed on the record by the judge. So
I think I mean, I definitely have my criticisms of the judge, but show me a judge I haven't had criticisms of, because and that being said, I'd have criticisms of myself because I'm, as is often true, I'm a harsh judge of my own work too. So I'd look at myself and be like, oh, well, that was stupid, and I was an ass and idiot and all the rest of the things. So I don't even agree with myself 100% of the time. So I have my criticisms of the judge, but I think his rulings have been fair, even though my style has at times been too lax for my taste. I want a harsher hand. So I want to bring Judge Ascarati back and, rule with a clock of doom.
bring back the Marine judge.
Yeah, that's right. She had it right. We didn't know how good we had it. And I had criticisms of her. I criticize everyone. I criticize Scalia. I criticize everybody.
Dan the man says, is one US dollar the minimum you can sue for? I believe so. I don't think you can sue for anything less, because there has to be, if you are suing for monetary relief, you have to sue for at least something. And I don't think they'll allow anything less than a full dollar.
Don't know. If your case is less than $1, you're definitely trying to prove a point to somebody.
1 cent.
Yeah. I feel like there might have been some cases less than $1, but I can't recall any off the top of my head. But yeah, if it's less than $1, just I mean, I know you've been injured, and I'll just
L'Aquarius says, what about the references to Jenny's depot? I think that they did that specifically because Paltrow's side, they knew that there was a potential issue with getting Jenny to testify. And so they wanted to be able to try to reference her testimony in closing argument. And so in order to do that, it has to come out on the record in front of the jury somehow. So by having the other people that know her comment on the things that she has said about their father, that at least gets the gist of it and the basic subject matter of her testimony out in front of the jury, which means that it is something that could actually come into a closing argument, which we could actually talk about closing arguments while we wait. So basically what to look for in a closing argument is essentially what Owens was trying to do with his opening statement.
Both opening and closing are, at least to my mind, to tell the narrative. It's to tell the story arc. The opening is more skeleton in its nature because the evidence hasn't come in yet.
Yeah.
So they parallel each other. In the closing, you're filling in the details with the evidence that's been heard, but they should be very comparable.
Yeah, you want, ideally. Sorry. Okay, so ideally you want, Sorry, I'm not bored. Just sometimes a little tired based on the time zone. So ideally you want the opening statement and the closing argument to kind of mirror each other, because that way it shows that you're kind of like showing without telling the jury, see, I wasn't lying to you at the beginning. Like, this, the way that you see it is exactly the way that I said that you would see it. So you want like a theme, ideally, that can be brought up initially in the opening statement, that comes up in the testimony of these witnesses. Like, it might just be a buzzword. It might be some kind of a reference to something, to an idea, to a concept. And then you want that to be hammered in your closing argument. In this case, the opening statements, I didn't really see much of any theme in either one. It was hard to identify them. Like, if I were Terry Sanderson's lawyers, I think that a pretty good theme, I don't know, I thought of it, so I think it's a good idea. Maybe it's just the IKEA effect, but I think a decent theme would have been for them to say, everyone has to abide by the same ski rules, including celebrities. Like, you say something like that, and then that's something that could have been brought up through various witnesses, and then you can bring that up and it fits in with their need to prove liability and all this kind of stuff. So, like, you can have a theme like that also kind of triggers some emotions for a lot of people, because there are a lot of people that feel very, very strongly about celebrities getting special treatment. And that's something that kind of comes up in this case a little bit too. Like, she's got her private instructors that are very expensive. She's got, afterwards she went to get a massage. She's staying at the resort, which is very expensive, undoubtedly. And then, like, she's not the one to give her information. She gives it to the ski instructor to give to him. And I guess the ski instructor didn't give it to him initially. So, there's a lot that can look very privileged. And so I think that they would have done better to have that kind of a theme at the beginning, just to say, like, look, she's a Hollywood celebrity. She's got to abide by the same rules that any of us do.
Sure. Which is fine as long as you can actually show that she didn't violate the rules. And yeah. Yeah.
So anyway, so in the opening statements, I mean, like you said, you're giving a roadmap. You're basically telling them, like, this is what the case is about. This is what the evidence will show happened. You're giving the framework from your client's perspective, hoping that the framework that you give the jury is the one that they will adopt and then fill in the information as they get it into your framework, as opposed to the other sides. So you want to be very clear about that. And you want to be very clear in your narrative of, like, what happened. One of the things that both sides did terribly in their opening statements, in my opinion, is they're waffling on, like, trying to recollect what happened in this case. Like, they didn't seem particularly knowledgeable or confident in their case, and just, like, they were trying to grasp at the back of their minds for what exactly it was that happened, so that they can tell this story to the jury. And it made it hard to follow. Anyway, so yeah. But when it comes to the closing argument, this is where you're allowed to use full argument. Before, Owens was getting objected to up and down, left and right, because he was using argumentative language. He was saying, like, this is ridiculous. There's absolutely no way that this could have happened. Blah, 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 blah. Like those kind of statements you can't say unless you say the evidence will show that there's no way that it could have happened the way that he said it, or the evidence will show that Gwyneth Paltrow's account is the correct account. The evidence will show that Terry Sanderson doesn't know what he's talking about because he was fed a memory from a friend.
There you go.
Like that.
You got it. That's what you're supposed to do. You got it.
Like that all. It sounds argumentative, but when you tie it to the evidence will show, you're just saying, look, you're going to see this. You will see this for yourself. So, and then in closing, you're basically doing the same thing, but you're going to, instead of saying the evidence will show, you're going to say, you saw this because of the testimony of so-and-so. You saw this because of the testimony of so-and-so. You understand the physics because of Dr. Scher. And so you understand that the way that he says it happened is not the way that it happened in reality.
Right. That's exactly right. Yeah. You just tell it's hard to agree more. I mean, that's perfect. That's what you're supposed to do. Just like, here's what the evidence will show. You know what your evidence, you know what you're trying to prove, you know what the end goal is trying to be. So you try to tell, at least in my view, you try to tell a satisfying story based on the evidence that's available that will reach that end conclusion. Because what you're trying to get the jury to is the end conclusion of the story,
Mhm.
right? This is what I want you to do. So
Yeah.
ideally, what you want is all the evidence to be ... so that it will inevitably drive to that conclusion. Like, this is the only
Yeah.
possible result of this. This is the only
Yeah.
way the story can end. It must
Yeah.
be this. So therefore this, right?
Yeah.
And then of course you present the evidence and you'd be like, well, okay, well, this is what you heard. I told you at the start. All right. I told you at the start, you're going to hear this witness. And he testified to this. And this witness testified this. And this testified. And therefore it drives to this one conclusion.
Mhm.
And what Alita said is, yeah, basically the right idea. So perfect.
Thank you. Indy agrees. I saw folks in the chat commenting on, yes, she pushed off that cushion because she just doesn't want to be crowded out by the cushion. Hey puppers, how are you?
Yeah.
She's just looking at me.
You want blue and pink in chat? I can make that happen. Hold on.
Did you mean to mute yourself? Oh,
Yeah.
nice.
Tell the voice assistant.
Oh, that's why. Nice. That's awesome. That is really nifty.
Yeah. I'm here to help.
Nice. So yeah. It'll be interesting. It'll be interesting to see. Did they say how long this break was going to be?
I don't think so, no.
Hmm.
Yeah. Color changing lights are best lights. It was one of the best investments I ever did. It was less than $100. It was so great.
Oh,
Just to be
nice.
able to do it. And then you get the board and you can just press the button for like random different lights and change the color schemes. It's made me so
Nice.
happy. Feel like a real YouTuber. Like I got color changing lights behind me. Irrationally happy.
Oh man. Oh whoops, I didn't mean to. Okay.
I could even
No, I didn't.
run an extension in my own chat. There is an extension for it so that people in the chat can change my colors behind me by sending commands in chat. That could be fun. / disturbing.
Yeah. Thank you, Creed. That's correct. It was the directed verdict form that they are in there to fix. I forgot about that. So yeah, it's just, we're still just waiting on it.
It's interesting on camera 'cause it's
Ellen,
just
not
more
Sarah Lee.
pink in
I'm so
person.
sorry. You're right. I totally I forgot to pull this up on the screen. I saved it. Thank you for reminding me. I'm so sorry. Ellen, not Sarah Lee. Thank you for the super chat. Let's hope the closing is more powerful by Bueller than the opening. He literally read the whole thing. Yes. And here's the thing about that. I know he got a lot of criticism, but remember, Camille Vasquez also read her opening and her closing during the Depp trial. The difference is delivery. Because you can my pre-recorded videos, I usually do a lot of scripting for a lot of my videos, but you can deliver the words that are scripted in a way that still connects with people. Obviously when you can edit things out, it's different, but yeah, it was really boring. His opening statement was really boring because he was just reading the words on the page without any kind of feeling, without any kind of emotion, without any kind of like checking in with the jury to see like is this connecting? Are you paying attention to the words that I'm saying? Now, I feel like I feel like that's kind of he has a very understated style overall with his like directs and cross examinations. I will say though, maybe that's to balance out with Sykes because he's like overly theatrical where he's like cross-examining an expert witness and like turning to be like, oh, she's the Queen of Denmark over here.
That didn't play.
Yeah.
That didn't play. But yeah, I'll give the same tip I normally do on this thing. Toastmasters is great. I've been a member of Toastmasters for many years. It's very inexpensive. It's a lot of fun if you want to learn how to do public speaking. And then when you get into the advanced stuff, do a storytelling module. It'll help you just in public speaking in general. So you learn how to do basic stuff. So
Ready for the jury?
Take an acting for lawyers class somewhere at a local community theater. I'm doing improv classes.
Yes.
That'd be good. Yeah, I do agree that the Hamlet comments were just very, very rude and annoying. And she came off as very professional. So the juxtaposition of the two was just not favorable for Sanderson's side. How long do you think the jury will be out for deliberations? I think it's going to be less than a full day. So
Yep.
it may be, it may not be today, maybe tomorrow morning, but like I would say by tomorrow midday, we would have a verdict.
Improv is going great. Thank you for asking, Katrina or Katra. Apologize. I've done it before. It's been a couple years, but I'm really enjoying it again.
Yeah, but today's rebuttal, I don't know how much the jury was picking up on today's rebuttal witness.
And thank you for the people in chat for mentioning my soup video. I'm glad you like cooking with Kurt.
You made a soup video?
I did make a soup video. It turned out to be one of my more popular videos recently too, so it was interesting.
That's funny.
Yeah.
Indy Tony D, thanks for the super chats. I don't know if I've seen this answered anywhere yet. Why wouldn't GP's attorney have removed the federal court at the outset because of diversity?
Okay, you should have on
You
your
may have
chair.
thought it was more
the document,
advantageous.
3 pages
They could
called
have.
special verdict form. I'm going to go through that right now.
They could have for diversity because it's more than $25,000.
Members of the jury, please answer the following questions in the order that they are presented. If you find that the issue has been proved by a preponderance of the evidence, answer yes. If not, no. At least 6 jurors must agree
Save this
on the
in case
answer
I think of a
to all of the
better
required questions, but they need not be the same 6 on each question. When 6 or more of you have agreed on the answer to each question that is required to be answered, your foreperson should sign and date the form and advise the bailiff that you have reached a verdict. Gwyneth Paltrow, question 1. Was Gwyneth Paltrow at fault? Yes or no? If you answer yes, go to question 2. If you answer no, go to question 3 below. Question number 2, was Gwyneth Paltrow's fault a cause of Terry Sanderson's harm? Yes or no? Regardless of your answer, go to question 3. Terry Sanderson, question 3. Was Terry Sanderson at fault? If you answer yes or no. If you answer yes, go to question 4. If you answer no, go to question 5 below. 4, was Terry Sanderson's fault a cause of Gwyneth Paltrow's harm? Yes or no? Regardless of your answer, go to number 5 below. Number 5, if your answers to question 1 and 3 are both no, you should not proceed further except to date and sign this verdict form and return it to the courtroom. Otherwise, continue to question 6. Comparative fault, question 6, Gwyneth Paltrow. What percentage of the fault do you assign to Gwyneth Paltrow? If your answer to either questions 1 or 2 is no, then enter 0%. And there's a blank and a place for you to put your number in. Proceed to question 7. Question 7, Terry Sanderson. What percentage of the fault do you assign to Terry Sanderson? And there's a blank and a place for you to put your percentage in. If your answer to either questions 3 or 4 is no, then enter 0. The total must equal 100%. If Terry Sanderson's fault is less than 50%, answer question 8. Do not deduct from the damages any percentage of fault that you have assessed to Terry Sanderson. The judge will make any necessary deductions later. If Terry Sanderson's fault is 50% or more, do not answer question 8 and proceed to question 9. Damages Terry Sanderson, question 8. What amount fairly compensates Terry Sanderson for non-economic damages, $blank. Damages Gwyneth Paltrow, number 9. What amount fairly compensates Gwyneth Paltrow for economic damages? This cannot exceed $1, $blank. When 6 or more of you have agreed on the answer to each question that is required to be answered, your foreperson should sign and date the form and advise the bailiff that you have reached a verdict. So we'll now hear from the lawyers with their closing arguments.
Okay.
Plaintiff will go first. We'll check with the expert here.
Hello, hello?
Sounds good. Can you actually do it again?
Hello, hello?
Yes.
Ladies and gentlemen of the jury, thank you for your attentiveness during these 2 weeks. It's been a hard, long case. I've tried a lot of cases in my lifetime. This has been a hard, long case. By the way, it's about an hour each way going to Salt Lake with traffic, so that adds to it. But you've been very attentive. I've seen you taking notes and paying attention. No one nodded off. So thank you again. Now, I'm going to turn on my, Lawrence and I are going to split this. Let's see, nope. By the way, I apologize for my cold. You can't really choose when those come. I've got asthma and it makes it worse. But I've done everything I can to try to resolve it. Took all the tests. I'm negative for COVID, et cetera, but it still has plagued me. So I apologize for the coughing. Maybe a little bit more of that. Okay. There are really 3 issues in the case. Number 1, who hit whom? Okay. Number 2, did it cause any damage? Number 3, what are the damages? What are the damages? Now, Gwyneth Paltrow, in this case, is not a liar. Terry Sanderson is not a liar. Okay? Gwyneth is a good person. Okay? She's a good mother, and she loves her children, and she's passionate about many things. Now, we don't usually say good things about other people in our closing, but I think that's an accurate statement. Okay? I think that she believes, and I believe Gwyneth Paltrow when she says she believes. She says, Terry hit me in the back. And she believes it. It's a sincere belief. She's not a liar because of it. Pardon me. But the problem is, a sincere belief doesn't make it so. Now,
Oh gosh.
some of you are skiers and some of you aren't.
Like
When
even with
you're
his
involved in a ski
justification,
crash,
like he gave the reason for why
it can
it's
be
happening.
very
It's
confusing.
still,
I don't care who hit whom. It can be very confusing. So I think she sincerely believes that she got hit in the back.
The problem is you have to make a decision based on the evidence that you've heard here. Okay, on the evidence. Now, let me tell you, to illustrate this, about something that happened to me about 1.5 years ago. Okay. We live in downtown Salt Lake, and we use that Costco or shop at that Costco on 17 South and 3rd West. Some of you have probably been there. It's the largest one in the world. Okay.
We are having a hard time hearing them, so.
Yeah, Mr. Six, where's the microphone for that? Is it on your chest?
Maybe it's not turned on.
Oh,
Oh my God.
It's just so faint in the room.
It says on.
I know, I mean, I'm picking it up just fine on for the record, but no one else can
Let me
hear
use
you.
that one.
Well, maybe put it higher on your.
Maybe don't stand right in front of the jury so that other people can hear you too. Also, you're maybe coughing on the jury. Pizza the Hut up in here. Sorry to go there. Indy Tony D, thanks for the super chat. I know that's a Spaceballs reference.
Testing.
I appreciate the Spaceballs reference.
It's
Solid.
okay. He doesn't have COVID, and that's the only disease you can spread by coughing.
I just got gas at Costco. It was about July of 2022.
What?
No, 2021. And I was at intersection. This is a pretty busy intersection. There are 2 lanes,
Facts, not an
north and
evidence.
south, 2 lanes, east and west, 2 each. And there's a left-hand turn lane. I had a red light. And I was the first one at the intersection. I had a good look at it. I looked in my rear view mirror on my left side, and there's a green arrow for each direction going east and west, turning south and turning north. You understand that? So I'm waiting to have a red light. And there's a lady across the way from me, car heading west but turning south. She had a green arrow, like I saw one her heading north. I looked in my mirror, and here comes a guy at about 40, 45 miles an hour on the inside lane of 17 South. I said, my goodness, he's going to hit that woman. He's making that turn. And sure enough, smacked her and smacked her hard.
It's supposed to be a metaphor, but
Didn't slow down at all.
he's going awfully long on it.
Well, I was had a good view of it, and the car spun around, but I was able to get by. There's a Maverick on the southeast corner of the intersection. Okay. I pulled in there.
This is not what I meant when I said you should be telling a story.
And asked her, "Are you okay?" Like everybody does.
Story time.
She said, "Yeah, I think so." I didn't think she was, looking at her, but she said she was okay. Okay. So I ran over to the other guy. I was the first one there. Some people were beginning to stop. And the guy that ran the red light said, "Are you okay?" He said, "Yeah, I think so." I said, "Well, why'd you run the red light?" You know what his answer was? "I didn't. It was green." Well, I wasn't going to sit there and argue with a guy like that under those circumstances, but he said it was green. So when the police came a couple minutes later, and you got to be careful as an attorney, I gave them my card, not to get the case. You know, you can't do that, be unethical, but let people know who I was so they could call me. Get a card, and I gave each of the persons a card. And about several months later, I started getting calls from insurance adjusters wanting me to tell them what happened. And I tell you that story because so often people that are in these types of events have a totally different viewpoint. So we don't hold anything against Gwyneth for her viewpoint. It's sincerely expressed, but she's wrong based on the evidence. Okay? And Terry's correct. Now, what's the evidence that Gwyneth hit Terry? Okay. Number one, and there's no particular order on this, but Terry's a strong skier, advanced intermediate. Mr. Christensen said he saw him going down the hill doing wide radius turns. That's side to side, all the way, back and forth. Now, on a beginner's run, That's highly unlikely for an advanced skier. You don't do that. You don't do that. It's too many people. And so that doesn't make sense. Number two, I'll call it the scream heard around the world. Okay. This is being broadcast everywhere, by the way. It's on Court TV.
Shout out to Court TV.
You get emails every day from Canada, Great Britain. There's a loud scream. Terry heard it. Loud scream. Craig Ramone heard it and looked over. Several other people heard it. Carrie Oakes said she heard it. Peter Christensen heard it, so it caused him to look over. It's before the impact. And you don't, if you're the downhill skier, like Gwyneth claimed she was, you don't scream at something you can't see. You don't. It's the uphill skier that's going to make that scream.
I mean, unless
And that was Gwyneth Paltrow.
you're being hit.
The
That's
stretch.
why you're screaming. The ordering of like scream then hit is
Everybody
only
here
because of Craig Ramone.
probably been a parent.
No one else has given information that would suggest
But
that.
I've had my kids up there, and they want me to watch them ski. And mommy wants to ski. Now, Carrie Oakes said that, and that the deposition segment that you read.
Carrie Oakes did not say
said
that.
that 3 times. Okay, 3 times.
Oh, sorry. No,
And,
Carrie Oakes did say that, but that's so misleading.
That's important. Can we show Gwyneth's deposition up here?
Carrie Oakes also said that Gwyneth Paltrow was looking at where she was skiing the whole time. She never saw Gwyneth Paltrow look over at her kids while she was skiing. That's what she testified to.
Your Honor, what are we talking about here?
Mr. Sykes, is this deposition testimony that was read into court?
Yes.
And is it only deposition testimony? that was read? Okay.
Deposition, meaning trial testimony?
Well, it was read into court.
May we approach, Your Honor?
Sure.
That may be problematic because it's not a demonstrative. It's not an exhibit. It's testimony. It's read into the record as testimony. So you can use demonstratives that were used during the trial and show that to the jury during your closing arguments. You can use the demonstratives. So they can show, for example, the animation videos that Paltrow's team created for, and that aided the testimony of the expert witnesses and of the one ski instructor, Eric Christensen. But you can't just like readmit testimony
if their plan is to visually display it, that would be completely improper because that the live witnesses who are there don't have depositions, right? So it would create a unfair treatment of the witnesses.
Yeah.
So you can't do that. You can quote it. You just can't show it visually.
Right. Can they show weird formulas on paper? Yes. Yeah. Those were all demonstratives.
Yeah.
You could make the screen only show the part that was actually read in court.
Is that
really
okay, Judge, like that?
That looks good.
Okay. Well, disagree with
Now,
that
Ms.
ruling.
Paltrow, isn't it true?
I guess.
Isn't it true? I'm just a country lawyer here. Okay.
Oh, kill me.
Isn't it true?
He said the line.
God, he managed to bring country lawyer into his closing.
That your kids wanted to watch you ski, or pardon me, that the kids wanted you to watch them ski. Isn't that true? Vague as the time. I can still watch my children ski and be skied directly into my back by someone. Okay? Which is what happened.
This is from
And I'm going
Gwyneth
to
Paltrow's
omit Mr. Owen's
deposition?
statement and my own. And here's how it reads.
I'm very confused about this.
Isn't it true that your kids wanted to watch you ski? Or pardon me, that the kids wanted you to watch them ski. I can still watch my children ski and be skied directly into my back by someone.
Oh, I misunderstood. In the question itself, he called himself country lawyer. So he's just quoting himself.
Yeah.
Okay.
Yeah. Which just supports the idea that is a gimmick that he likes to pull up.
I hate him. I have disdain for him, and I have disdain for Man Bun,
Craig Ramon.
Chewing gum.
We thought about having him testify again today about those drawings, but we decided not to do it. But
It's a race of who do I hate the
he
most.
saw the
That's
whole
what's
thing.
going
He
on.
saw the impact. And he's the only one that saw it. That's a
That
key
deposition
piece of
testimony didn't even
evidence.
come
And who
out
is
during
Craig
trial,
Ramon?
though. I
He's an
disagree with
acquaintance
with
of
that
Terry.
decision.
He's part of a meetup group. He's not close to Terry. They went to get garlic burgers twice, okay? He has no dog in the fight, ladies and gentlemen, no dog in the fight.
Craig Ramon? He's got some
He's
loyalty
he's
to his
independently
friend.
wealthy. You can tell that by what he does.
Your Honor, that's assumes facts not in evidence.
Well, it's,
Just a minute. Objection overruled. The jury will have to recall what the evidence was, and
the evidence was he sold his business, I don't know,
And this judge
10
doesn't
years
like
ago.
that.
And all he does
assessment.
now is ski and
He said
travel
earlier
and scuba
today.
dive. Okay? He has no reason, no motive to falsify this. Okay?
Yes, he does.
Confirmation, those meetup emails that you saw. There was one of the last evidence, I think it was 44, was it? I won't go over it with you. But we printed that out, I think, Saturday or Monday. It gives you the number of days since it was entered. And you add those up, you go right back to February 26, 27, 28, around there. Strong evidence. Terry has repeatedly said to his medical providers that he was hit in the back over a period of years. And that he has problems, medical problems with him. The broken ribs, that's one of the strongest pieces of evidence you have, that Terry was the guy that was hit. He was the downhill skier, okay? 4 broken ribs, 2 of them separated like that, weren't together. And that's very serious, it's very painful. But the pattern of those broken ribs, 2 MDs, one from Utah and Dr. Bain. So that pattern of broken ribs supports the fact that he was hit from behind. Now, I'm not going to go into all the details of that. That's what he said. And Dr. Bain, who just testified again today, said that Dr. Scher was simply wrong in his philosophy, or his formula. He assumed it was a free fall, and it wasn't a free fall. Broken ribs. How do you get that without a significant impact? Now, the flaky Deer Valley investigation, I think, suggests a cover-up. Eric Christensen, I think, was unbelievable and inconsistent. And there were a number of things. I'm not going to go over each one of them, but I will talk about one. The claim
I think he's right
that
at
Terry
the jury
said he
box
was
right
okay.
now.
Now,
If I'm in
some
that
of you
front
probably
row,
had
I'm
broken
like,
ribs or loved ones that have had them.
can I
you know.
put a poncho on?
Even
I'm in the splash zone.
Steve Grant up here said it's extremely painful. Now, this whole process took place between 11:55, which is the time of Graf's incident report, and 12:02, when Ramon flagged down the ski patrol, and 12:04 when Whitney Smith arrived. So we're talking about 7 to 9 minutes, okay? And they would have you believe that a man with 4 broken ribs, 4, 2 separated, told not only Eric Christensen that he was okay, but 2 other unnamed, unidentified ski patrollers that never logged it in. He told them he was okay. Now that's just unbelievable.
It is
that
believable,
would happen.
actually.
A person with 4 broken ribs, not just one,
You
4.
proved it was believable about
ski
20
between the
minutes ago
legs.
when you told your car wreck story.
I don't know how many of you are skiers. I don't remember. You said it in your interviews.
Oh, a number
weeks
of them
ago,
are
but-
skiers.
To
That's
have
Pastor
someone
Sanderson.
ski between your legs. She thought it was a sexual assault. Okay? But to have someone with both skis, to someone that's moving and shooshing back and forth, it's just another unbelievable claim. That can't happen.
Mark Taylor, thanks for the
Now-
chat.
And then Gwyneth skis away to lunch. The only way that Terry Sanderson knew that this is Gwyneth Paltrow is Christensen got angry and said, your buddy just took out Gwyneth Paltrow, which is an odd comment to make. Like, just took out a person, but he had to put in Gwyneth Paltrow. That's the only way we know that. That's why you're here. Now, causation. This event caused an injury. Well, I've already mentioned this. The impact was significant enough to break 4 ribs. The impact in the fall, that is a significant impact. The location, the right front, is where you would expect it under the circumstances. Loss of consciousness. It was
I've
only
lost
a few
consciousness
minutes,
at portions of this
maybe 2,
trial.
maybe 3.
I think it's just a normal thing.
But
That's
there
also
was a loss
passing
of
around.
consciousness widely reported in the medical records and that
I
day.
demand compensation.
Widely reported. I mentioned the okay. Don't want to mention that again. So it was significant enough at the time. The very first thing that anybody noticed was that Terry forgot how to ski. He was snow plowing down the hill.
Too
An
early to start
advanced
drinking.
intermediate snow plowing.
That only
down
came
the
in
hill.
because of here. I mean, that was
Think
Thursday.
about that
That
for a
shouldn't have
minute.
come in.
And Craig Ramon says, hey, Terry, you forgot how to ski. And that's when Craig Ramon said, I got to flag someone down. So he did. And he told that person, he's got a head injury. That's the words he used, a head injury. Now, it took him 5 seconds, and Craig acted it out up here, 5 seconds to be able to tell him his name. He didn't know where he was at first. That's a significant impact. That's a concussion. Now, ski patrol flagged down at 12:02. Whitney Smith arrives. What a sweet person. And Terry's taken off the hill in a toboggan. Now, that's no fun, but it shows you something happened. She rides disoriented, rib pain, loss of consciousness. By the way, Alina Fong, who treats thousands and thousands and thousands of TBI victims, said loss of consciousness is not required. Okay, not required. Headache, and that day, I think at the clinic in Park City, dullness in the front of the head. And Whitney Smith said, go to the ER. And Dr. McMahon said, go to the ER. So the next several months, you have numerous symptoms of TBI that show up in the VA records. Cognitive, personality, social, and emotional. I could go through and show them to you, but you all saw them. But then, one of the most significant
Cough one more
pieces
time.
of evidence here
I dare you.
is a sudden and precipitous change in Terry Sanderson. Sudden and precipitous, okay? Now, I'm not talking about when he came home and Carlene, said he didn't want to be touched. He's got 4 broken ribs. But Carlene, who loved him, said it was a love relationship. She wanted to marry him. They've been together 300 days a year up here and then down there in St. George for about 1.5 years. It's a long time to look at someone. She loved him. She traveled with him. She wanted to marry him. And you saw how she choked up when she explained how the relationship ended, that he changed. His personality changed. Polly Gresham, Shay Harris, same thing. Big changes. They didn't see him as often. So that sudden and precipitous change is a sign of brain injury. Diagnosis of concussion. The VA diagnosed it. Multiple physicians diagnosed it. All the defense experts admitted it. Every one of them admitted it. They minimized the extent of it, but they all admitted he had a concussion. Every one of them. Every one of them. Dr. Gibby, Dr. Fong, Dr. Goldstein, Dr. Bain. The only question was severity and permanency. But every one of them, they didn't want to admit it, but they gave different numbers between 5 and 20% of people that get a concussion. It's permanent. They have permanent problems. 5 and 20% between that. Dr. Fong thinks it's higher than that even. Now, the physics. Dr. Bain explained the physics, I think, second day of trial, and a little bit today. But he's a neurologist, but he's also a biomedical engineer. That's different than Dr. Scher. He's a biomechanical engineer. But Dr. Bain specializes in how force affects the body. Very highly respected in that field. That's very rare, not very many of them. Terry talked about the loss of friendships. Mark Horath, good example. They were good buddies when skiing, and didn't like him anymore. He talked about the woman that he was going to Europe with. Don't remember her name. You remember it, but she changed her mind at the last minute and had an empty seat. That's how Jenny got to go. The experience of his granddaughter carried into her for how to tie a knot. Big changes. Greg Ramon said, Terry, after the accident, seemed like he could talk to the wall for an hour and have a good conversation. Faking. Every witness you heard from the defense admitted that Terry was not faking, malingering, exaggerating, or magnifying his symptoms. And Dr. Goldstein said there are tests embedded in his tests to find that. No evidence of that at all. And by the way, the VA records continue up until the present day. And they didn't show you any single VA record where that was ever suggested of this man.
Closing isn't really doing it for me.
NPH. They suggested, that could just the normative, what is it called again?
Normal pressure hydrocephalus.
Normal pressure hydrocephalus. He's
It's not
got
on your
it, but
sheet in
no
front of you?
symptoms. And it didn't change over about a 13-year period. 2009 to 2021. Dementia, they kind of implied that maybe he's got that, but when we cornered them on cross-examination, not a one of them said he had dementia. And there's no reference in these thousands of pages of records that he diagnosis. Degradation of imaging, okay? We have imaging, I think, from 2009 to 2021, and all the defense experts, plus our own, said there's no degradation on these imaging. He's got white matter abnormalities, probably half of us do. Nothing showed in there. No problems. No increase. We heard that just as recently as yesterday. Now, I'm going to say just a few more things here in terms of time over to my colleague, Lawrence Bueller. This is actually his case. He asked me to help.
Oh, boy.
You did?
Yeah, I guess so.
That day when Terry left his home.
Ask someone else.
In the Deer Valley, that meetup here. February 26, 2016. He anticipated, like many, many other days in his life, a fun day of skiing. Okay? And he never returned home that night as the same Terry. He never came home, figuratively speaking. Terry has tried to get off that mountain, but he's really still there. Part of Terry will forever be on the Bandana Run, figuratively.
It's very dramatic.
People who are just after money, and that was suggested. He's just after money and fame. somehow going through all of this and spending all the money he spent on experts, he's doing it for fame. Give me a break. But
You're not going to
he spent hours
rebut that with
and
some kind of
hours trying to
reasoning?
get better.
Like
If you heard anything
theory?
about him, he is almost, what's a good word? Extreme in trying to get better. He does everything he can to get better.
Like the time he hit his head.
Anyway,
past
we hope
45 minutes.
that you will help bring Terry home off that
Hey,
mountain
Steve.
with a fair verdict today.
Good to have you back.
Now, before I turn it over to Lawrence, I want to say one more thing about executive function. Okay. I had an experience up here that taught me about that. 40 years ago, I was in the legislature with a guy named Glenn Brown. I think he's still alive. He's in Colville, has a dairy farm, or did.
So he's a former politician.
And I used to kid him about milking cows, So he invited me up to his farm. Young lawyer, going to show me how to milk cows. Never done it. Got up there, and he showed me around his barn. It was really sophisticated.
I thought you were just a country lawyer. You didn't know?
Yeah, exactly.
But
Even I milk cows. Come on.
when you think about why Terry never came home, think about this story in executive function. Because he put a little stool out there for me, and I sat down in my jeans and tried to milk a cow by hand.
His country
Took off
jeans.
my cowboy hat.
It's very hard to do for a
Strapped on
country boy.
my country boots.
They grew up in the city. But I was able to squeeze out a little bit of milk, He gave me some, take home. Glenn Brown's a great guy. But I asked him
That's a good idea.
this situation. I said, how do you do all this? He showed me this very sophisticated situation that milks cows automatically. This is automatic.
Wow.
He says, without this, Bob, I could never make it. Couldn't do it. Can't get enough people to come help me do it by hand, like my grandpa did. That's executive function. That's what it does for us. We're able to do a lot of
executive
things
function.
in life. And that milking
Not the best
mechanism
explanation.
was executive function for Glenn
Well,
Brown's farm.
In that case, I have
produce
no
milk.
executive function,
Yeah.
I guess.
It's utterly irrelevant.
Terry's
Uh,
saddest problem is loss of executive
That was
function.
perfect.
Okay.
Awful.
He cannot
It's an old country
organize
joke.
and
love
manipulate his life to do things like he used to do. It's the saddest thing. And that's why part of him is still up there on that mountain. Thank you. Lawrence?
Which part?
That's
Stan
Something,
Ramirez, thanks for the
something,
super chat.
Let's sit down.
Yeah, I
something,
didn't have
something
milking
milking
cows on.
cows.
I didn't have that on my bingo card
I'm gonna
either.
have a few more comments for you when he's done.
Something, milky cows. Terry should win.
There was some kind of a car accident on a 2-lane highway. He's really trying to like buttress this idea that he's a country lawyer with these examples.
But he's shocked that
metaphors,
not every cow is milked by hand. I mean, come on. How old is this guy? Like 186 years old?
What's this technology you speak of? Oh man.
Still good morning. Good morning.
Is it
everyone.
though? Is it good morning? Facts not an evidence. Objection.
Can I try this? See if it works on me? Sure.
It was good. Yeah.
When he says country lawyer, he just means like the United States.
All of the United States, every part of it.
Never trust those city lawyers.
I'm actually just hearing it from you right there. Can you try the other mic by chance? Let's change the batteries.
Yeah, there was really no narrative to like hold on to get his points across. It's like he was just going through like a bullet point list and just trying to check off his box. Like, okay, I talked about this, but it's hard to follow everything. It's hard to keep all of that information in your brain when you're just going through data.
All I know is the best part of Terry got milked out of that cow. on some mountainside a long time ago. That's all I know from that closer. He should have gone with the unfrozen cave lawyer. I've always enjoyed that skit. I think he should have done that. I don't buy him as the country lawyer.
Oh,
Southern-in-law's a country lawyer.
That's yeah.
This case is simple.
Way out in the woods in Virginia. I've seen cows in real life.
You've heard the first two parts of this. Who hit whom? And what are the damage that were caused to Terry? And then
the Southern-in-law
next
believes in
question
that
is,
book learning.
How much are those damages? That's the part of the case I'll deal with. This case is about answering the simple questions the law asks us to put on the form that we call the verdict form, which you'll get in a few minutes, or maybe this afternoon.
Oh no, they have the boring guy talking about the boring part?
Verdict. That's an interesting word.
Oh, no.
It comes from Latin.
Oh,
It's actually
no.
two words. It means verus, truth, or dicta,
saying,
or to tell or told. So combined, it means truth told. And that's what you're here for.
Wow.
is the
Thanks for the
truth
etymology
told.
lesson. That was really valuable in my day.
So what does the law want us to tell the truth about? Well, let's look at what the verdict form says.
Webster's dictionary defines verdict as
Yeah. I don't
The
like
first
I don't
question
like this
is,
style.
was Gwyneth Paltrow at fault? As my colleague Bob Sykes said, the evidence is clear. There were 4 broken ribs, an eyewitness. There's lots of other evidence too, circumstantial evidence that Miss Paltrow hit Terry Sanderson on February 26, 2016. The stories have been consistent for 7 years. So the first question, we answer yes.
We?
Now,
sure you do.
earlier, it was in
Tell you what I think.
jury
How about
instruction
no?
number
It's
27.
gonna work for you?
The judge defined what negligence is. And judges around the country have a hard time defining what it is. It's very abstract, very abstract. And what it means, basically,
At least
is
he's not reading this time.
they knew it was dangerous to ski.
I'm gonna have to
Well,
put on my
distracted.
coffee or something. I don't know.
I do
They
want to
knew
see
that someone
what the
could
jury
get
looks like. I
hurt
wish
if
I
they
wish we could
continue
see
to
what the
do
jury
that.
looks like right now.
And they did it anyway.
Maybe I should start my own coffee company. Everyone else is doing it.
Did they know the damage would be this serious? Well,
All 2 brand coffee.
we've all heard about collisions. Collisions happen on the football field. Collisions happen even on sidewalks sometimes. People get concussions. And Terry, there's no doubt, suffered a concussion.
Just look at him. He's pitiful.
But Terry's damage is not just a concussion that goes away in a few minutes or a few days or a couple weeks. We know that Terry's damages or his concussion persisted for more than a year and a half. And that's been verified by Dr. Fong, Dr. Gibby, Dr. Goldstein, and Dr. Bain. Even the defense's experts admit that he had a concussion. They quibble on how long it's lasted. But none of those defense witnesses actually examined Terry. And as Bob pointed out, none of them really acknowledged that Terry had problems. One of them refused to acknowledge the before and after witnesses. His 2 daughters, actually 3, but 2 daughters that testified in this trial, Shay and Polly.
And the other one.
His friend Mark Harath, Finally, or the first witness after Craig Ramon was Carlene Davidson, his ex-girlfriend. They'd known each other for 18 months before the crash, 6 months after the crash. She testified that the damage continued, thus making it a permanent, this is a tongue twister.
Is it?
Persistent concussive symptom. And that permanent persistent concussive syndrome is the long-term brain damage that we're talking about. So what it means is every waking hour that Terry has, he's got this brain injury that causes so many problems for him, from executive function to just, being able to deal with people. And as those witnesses showed, Terry has a problem. He looks fine. It's an invisible injury. People know, that's what they say about brain injury. It's an invisible injury.
Clearly can.
You see someone with a brain injury and they look fine. What's wrong with them? If he has a brain injury, why isn't he in bed and moping around and not doing anything? Well, that's the opposite of Terry. The crash took much of what he had and left it on the mountain. Terry still has that drive to get better.
I'd like to offer my legal services to the fine people of Utah because they clearly need it.
They last a lifetime. They last forever. So 16 hours a day, Terry is dealing with this injury, such that, as Bob mentioned, when people get to know him, after a while, they don't want to deal with him anymore.
Yeah, they hate him. We hate him.
I'm sorry I have to say this, but I've known Terry now 6 years. This is just argument, but it's
Can't
real.
stand him.
Now the 4 broken ribs, those were painful for maybe 3 months or so, but the brain injury has persisted to this day and will last until he dies. The executive function, the social abilities, the mental problems, driving to the store, not knowing where you are and having to use GPS just to get home. These are real injuries that Harry, who was a very bright person, you would not know it just talking to him for 10 minutes. But once you get to know him better, you realize he's got these problems that just change everything. So as I talked to someone left me a message, and every time I hear this voice message, it just makes me cry. Just because it's so just kind of flat, but he says, this person suffered a similar injury 30 years ago. Persistent concussive syndrome or injury, permanent brain injury.
Something.
And she said, it's permanent. Your personality change is permanent. And you lose everybody who knows you. You lose everybody. Yeah, your family, they'll put up with you, and maybe the lawyers, but really they're just putting up with you.
Massive dunk on their own client.
So let's go to the next question.
He's a jerk.
I hate this guy. He's the
No
most
one
vile
likes
I'm going to
him.
go through, because this is a complicated case, Ms. Paltrow is suing for $1. We're going to go through these next questions. Was Terry Sanderson at fault? Terry was hit from behind. Craig Ramon saw it. The rib injuries show it. Now, Dr. Scher, for the defense, who's not a medical doctor, he's a mechanical engineer, deals with ski bindings
Damn good one.
mostly. He says that Terry Sanderson likely skirted under Gwyneth Paltrow and somehow twisted around and broke his ribs. As Dr. Bain confirmed again today, that's impossible. It defies the law of physics. So I think you have to answer no. I mean, it's a clear no. Was Terry Sanderson at fault? Number 3, no. So then you go to 5 below. And since 1 is yes, this is like a puzzle.
No, it's not to mark it. Mark it.
Here, I've got a pen. Here. I've got one.
Let's solve this puzzle.
So was Terry Sanderson at fault? I'll go back to the first page. Was Gwyneth Paltrow at fault? Yes. Oh, I forgot to do number 2.
Wrong box.
And you have to go in order. Was Miss Paltrow's fault the cause of Terry Sanderson's harm? It clearly is. Terry Sanderson was hit from behind. There was a scream, and he was hit from behind.
Paltrow's just
So
shaking
the
her head
answer
no.
is yes. So then we go to 3.
Don't do it. Don't
And because
smart.
we answer number
Don't roll your eyes. Oh no, what's happening?
0.
Okay.
And to be honest with you, this is the first time I've seen the form because it was just finalized just before we started the. So I have to think about this one a little bit, but let's think about it together.
Yes.
What percent of fault do you assign to Gwyneth Paltrow? If your answer either 1 or 2 is no, then enter 0. Well, both are yes.
This is the worst thing ever.
Because Terry Sanderson did not cause this crash. You can't cause a crash when you're hit from behind.
Okay, that's some real law there.
Did you see that? Did you
What
see
percent of fault do you assign to Terry Sanderson? Well, it has to add up to 100, so you have to put in 0 there. If Terry Sanderson's fault is less than 50%, answer question 8. Well, it is, so we skipped 8. What amount fairly compensates Terry Sanderson for non-economic damages?
0.
Non-economic damages. Our time on Earth is the most valuable time we have.
Because it's the only time?
Our time on Earth is one of the most valuable things there are. There are paintings on a wall that are worth $50, $100 million. There are houses on these mountainsides
quite
that are worth
seen this tactic.
5, 10, 20, much more millions of dollars.
But I guess some people.
There's even racehorses that are worth tens of millions of dollars. Well, Terry's none of those. Terry's in the last
Obviously the most boring way
days
to
of
do a
his
closing
life.
argument.
He probably has at least 10 years left, according to what a lot of people think. He guards his health. He doesn't smoke. He's trying to pursue a healthy lifestyle every single day. Yeah, he goes to the doctor, but he's since the crash, it's been 7 years. And let's say another 10 years. Every single day, he's got a 16 hours of dealing with this brain injury, this persistent concussive symptom that causes all these problems. So how do we calculate that? As the instruction says, for non-economic damages, jury instruction 35, which you all have, it gives a detailed instruction about that. Pain, suffering, loss of enjoyment of life, and a retired person, well-to-do person like Terry, who worked all his life, these are the golden years. These are the most valuable years when you can enjoy your retirement and actually do things like travel.
Which he's been
now
doing.
He has to travel with other people or he gets lost. Dr. Fong and his other therapists, most of his therapists have said, what's the best way to deal with, your brain injury? Well, do the things
Apparently
that
riding
make you happy,
camels
be
Morocco.
active. He could sit around and mope around and be an obvious brain injury victim, but no, Terry doesn't want to be brain injured. He wants to live life to its fullest. So 16 hours a day, he's got this issue that where a big part of him was left up on that Bandana ski run.
Is the dude gonna give him a number or what? Is that what this board's for? And the check, please.
Drum roll.
So you have
Is that
the
a
power
giant check?
here. This is, before we were just arguing and presenting evidence and the judge was ruling on it. But now the judge is going to pass the case to you. And this is where you decide what happens next. So I'm going to suggest, I'm not going to ask, this is not a, Terry asked me several years ago when I first learned of his case, well, what do you think it's worth? I said, well, Terry, could you, if you could turn the earth backwards like Superman, go back in time, and how much would Terry take to not have what he has now? And he says, I'd rather go back in time and never have this. So
Well,
how
obviously,
do we calculate this?
that's anyone.
Well, I'm going to suggest a number. This is just a
3.275 million.
suggestion that we do it with 16 hours a day.
He's ashamed of whatever number's coming.
About the formulas, Dr. Bain and Dr. Scher give you
He's
a lot
having
of
a,
formulas.
yeah,
but
he's having a
hopefully
hard
these will
time
be simpler,
swallowing.
more
having
simpler
to give this
than all
part,
those.
I think.
So that's 16 hours a day.
Times 1 day is, well,
Times 365 days a year.
Times 10 years.
he's going 17, right? He's got 10 to go and 7. He's
And the
suffered
next
so
question is
greatly.
the years. Well, it's been 7 years since the crash.
Oh, 17. Yeah, I guess you're right.
Yeah.
Terry's likely to live another 10 years. Probably, we hope longer, much longer. He wants to live at 130.
That would be difficult.
Even he laughed at it.
Did
You know, at
Terry
least
just
10
laugh?
years.
Yeah. His own clients are like, what in the hell?
7 years since the crash, 10 years, that's 17 years. So we're going to times the next number, 17. Then the question is, how much is, not the price, there's no price that you can give for Terry's time, but what is the value that's been taken away from Terry? What is the value? I mean, they're lawyers and they're experts and lots of people here that are making low wages, but a lot of people are making $300, $400, $500 an hour. Well, I'm just suggesting a number, and you can put in whatever number you want. This is for the non-economic damages that Terry deals with every day. So that's the next number. 16 times 365 times 17.
Have some multiple of 3 or
I'm going to suggest a number. You put in the number you think is fair for Terry. The full value of the harms and losses that he's dealing with every day.
He's using what somebody
I'm gonna
made
say
per hour
$33.
for a measure of non-economic damages.
$33.
Where does he get 33 from?
$33 an hour.
And
He's totally made
I've
that
done the
up.
math because I told you in the opening. Except for the small change at the end, a couple
16.
$100.
No, 16 hours a day. Oh, yeah,
This
that's right.
equation,
I was reading Mark Taylor's comment in the chat. Well, why? I knew it.
There it is. There's the 3 million. Talking about the other day. They still want that to get paid,
Yep.
is $3,276,000 for the 17 years that Terry has to deal with this permanent brain injury.
But why?
Yeah, you could,
why
you
30
could say, well,
times 33? That doesn't.
it's priceless, but an old shoe is
Here's a price, though.
priceless. No, this is the most valuable time of his life. And
An old
so
shoe.
that's the amount that I suggest you consider. So what is this case not about? It's not about celebrity. It's not about that. Yeah, there are lots of indications of that, but this is about a man's life. What does the defense want to make this case about? They want to make it about Terry's multiple issues. The 69-year-old Terry that was on that hill. Oh, yeah, he had all sorts of medical problems, but the defense wants to make it about that. But that didn't mean, he was skiing on that hill at Deer Valley. I can't think of any place I'd rather be skiing than Deer Valley. maybe, backcountry powder, but the point is he was healthy enough to ski, and now he doesn't ski. Now I'm going to tell you a quick story about the legend of King Morgan.
Oh
King
my
Morgan was
God.
the real king back in England about 1,000 years ago.
Telling a lot of great
Back
stories,
then, the
just not one
kings
about this case.
were the law. Someone had a dispute. A farmer knocked an eye out of his neighbor. It was eye for an eye justice. They'd take the eye out of the guy who did it. And what did the victim get? Nothing. Well, King Morgan one day said, you know what? I'm going to invite 12 of my nobles, the guys that have the littler castles. And I'm going to have them come in, and I'm going to have them listen to a case. And he
That's
heard
what the king said.
The nobles heard the case, and then they said, well, we think it should be decided this way. And the king said, yeah, you're right. And that's good. So they did it a few more times. And finally the king said, you guys decide the cases. I'm going to go off and do what kings do and hunt and fish and fight battles. Well, that's the same system that was adopted in the Magna Carta almost 1,000 years or 800 years ago.
Why are we talking about
And it's the
Magna
same
Carta?
system that was brought over by the pilgrims
This is
that we
America,
celebrate
sir.
Thanksgiving for. And it's the same system in our country. And we're the only country that still has the jury system where people like you decide the cases. Winston Churchill, the Prime Minister of England during World War II, he said, America is a great country. And one of the reasons it's so great is its jury system. And no other country has it. And if you want to weaken America, take away its jury system. Thank you.
Rule for our client, or you're ruling against America. That's what I heard.
We'll take a short recess before we continue. Maybe about 15 minutes.
Oh, quick recess. Okay.
I think they do need a few moments to digest what in the world just happened there.
Beautiful four stations.
That was that was a way to do a closing argument.
Yeah.
Not the way that I would want to do a closing argument.
King Morgan rides off into the sunset, and what? That's. And is it true that we're the only country in the world that has the juries? I'm not sure I buy that without Googling it.
I don't know, but the jury doesn't need to know that. That's not information that they need to have in their brains.
I think most countries have abolished it for a lot of cases, including England. They still have it for some cases, but not as much as we do.
Shireen is calling BS. UK has juries. So
do you though? Do you do? Because you're not America.
And they say you can still hear King Morgan in the hills at night, riding around laughing, letting that jury do his work.
Yeah. The thing is, like, they wanted to tell stories. Why didn't they just tell the story of what they say happened in this case?
Why don't you just tell the story of Hamlet? That'll be good.
I mean, that's what the closing argument is supposed to do. Like, you're supposed to restate the narrative from your client's perspective, go through the evidence that came out in trial in front of the jury, remind them, you heard from this witness, you heard from that witness, you heard from this witness, you heard from that witness. And all of that supports this theory, or not theory, because it's not a theory to you and your client. It is a reality. It supports our side. It shows that the other side is BSing you, and that's the end of the day. I don't know why they needed to go into these other side quests with talking about these other narratives when they could have done a very sufficient job of just telling the story of Terry just minding his own business, skiing down the hill, and Gwyneth Paltrow being this reckless Hollywood celebrity, just tearing it up.
Wait,
and
I want to do one. I have one. I want to do one.
Okay.
All right. Okay, ladies and gentlemen of the jury. Once there was a Viking king named Bluetooth, and he was known for bringing together the various coalitions and unifying a government under him. And Bluetooth is the name that we now use for the technology that we use every day in our lives for devices to communicate to each other and named after that Viking king. This case is about communication. And like Bluetooth himself, I want you to communicate clearly and loudly, using your voices as a jury, and return a verdict for Terry. How'd I do?
That was good.
Great.
That's very
Thanks. No problem.
Very good. A+ on the delivery.
Great. Thanks.
So the $33 an hour, did they have a $3.2 million demand? And they're like, well, we got to backfill an equation that comes up to this, and 33 is the number that makes the magic happen? Or what the hell was that?
I think that's exactly what they did, because when he drew that line and said, you can fill it in however you think is appropriate, I was expecting somewhere between 3 and 5. That's why I said that, because I've done these damages estimates as when I was doing plaintiffs' employment litigation cases, and we would estimate emotional harm for someone being retaliated against for making a complaint or what have you, along with their economic damages, loss of income, all this kind. You take the loss of income and you multiply it by somewhere between 3 and 5. And because that is how you get like the emotional damages on top of the economic. So it's like you have to have reasonable limits. So that 33 is like, that's wild to be multiplying it by that much.
And especially when he still does all the things he used to do, except mostly what I got was he needs somebody to go with him, although I'm not sure he traveled by himself before. And also everybody hates him. He's like the worst butthole. They can barely tolerate him. Look at him. He can get by for 10 minutes convincing you he's a decent person, but after that, you will hate him with every fiber of your being. And he testified, right, for a period of time without becoming a raging lunatic. I know he said weird things, but he was on the stand for a while. So now you have to convince the jury that this guy who was trying to be decent and polite, because wasn't he polite and stuff to people, that he's actually a raging anger 24 hours a day. Well, 16 hours a day. He's a raging lunatic that everybody and no one can stand him, even his own lawyers. That's a weird one too.
Yeah. And his performance on the stand is kind of a catch-22 because of the head injury. So it's like, I was expecting him to have some trouble with his testimony. And I really think that is the real reason why they had, was it Dr. Black? The one who had a stroke before. Let's see here. I think it was Dr. Black was that doctor. Yeah, because Dr. Hesh was the other bald guy. Dr. Black was the one who had a stroke. And so it was kind of difficult to follow his testimony. You really had to focus in order to get it, because he has obviously he's a very intelligent guy, and he's got a lot of clarity of thought, but the communication between his brain and his mouth, it takes some time for him to send the words to his mouth to talk and to communicate. So it's like, we saw what that looks like on the stand. So I'm wondering if that was half the reason why the defense attorneys called him as an expert, was to show like, this is what a head injury looks like in testimony. Which of course it can look different for different, like every case is different because the brain is so complex, and head injuries can be very, a stroke can happen in any part of the brain. Concussions can happen with bruising in different parts of the brain. And so I definitely recognize that, but I think that was maybe like a subtle thing that they were trying to do, was to compare, like, Terry Sanderson is having zero problems communicating right now. He is being very polite. We think that he's being deceptive because his daughter testified to his trip with his other daughter, Jenny, and she described it as a complete disaster. And then when Terry Sanderson got up and he was asked about that same trip, he was like, "Oh, it was a wonderful trip. I love my daughter so much. It was such a great trip." So it's like, you're not being real to the jury. You're not being fully honest about your experiences with other people and with yourself. So anyway, I don't know. I'm not sure exactly if I landed where I was going with that, but yeah, the whole head injury thing it can be a bit of a catch-22, because if you look if you look too good, you can look like you don't have a head injury, so and the jury is evaluating that. At the same time, like, if you communicate poorly, you might have a hard time getting across what the jury needs in order to understand your case.
When he was doing all those Facebook posts and stuff about all these travels all over the world, going to Germany 18 times and car shows and exotic cruises and camels and ships and skis and castles and things, they should have told him, look, every time you finish your Facebook post about this play track, just end it with, and I am so angry. Here I am on this camel at this beautiful sunset with this beautiful new girlfriend, and I am so angry.
Still struggling with the head injury, but, making the best of what I can.
Yeah, exactly.
Like, here's a prescription vacation number 2. Doctors prescribed me this vacation. It's the only reason why I'm doing this.
I get my insurance to pay for that. This is diagnosed by provider or my doctor. It's like, you really need to go to Japan to get healthy. So give the insurance company to pay for that one.
I doubt it. But it would be nice. But yeah, what we usually expect out of a closing argument is something that's more like hammering in the narrative again, like just saying like, look, this is the reality of what happened. And the other side, they have their perspective, but here's why they're wrong. And here's why we're right. And what they did instead was, in the first half with Sykes, he's basically checking boxes like, I need to go over this. I need to go over this. I need to go over this, so that I make sure that I talk about these points. But none of them like tie back to, and this is why we win, and this is why you should believe our version of events. This is why you should believe Terry Sanderson and not Gwyneth Paltrow. It was just very stilted and very hard to follow. Honestly, I feel like trial lawyers should all take practice of uploading at least one YouTube video. Because like, if you can explain legal concepts in a YouTube video and have people actually watch it and sit through it and understand it, it makes it like, I feel like you learn a lot about being able to explain this stuff to a normal person. These guys, I have a sense that they don't spend that much time like explaining law to normal people. I don't know.
Or in a courtroom. I'm sorry to say. I mean, when I first started out, I worked at a very big firm, and a lot of the high up partners would do all they could to stay out of a trial, because losing a trial, would result in a lot of bad publicity. So there were a lot of people that didn't have much courtroom experience, despite the prestige they had in the practice. And I wondered that about these guys. Like, how often do they go to a jury verdict? I mean, certainly I haven't done it in a long time, so I'm not claiming it. I don't have rust. But I'm like, this is all wrong. Like, did they dry run any of these closings to even a family member? Like, they couldn't have, right? Because it's all like, what are you talking about? It seems like you said they scribbled down points and figured, I'll get up there and talk about it. You go over the points and I'll go over the form with them. You talk about the cow and how his ribs are broken, and then I'll show them how to fill out the form, and we'll get $3.2 million, maybe we won't. Do they even care? Because they hate this guy so much. So I don't know what's going on here.
Yeah, no, I don't. That's a very good point. I mean, I don't know about their experience with doing trials. I would be surprised if they did a lot of trials, at least recently. Maybe they used to do a lot of trials and they're a little bit out of practice because they haven't done them in a while. I mean, I guess the reason why I feel like it would be good to upload at least one YouTube video is because, like, closing argument, opening statement, it's one of those experiences where you are expressing, like, you're explaining certain ideas and you're expressing a certain point of view to a group of people and you can't really get feedback from them in real time. Kind of, you can, like, you can tell if people are meeting your eyes, you can tell what their body language is, but like, it's not like a normal conversation where someone can just, like pipe up and say like, I don't understand what you meant by that, or I don't understand where you're going, or I'm lost. Like you can't exactly get that kind of feedback. And it's similar to a YouTube video where it's like, live streams, you can do that a bit because you've got, if you've got a chat, you've got people asking questions and things like that. But like in a normal uploaded video, like that's pre-recorded, that's different. Like you, in order for it to be successful, it has to be something that people are going to be able to follow. And you don't necessarily have that feedback until long after you have already uploaded that video and obviously scripted and talked in it and all that kind of stuff. So yeah, I don't know. I feel like these guys would do well with learning that whole process. By the way, Shireen, thank you so much for gifting 5 Legal Bites memberships. That is so kind, so generous of you. And I know you've donated before gifted before, and that's so kind. So, and to all the folks that are now members of Bite Club, welcome to Bite Club. I hope to see you in our next members only live stream. If this reaches a verdict early, then I'll probably end up doing the members only live stream tomorrow, like usual on Fridays. But if not, then we'll be continuing some coverage here. We'll see. There's also a super chat here that I saved. Terry B, thanks so much for the super chat. This is also both experts yesterday said categorically that any permanent damage past 6 months isn't a known science anyone goes by. 100%. That's why those experts were just so devastating for his case. And also I saved this one from earlier. Joshua Taylor Ampliford, thanks for the super chat. It says, how can they say he hasn't skied since? It's been 3. I thought that he had gone skiing since.
Yeah, he did say that.
Yeah. Okay. So this is where either there's a miscommunication on the team or there's a lack of clarity on the testimony, which you also want to avoid. Or, where was I going with that? Sorry, I got distracted for a second. Or you're not keeping track of your details, which that seems to be the case in this case. Like there have been so many instances where Sykes has like stood up to like pound his fist on the table to be like, this is wrong. This thing is happening. And it turns out that he's completely wrong because, the deadline that he says that the other team didn't meet, they actually did meet. Everything's above board. Everything's fine. And he just makes himself look like an ass because he doesn't, it's like the left hand doesn't know what the right hand is doing. So when he says that Terry hasn't skied since, but Terry has previously said that he has skied since, and the jury has seen both statements, that just means that they're less likely to look at the attorney and be like, oh, okay, yeah, your arguments make sense.
I wonder if they thought, she'll settle this. She'll never want to sit through a trial and have to deal with all this. And so we won't have to go to a trial. We'll be able to get money from her. Her lawyers will tell you, there's always a chance you'll lose and stuff like that. And then yet she won't do it. And so now here they are in trial because she's been pretty determined, it looks like, to stand her ground here. Yeah.
Yeah. I think that may be part of it, but any litigator will tell you, when you bring a case, you've got to be ready to bring it to trial. You've got to act like it's going to go to trial. That's the best way to litigate a case. That's the strongest way. Ellen Sarah Lee, thanks for the super chat, says, does anyone else want to go back and tell the people who were saying 300K, I told you so? Anyone? Well, to be fair, we can blame the media for that one because that's what they were reporting. So that was a little bit confusing with that. Let me also share my screen here. Deke Slade, I see you in the chat. He shared something with it. This was a funny moment from the closing argument. Her ridiculousness right there, because I can't remember exactly what he said. Oh wait, it's muted here.
can't cause a crash when you're hit from behind.
Oh, you can't cause a crash when you're hit from behind, he says. That's right. And she's like, well, I was hit from behind. So yeah, I didn't cause a crash. Which, you know, if I'm her attorney, I'm asking her politely not to chew gum in court, and I'm asking her to try to contain her facial expressions and her gestures. But I do understand her perspective. So, yeah. Anyway, well, that was funny. Thank you for sharing that. And
so I had heard the 302, and I tried to glance at the record, and I didn't see anything about it. Like, I didn't know if they'd made a new request for admission on damages or something. And then you told me you hadn't heard it either. So, like you said, sometimes things get spun in the media that aren't there, because normally, you know, your damages amount is going to be what you ask for at trial, unless there's been something that occurs before that where you tell, you know, high-low agreement or, you know, whatever. I don't know, but obviously they didn't do that here.
Yeah. I don't know. When I first saw the $300,000 amount, it was written as though there was a cap on the damages, like some sort of a statutory cap.
Maybe for non-economic damages as a multiple of, I don't know. I didn't check that. That's for sure.
Yeah. I mean, so maybe the 3.27 million is arrived. Maybe that's why they needed the multiple times 33. Because they had to get there somehow after the economic damages cap.
Well, and if there were a cap, you know, you can ask for whatever you want, and then the judge would reduce it later, kind of like the whole Alex Jones thing. So, but I'm not aware of a cap. I'm just saying maybe maybe somebody thought there was one, but I don't have any idea where the 300,000 came from.
Hey, Alita, since I just took a 5-minute stretch, I just want to ask if you wanted a break, and I'll hold down the fort for you for 5 minutes if you wanted to take a little stretch break.
Thank you. I appreciate that. Let me get the super chat first, and then I'll pull up on the screen in case they start when I step away. I'll just step away for like a minute. Bloody Vanessa, thanks so much for the super chat. Says, does anyone have a much better respect for Elaine and Rottenborn after this closing? I thought Rottenborn was great during his trial. He had a losing case, but I thought that he was a very capable attorney. I as far as Elaine is concerned, you know, she did get a lot of ridicule. We were very frustrated with her lawyering. Her closing, though, felt a bit like Sykes' closing, in my opinion. So I don't know. That's my perspective. I don't know how you guys feel.
No, I didn't find the closings particularly effective, and the story hour didn't really do anything for me, and felt disconnected. There were points in there that were good, but they were buried in a lot of crap.
Yeah. Okay. So I'm going to step away for just a minute, and I will be back. I might have to take Indy outside real quick. So I'm going to pull up the video on the screen just in case.
Yeah, fair enough. Take a minute.
Cool. Thank you.
No problem. These trial days, when you're sitting for long periods of time, it can be a lot.
Yeah. So I'll be quick.
Cool. Yeah, so I mean, overall, I didn't really like the closing. There were some points in there that were good in terms of trying to emphasize his side of the story, like he's hit from behind, so he can't be negligent. He did suffer some breakage of his ribs that certainly suggested that someone fell on top of him rather than just simply falling over on a ski slope. I've fallen over on a ski slope before. I've never broken ribs doing so. So it's suggestive of, and it's not a double diamond slope or something. He's not skiing really fast. So it seems a little off.
Thank you. Are we ready for the jury? We are? Okay. We're ready for the jury.
That being said, of course, that presumes that Gwyneth is at fault, which I don't really think is demonstrated by the evidence as best as I can do. So I'd be ruling for Gwyneth here. Not for the least of reasons that his own story is not credible, both because it is a reconstructed story that he's had to rebuild himself in his own mind. And also he has problems with honesty just as a general proposition. So whether he's lying or not, he's not credible. And he does seem like he's attention seeking and
I think the defense
bitter.
lawyer was asking if they used all the time or not. Maybe he's trying to find out if they still have a rebuttal or not. But he had to shut up when the jury came in.
All right, thank you. Mr. Owens, you ready to proceed?
Thank you. Yes. Just to be clear, because James is going to share the time with me.
Sure.
And is the plaintiff reserve any time for rebuttal?
They reserved 10 minutes, which I granted them.
And so do they have an hour and 10 minutes? And do we have an hour and 10 minutes?
They reserved 10 minutes, so you can proceed.
So we have 1 hour.
You can take 1 hour, and if it happens to go over because you're finishing a topic or something, that's fine.
Thank you so much. Well, folks, we didn't even know each other 2 weeks ago, and here we are. Thank you. It's a beautiful thing, I think, that we resolve disputes in our country in this way, just like
well,
Lawrence
he's smart
mentioned.
because he's going to let James
plucked
get the back
and
half
really
of this and the
against
last
your
word.
will,
And James,
even
by
if
far
you
and away,
had to
the
fight
better
it. In
polish of
theory,
it.
one of these
So
bailiffs could
give
go
him
arrest
credit for
you and
that.
come and make you come here. So we don't do that with anything else. But why do we do it? Because it's such an important thing to
We're so glad you came here, so we didn't have to send the
resolve
bailiffs after you. Ha
disputes
ha
in
ha
our
ha ha.
country in a peaceful manner. So, thank you.
All right, I'm back.
I'm Miss
Did you just try to
Paltrow's,
ask for more
and
time?
I'm going to just call her Gwyneth. I'm Gwyneth's
Yeah.
lawyer. I'm her spokesman this week. So she sat there for 2 weeks and been a punching bag. We've blown through a lot of these cute little Post-it notes where she's sending me stuff. But I take it very seriously because she's comfortable in a lot of worlds I'm not comfortable in. But she is not comfortable in this world. It is not a nice thing for someone to throw a press conference and say, like King Kong, you knocked him out and walked away, skied away. That is not what happened. And the court has actually dismissed the idea, and that's one of your jury instructions, that this was a hit and run. That took no small amount of work, by the way. But that is what she was faced with. It takes a lot of courage, does it not, for her to sit there for 2 weeks and be pounded like a punching bag. What did she lose? Did she lose? Oh, that's too bad. You had to come in early and have a massage. No, this is what she lost. She was in love with Brad Falchuk. Dated for 2 years. They both had, very interesting, I think, 9-year-old sons and 11-year-old daughters. It's kind of cool. And they said, how are we going to get these guys together in a loving, fun time? They're very busy, where we can kind of all be together for a couple days and see if this will work, if we can blend our families together. We're going to make it relaxed. We're going to put a lot of planning. She put a lot of planning into that trip. And so here they are. It's a little delicate because anyone who's been through like trying to blend families, it's a delicate thing. So what happened? They got there. They're organized. First day of skiing. They have ski instructors. By the way, I thought it was cool. I don't know if you did. Her dad taught her to ski at Alta. And she has tender feelings about that. She's been tearful with me in describing those ski trips with her dad because her dad died in his 50s. In fact, it was so painful, she didn't ski for a long time after that because she would miss her dad. But when her kids were of this age, and we're talking with Brad was a big skier. We didn't get to hear from him, unfortunately, lack of time. But they were going to come, okay, let's get our kids together. So what did they lose? They lost a half day of bonding and even more because now everyone's stressed. That was the day when they bond up going up the ski lift. They bond having hot chocolate mid-afternoon. They bond relaxed, laughing around the fire.
As a dramatic loss. Oops.
They missed hot chocolate time. Hot chocolate time is key time. I mean, you know.
He's pushing it with this. He's
Why?
pushing it.
Why is this buffering? Oh no. Oh no. Okay, hang on. Let me try refreshing the screen.
Going up the ski lift.
Sorry,
They
guys.
bond having hot chocolate mid-afternoon. They bond relaxed, laughing around the fire. A deep cost to my client. I told you when we first met, I wanted to concentrate on a couple things about Lady Justice here. By the way, if I didn't make it clear, you are Lady Justice. All right.
It just mirrors the audio and
Blindfold
video.
eyes. Because she's blind? No. She's smart. But she's not going to be distracted by chaos around her. Chaos like media, chaos like sympathy. Oh, don't we all feel bad for him? I would have liked, by the way, at least a discount on the camel ride on your request for damages, but that's another issue. The idea is, okay,
Snark.
we're going to focus. We're going to focus. And we've tried, and the judge has given you all these warnings. Don't be talking to people. Don't even talk to
refresh
yourselves
one
yet
time.
because
Sorry,
we want you
guys.
focused.
It's bugging me.
Don't we all feel bad for
There
him?
we go. This is better.
I would have liked, by the way, at least a discount on the camel ride on your request for damages, but that's another issue. The idea is, okay, we're going to focus. We're going to focus. And we've tried, and the judge has given you all these warnings. Don't be talking to people. Don't even talk to yourselves yet because we want you focused. And that's Lady Justice. Now, I talked to you earlier about the scales of justice. This is a civil claim, meaning the preponderance of the evidence. The plaintiffs brought the lawsuit. That's why we're all here. His daughters say, isn't it terrible? These two daughters that he's brought here, his life is laid open. It's because of him. He hit her. He hurt her, and he wants $3 million for it.
Nice.
That's not fair. The
Nice.
easy thing for my client would have been to
He's
write
actually
a
doing a
check
pretty good
and
job
be
here.
done with it.
Nice.
But what does that tell her kids? It's cost of business. No, it's wrong. It's actually wrong that he hurt her and he wants money from her.
Mm-hmm.
And that's why we're here.
Okay, not bad.
Boom.
All right. So back to the scales here on Lady Justice. He has the burden to tilt. Okay? Tie goes to her. Now she has a $1 counterclaim. My wife said, don't waive the dollar, and I'm not waiving the dollar.
Good. Don't do that.
But a dead even tie means neither get anything. And I'll walk you through that in just a minute. But let me suggest it's not even close. Let me suggest it's like this, the evidence here versus here. And let me talk to you about that. Let me mention a couple other jury instructions. So I talked to you about no sympathy, passion, or prejudice. We don't want you making decisions on that basis. I talked to you about the burden of proof. That is theirs.
He has not waived
And
the
then
dollar bill
from
yet.
today, let me talk to you about a
We'll
few
wait for
things.
it. It's on the bingo card. Thanks for the super chat.
By the
He
way,
said he's
the
not gonna
burden of
do
proof was evident because they get the last word. Because they have to tilt the things, you may have noticed this morning they could call a witness, and after I'm done, they can speak for a few more minutes. And that's what we do to the people who have a burden of proof. Instruction 30 that you were read today. Gwyneth Paltrow did not leave the scene of the accident without giving her contact information. Press conference 4 years ago. King Kong came out of the jungle, left me unconscious, and brushed off and went away. Utterly BS, and it's been discounted. It's not even before
Say
you.
that in closing.
The judge
Say
took
in-
that away from you because it was so obviously false.
Utter BS.
31 deals with spoliation. That's the GoPro issue. Spoliation is probably a word you've never heard before. It's a legal term. But the idea is if they destroy evidence, you can assume that it was bad for them. All right, so Terry, in fact, I should say Mr. Sanderson, in fact, owned a GoPro. All right. He talked to his daughter that night.
Thanks for the super chat.
6 p.m., so about 6 hours after the collision. She got off the phone with the understanding that he had a GoPro video of the incident and typed to him, I am so glad that there's a GoPro and that you're okay. All right. No one has the GoPro, but I'm telling you this. If you find that there was a GoPro and that he said, that will not help my case, delete. If that happened, you can conclude that it was against him, that it helped us. And wouldn't it have been nice if it had been around? Do you remember when we talked 8-9 days ago? I said, you're going to hear so much stuff about damages. So much stuff. But if you find that he hit her, you can ignore it. So we heard like a week of testimony about Mr. Sanderson's brain and how he thinks. He does like to be the center of attention. He likes to be in the spotlight. His own daughter said he would be dishonest for money or notoriety. Does that make you like uncomfortable? It makes me really uncomfortable. When Dr. Gibby was up there, he said, oh, he has a great relationship with his daughters. It's like, who? He says, two daughters. There are 3 daughters. You can't just pretend this stuff away. 3 daughters. Ooh. It's pretty important, isn't it, for a witness to know that he's
I only like 2 of them, though.
Not
2 out of 3 isn't bad.
In the least good relationship.
This is the best this dude's done all trial that I've seen.
He was abusive.
He was just
and a lot of other adjectives that I'm not actually will defer to you to remember. So Miss Paltrow is asking for her dollar, but it's not about the dollar. It's not about.
It's about the.
I mean, think of what time is we're sitting here for 2 weeks. It's not about the money. It's about kind of ruining a very delicate time in a relationship where they're trying to get their kids together. Ever. That's what Terry Sanderson caused her. Pre-existing conditions. Oh my gosh. How do we not talk about what was going on right before and what versus what's happened after? He's 76. I mean, my parents, I'm not being flippant. They were dead by then. They certainly weren't taking 10 trips around the world. So we have to look at that. Those are the jury instructions. I do want to tell you the special verdict form that was appropriate. Can you bring that up? Lawrence walked you through it, and I don't think there's any harm in me telling you what I want. Is there? No. I'm going to ask you to fill this out. This is what you go to the delivery when you deliberate. These 3 pages. The last page really is nothing. So it's essentially 9 questions. And I want to show you how I want you to fill it out. I'm not trying to be subtle.
A giant X on the no.
So was Gwyneth Paltrow at fault? No. If you answer no, go to question 3. So next page. Then you have to, that means Terry Sanderson's not going to take any money away from today. If you write no, so no on 1, you are done kind of in terms of his claim. Then you go to paragraph 3, which is our claim. Was Terry Sanderson at fault? Yes. We want you to say yes. Was his fault a cause of her harm? Again, we're asserting $1, but it was so much more. It made everyone nervous all afternoon. Was Terry Sanderson's fault a cause? Yes. And then, James, if you answer, regardless of your answer, go to 5. if your answers to questions, so this is like a tax form where you have to like read it 4 times, sorry. If your answers to questions 1 and 3 are both no, one was, is Gwyneth at fault, you should not proceed any further. And you go to the end and sign it. And this is because you're trying to figure out, was she at fault? Yes or no. Was he at fault? Yes or no. Did it cause any damage? You can actually find today that neither were at fault. Skiing is an interesting thing.
Inherent risk?
We strap sticks on our legs at the top of a very high hill and go down for fun. It's breathtaking. I've done it. I love it. But it has inherent risks. So the back of every ski pass you've ever seen.
Judge, objection. You've excluded this inherent risk of skiing.
We referenced this, Your Honor. You said I could argue.
It applies to resorts and not to people.
No, the argument is improper, so overruled.
So inherent risks, you've seen it on the back of every ski pass. And even your own common sense says, hey, if I don't go down this hill right, I could actually kill myself. So skiing is different. It's even different than driving. I mean, we don't drive cars down hills, right? Down the icy hills. But we do ski down icy hills.
I've driven a car down a
The
hill.
Deer Valley guy would say, we're never icy at Deer Valley. But nevertheless, it's kind of a dangerous thing. And so you can actually say, no, don't get me wrong. I want Gwyneth paid for the hardship Mr. Sanderson caused her. He hit her, he hurt her, and he's not entitled to sue her. I'm sorry, he's entitled to be here today, but he's not entitled to be rewarded for hurting her. That's not how this country works.
He's not entitled to be
All right,
rewarded for
James,
hurting her.
let's see.
Just keep hammering that
Then
away.
if we go if your answers to 1 and 3 are both no, you should not proceed further. So if you found not at fault, you're done. You go to the end and your 4-person signs it. But if you keep going, otherwise continue to 6, James. I couldn't do this without James if you can't tell. What % of the fault to you assigned to Gwyneth Paltrow? So then you have to figure out a percentage. It's possible that both people are at fault. And how this works is you take 100% pie and you find out, okay, Gwyneth's 10% at fault, Terry's 90% at fault. So a lot of things aren't just so obvious, like gray and white, black and white. We would, obviously, if you get this far, we'd want you to put 0 apportionment to her, Terry, 100%. I guess you could find that Gwyneth's entitled to 75 cents and not $1, believe it or not. Okay, then we keep going.
I guess that's possible. I guess $1 isn't a minimum.
James, whatever you can find here. What amount compensates Terry Sanders? And we just want you to go to 9 and give us our $1. There was a little issue raised about whether her attorney's fees could be added to that. The judge has said, I'm going to deal with that. That's not in front of you. All right. So your topic is this $1. Believability of witnesses. This was one of your earlier instructions. How do I figure out who's telling the truth here? And I'm going to put Craig Ramon. First of all, Terry doesn't remember much. There was one just blatant misstatement in their closing, which was Terry could talk to a wall for 2 hours and have a pretty good conversation. That was before the incident. That was misrepresented as being after the incident. Every time that issue came up, I said, before? Yes, before. All right.
I don't know how that helps.
Let's go to talking about evaluating witnesses. I'm telling you, if we were in law school and we had a class about eyewitness, how an claimed eyewitness actually sees what he thinks he sees, Craig Ramon would be the definition of a bad witness. And I'm going to give you some objective statements about that. He's at the end of the court. He says, I'm skiing, and there at the end, I'm colorblind. I have imperfect vision. I don't know what they're wearing. I'm looking at other things. I'm not focused on them. He said he hears and turns. Well, guess what? Eric Christensen, the ski instructor, who they accused of a cover-up, which was dismissed, heard and turned. They're the same. They heard and turned. Craig describes himself as an eyewitness. Eric said, I didn't see the collision. I just heard and turned. They saw the same things. Interestingly, Eric came right over, and now's appropriate time to watch our little fun video. I don't know if you like these animations, but we kind of put them together so that you guys can kind of envision all this information coming at you. So Eric Christensen, did you like the guy? The guy is like, oh my gosh, I love this guy. He's been doing it for 40 years. He teaches art on the side. He's been a lifelong resident. He's married to someone whose whole life is skiing. And he is not a liar. He is not someone who covers up. He is not someone who falsifies reports. All of those allegations were thrown out. So we're not dealing with Deer Valley. Interestingly, it's not just Ramon versus Christensen, because all the Deer Valley people, do you remember the cool Whitney who took the toboggan woman? I mean, she's an amazing witness. She's up there, I'm assessing things all left and right, nothing, but that's a little different. So we're going to play this, and I think Moses is in orange. And there's Terry. So Eric Christensen says he sees Terry out of the corner of his eye. Well, he looks and sees, because he's in charge of sort of protecting these kids. So he says he's always looking up the mountain. And then he hears and turns. And then the next view, the next one. By the way, no one but Craig has the guy spread eagle with his head down the hill. There's no facial damage to his face. His skis stayed on. You've heard from these structural bioengineering people. If he came and got hit like Craig described, his skis would have popped right off. You don't keep your skis when you get blown. Sanderson says he was airborne, that he was flying. First of all, I'm not going to get into the weight.
That's impossible.
Have him sit on scales, but twice, by the way, not once, twice. Mr. Sanderson said, I'm 3 inches shorter and 15 pounds lighter. We're not talking about today. We're talking about then. Then he was 3 inches. I don't know if he shrunk 3 inches since then, but he described himself as pudgy. He's coming downhill at a faster pace. I mean, anyway, the structural engineering people, which is kind of interesting, not structural, biomedical engineering people. I don't know if you got bored in that part or was interested, but I'm telling you, the science does not work for Craig's theory. Okay, so we're going to play this. Mr. Christensen, am I in your way, Judge?
No.
There's Moses, Carrie Oaks, Apple. It's a little hard to absorb, but here's Gwyneth, and there's Sanderson. Now, let me tell you what Sanderson said, and he said it just at the end of the day yesterday. I said, tell me what's going on right before the incident. He said there was a lady on his left that was kind of tentative. So I deliberately, I think I said, passing on the right. Pretty sure I did. So there's the woman he describes in green. And he's trying to he's watching her. He is blind in his right eye. He said, I use that term loosely. He's an optometrist, for heaven's sakes.
Good point.
He's blind in that eye from a stroke.
Making that point about the blindness. He's an optometrist.
His retirement.
He should be accurate.
Okay, so he's watching.
How he describes it.
And imagine this. I'm blind in my right eye, and I'm really mindful of not hitting this woman to the left of me. And then he said, nobody could have passed on my left except the gal I just passed. So that gal I was real conscious of because I still worried about her. And so as I went past her, I went inches per second past her. I just remember it took forever for me to get past her, and there were skis. And then that's when the collision happened. All right, so maybe run it one last time, James. So he's looking to his left with a blind right eye to make sure he doesn't hit the woman. He's looking to his left, and what happens? Gwyneth described, and praise to the judge for not letting this be reenacted with Gwyneth and being assaulted in front of us all. She is skiing, and two skis come in between her, and this is not a big hill. By the way, I mean, these are kind of photographs. This isn't just claymation here. And comes in, and she's like, what is happening? They're not going that fast, but Terry's going faster because his skis are coming in between her. It's because he's looking with his one, by the way, he has like half an eye because he has a cataract in the left eye, hearing's shot, and he says, I'm getting too old. I can't do everything I can. Well,
he basically has
I stopped playing church basketball after my knee injury. I'm like, I love it, but I can't do it anymore. Okay, so sometimes we have to give things up, especially when we're 76 years old. I'm sorry. That's life. But he comes in between her legs. She's going, what is going on here? It's not like a ski collision hit, you're out. And he's grunting, his body's against her. She's thinking, am I being assaulted? Because this isn't really a ski collision. And then they go for a little while. She said spooning. And whatever the next next animation would be, James. And then they go to their right. Now, I don't know, you've heard the ribs issue. By the way, if you're 76 with osteoporosis, you can break your ribs.
That's another
You
point.
may see in this
Another
records
point.
in your documents, these weren't dramatic breaks. Two were not even dislocated. What's the right word? Displaced. Thank you. Two were not displaced, and two were just very minor displaced. Did they hurt? I'm sure they hurt them. I'm sure they did. All right, so she is on top. Eric Christensen said she was on top, and their skis are intertwined. And what is she doing? She's like, okay, I see I'm not being assaulted. And he may well have hit his head. He does have a helmet on. So does she, by the way. Craig Ramon is like, no helmet. He tried to change his testimony on the stand, but I had questioned him like 5 years earlier.
That's a good point.
No, she didn't have, I was really
Hammering
surprised.
on his
No helmet,
inconsistencies.
no mask. Give me a break. For anonymity purposes as well as safety, this is a person skiing with her kids. She's pretty focused on safety. Let me just tell you that. All right. So what's the first thing does? Eric Christensen, is this the last one? Is this the last of the
There were only
animations?
3 admitted, Judge.
There were,
Only 3 were admitted.
I think there were 5.
3 full ones.
3.
Whatever you can take us to next.
Well, but you've already shown 3.
There were 3 videos that were
Eric.
that were entered in their total, and then there were 2 only partial. Is that right?
Correct. Yes.
Okay.
So whatever you can give
Two
me.
partials that didn't show the actual impact.
Only Craig has their heads downhill. Moses, who you'd love him if he's a cute little 16-year-old now. But we only got to hear him. He skis over because he doesn't hear anything, but his instructor comes over. He comes over and he sees his mom on the ground. Now downhill because she's gotten away from this guy. Okay, I'm safe. The idea of an assault just entered her mind, she said, for a couple seconds because she's going, what's going on? This is the overhead view and run it as you can. Here's Miss Paltrow. Apple, Moses. Here's Miss Paltrow. Here's the beginning skier woman. Here's Sanderson. And she's making these small turns on the right. He's making big turns. He's a lot faster. He's a lot more advanced skier, I should say. All right. Here's Christensen. You remember we placed him.
Thank goodness.
Carrie Oakes went on ahead with
now.
Apple. Apple told
In the
me
beginning, he was
she heard
calling
a
him
commotion, but
Christiansen.
she was hangry for French fries, and she just wanted to get down the hill. Moses is here. And so there we go. Okay, any other animations?
I think he's made the point with the animation.
Uphill.
Don't lose your momentum, bro.
He doesn't. Yeah, that's what I'm thinking
Paltrow in
too.
black.
It's starting to slow him down.
Sanderson. Beginning skier in green. Woman. Watch Sanderson. And then we're done. So it's probably that third one, that two back, that's probably the most powerful of them in terms of showing you the layout. All right, how am I doing on time, folks? I want to leave James 10 or 15 minutes.
30 minutes so far.
Thanks. So I'm gonna 10 after. Thanks, Judge.
Well, it seems longer.
They were gonna, yeah. I thought they were gonna be like, you have
After
5
they've
minutes left.
separated, Brad Falchuk comes up, she skis down, but there's then this period of time. So here's Eric Christensen. Eric Christensen said, I came over to find out what had happened. They say he came over to bully him. Deer Valley employees who bully their guests get fired. He's been there 40 years. You could see if his grandfatherly demeanor makes sense under Craig Ramon's story. It doesn't. It doesn't. Eric comes over and he says, first thing I'm doing, I'm taking off skis. Remember, under all stories, no skis came off. That tells you something about the manner of the collision, doesn't it? It wasn't like Ramon describes, flat out straight. By the way, Ramon, oh my gosh, he says he's out cold for 2 or more minutes. Do you know what did you do about it? Nothing. Nothing. Could you imagine looking at an unconscious person, splayed out, head down,
snow,
skis on, for over 2 minutes? Could you imagine? I'm like, did you call 911? Did you check for breathing? No. Yeah. None of that.
Yeah, I would have at least checked for breathing.
Good grief. Give me a break. All right. Eric Christensen comes over and says, okay, let's take skis off. Remember, he had some personal knowledge because he knew kind of where Gwyneth was, and he kind of knew where Eric Christensen was. He knew where they were, downhill versus uphill, and he knew their skill level. He could tell, he said he could tell because Mr. Sanderson was an advanced skier because he didn't slide. I didn't really know this, but if you do you skiers will maybe know. If you can work your edges and you don't slide, apparently that means you're a more advanced skier. Okay, so he comes over, he's trying to figure out what's going on, but he actually knows some things. Gwyneth is pissed off. If you hit someone, do you yell at the person you just hit?
Ugh.
No.
I mean,
The
some people
hittee,
do.
and
Poor
I've been
assholes.
hit skiing, is usually the unhappy one. But she recognizes these things happen until he says, "Did you hit me?" And she's mad because not only has he hurt her and hit her, but now he's saying, "No, I don't think, I think you caused this." And then she's like, "Are you kidding me? You just ran in my effing back." And Moses heard it. Moses heard it. All right. So then Christensen, who I think is just a fabulous witness. I think everything he said is just utterly true. It's consistent with everything. He took off skis. I said, was Sanderson ever out cold? No. If he was, it would have been like that. Gwyneth, was he out cold for 2 minutes? No, he wasn't out cold at all. Don't you think people would be going like crazy if there was a man splayed out on Deer Valley, head down, out cold for minutes? That's not a believable story. Eric Christensen now is engaging people. Gwyneth's mad, but she's okay in the sense that she doesn't need help. She can still ski, but she said her knee, which she'd already had surgery on, hurt, and she has sustained a blow. I mean, I don't know if you've ever been hit, even if you're in a football game and you're all padded up. She had sustained a blow. She was upset. And then this idea of him not sort of, she says, you just did this. And then what did he say? "I'm sorry." Does the person who got hit say they're sorry? No. The hitter says, "I'm sorry." And he said it. "I'm sorry. I'm sorry."
I mean, there are
Okay,
other
now
reasons
she's
why I'd say
okay.
I'm sorry.
Okay. He's not
Jury's gonna be
denying
aware of that.
the stupid thing he just did. But okay, now we got to sit around and kind of we'll sort things out. Then Christensen goes to Sanderson. Tell me what you want to say. And he said, "She appeared right in front of me." That's what he said in his report. She appeared right in front of me. That's consistent with Gwyneth being mad and saying, "You just skied into my effing back." And it's consistent with Christensen seeing kind of what was going on. He was the uphill skier. He knew that. And there you go. That's if everything's consistent. Now, if he'd said, "I didn't do it, she hit me," okay, whoa. Now we got to investigate. And then you recall, so okay, it's clear who did what. Christensen says to Ramon, "Your buddy just took out Gwyneth Paltrow." I think this was just after she skied away. And what did Ramon say? "Did you correct him?" No. That's the time to say, "No, I saw it, and she hit him." That was the time. Ramon didn't say a word. He just sat there. He's not helping his unconscious friend, and he's not denying, under his story, what the ski Deer Valley representative has just determined. Your buddy took out her. All right. So that's the time to do it, not later. Remember, one of the things I said in opening is rely on the evidence before there's thoughts of lawsuits, because then you can kind of rely. People aren't thinking, okay, 10 minutes later, "Oh my gosh, Gwyneth Paltrow. Wow, that's something else. We were just in a collision with Gwyneth Paltrow."
He can't say Paltrow.
Now people are thinking,
Yeah.
okay, wow, I'm famous. They're not thinking that yet. In real time, he's saying, I'm sorry. And then, are you okay? Everyone always asks this question, are you okay? And he said, I'm okay. Now he tried to change it a little bit and we had to go to his transcript, but he agreed. He said, I'm okay. And then ski patrollers come by. So, I mean, there would have to be a pretty vast conspiracy against Deer Valley for this to be a cover-up. And remember, they were already dismissed. Ski patrollers come by. They see some stuff going on. Everyone all right over there? Eric Christensen did not answer that question. Because this is a contact now between injured skier and ski patrol. Eric's a ski instructor. And so what happened, Eric? He said they talked. So this isn't, we're not in there like trying to bully someone. Craig spoke to Terry privately. He said, Eric said, I couldn't hear it. And then, which obviously Terry at some point said he remembers Terry saying, are you okay? Are you okay? So there's a connection. And then what did they say? We're okay. And the ski patrollers left. All right, so that's what's happening in real time. Now we go to the paperwork. Why don't we fill out a big deal, get everyone's statements and everything? Because if this happens all the time on ski resorts, if everyone's okay, I mean, we don't have a scene about it. But they go down a little longer. They now know that Miss Paltrow was part of the collision.
Oh, there he's at it. Paltrow.
And then Terry, and you can believe him.
It's like he heard you.
Believe him. But they now know. I'm not skiing too well. I don't feel that well. All right. Fair enough. It did come 10 minutes after they found out who they had been involved with. All right, bring in Whitney. Whitney's an awesome, geez, I thought she was a fabulous witness. She pulls up and she's all business. Like, okay, I'm going to assess for unconsciousness. No. What happened? She says, what happened to Terry? He didn't say, I got hit. He says, I don't remember. I don't know. Did Craig immediately go in on that? I'll have to defer to her report. That was a legitimate question of mine. I'm trying to remember. James, when are you up?
Nice. He just ran out of gas.
Are you up in 5?
Yeah.
I can do that.
Dude, if you're done, be done.
That gives you 5 or 10.
Yeah. You don't have to fill that space if it's not going to be effective. Because you also don't want
Thanks.
to.
I'm going to be done in 5 minutes, folks. Okay.
I'm going to fill this time with something.
Whitney's delightful,
We'll come up
loads them up, takes them down, says, hey, before, I want you to remember 5 things. And this isn't like man, woman, dog. This is like, I got my degree in Michigan. I was Deer Valley Grand Slalom person, whatever. All these really detailed. I like horses, my horse's name, all this stuff. Remember it. Terry says, I remember, I knew I was now having a cognition memory test performed upon me. He goes down and she then says, do you remember? And oh my gosh, he remembered. In fact, he remembered so well, he decided this is a good opportunity for me to text and post a picture of Whitney smiling and just talk about how wonderful she is. Whitney, meanwhile, is sitting there trying to figure out, okay, are any problems here? Are you seeing any signs of concussion? No, I'm not. Do you remember Dr. Edgley? I don't know if you thought that was cool, that a guy who heads up the U's acquired brain injury clinic has had an acquired brain injury. I thought it was kind of cool. Anyway, he goes, what do you look at? You look at period of unconsciousness. We have Craig versus all these people saying he wasn't unconscious. they even imply like Christensen didn't even care about us. He's yelling at us, he's bullying us, and then he's abandoning us on the conscious, drooling on the mountain. Give me a break. Is that what you know Deer Valley to be? So then, okay, he checks out at the main clinic. Then he's down to the Instacare. What is that Instacare PA looking? He's looking for, no, I don't see any signs of symptoms of unconsciousness or concussion. Because they're looking at memories, they're looking at periods of unconsciousness, and they're looking at, what was the third? Do you recall? Memory.
Ataxia.
That means inability to speech. I don't think that is what they were looking for. In any
He's
case,
asking the other
they're looking
side.
for any signs and the symptoms of
This is the weirdest trial ever.
concussion. No. Now that doesn't
Hey,
mean
well,
he didn't
Delta,
have
can
a
you help me
concussion.
out?
But it does mean this isn't anything severe at all. I mean,
He should've
okay,
just
next
left
day
that
goes to the
5 minutes on the
VA.
floor.
These are the people
Would've
he
been
knows.
better. He's clearly like
CT,
just
guess what?
trying to stop it.
They're like all the same abnormalities as you
space.
had in your brain before. The problem is, and by the way, he then goes for 3 neuro assessments, and they all say normal to above normal. In some
Just
ways,
stretching now.
really above normal. So no assessments. Those are all his
Started off
treating
so strong.
providers. Why would we have our experts go do neuro assessments when 3 separate treating providers that he knows and trusts and that no one's paying say above normal? Why would we do that? But the problem is he then goes to Gibby and Fong and he just self-reports. Everything was normal beforehand. Wrong. And now everything's terrible. Wrong. Doesn't tell him he's flying all over the world.
We need the
That he's
Oscars wrapped up
biking,
so
that
they
he's
start
the
playing.
poster boy for fitness at age 75. He's posting every darn thing.
Not sure what happened there.
I'm sorry. I don't know how. I left you hanging.
Making sure I'm awake.
Scale. The sword.
Sorry.
The sword.
I don't know. My computer just
We
like,
want you to use
kicked
the
me
sword.
out.
Sounds harsh because we're not beheading anyone. The sword is to defend a meritless claim.
He's
This
back on the
is a
statue, I guess.
meritless claim.
Yeah.
You don't throw a $3 million bombshell in the courtroom, call her King Kong, and walk away. You shouldn't reward that. And Gwyneth, who could have just paid it out, paid the ransom. No, I'm not doing that. I'm not going to have someone hurt me.
Could have paid the
And then
ransom. That's a good way to put it.
Ask me for a lot of money. I'm not going to do it. I'm going to sit here. I said, you're going to have to sit here for 2 weeks in Park City. And you can't even look at your phone. And she said, I'm going to do it. I'm not paying it. We asked you for the $1, not because she had to go in and get an early massage, but it screwed up a very carefully planned, important time in her life. Thank heavens the family melded well together. But we want our $1. Thank you for your time.
We want our $1.
Judge, can we approach briefly?
Oh.
So the judge did tell the defense that if they went over an hour by a few minutes, that was fine, since he gave the other side an extra 10 minutes for rebuttal.
Mm-hmm.
That was the discussion there.
Okay.
I think you might have been out of the room. I'm not sure when he said that.
I just came in when there was some kind of a discussion about an extra 10 minutes, which I
Yeah.
thought that he was maybe trying to reclaim the 10 minutes that was supposed to go to the other, because I thought there were supposed to be three rebuttal witnesses today. So they were anticipating 5 minutes for each of those. So I thought he was trying to reclaim the 10 minutes from the other two witnesses that never appeared?
I think it was just for the closing. He's like, will you let him go for an
Egan, you may
hour plus
proceed.
10-minute rebuttal? So
Thank
give
you.
us an
All
hour and 10
right.
minutes. And the judge is like, I won't be
Are
too
you guys
strict, bro.
hearing this?
Yeah.
Okay.
Okay. Yeah, that makes sense. Just because that's an interesting point. I mean,
Okay, so
Yeah.
it's my job to talk about Mr. Sanderson's claim that he's not living the life that he used to live, and
Oh,
it's
here
Ms.
it goes.
Paltrow's fault. Hope I can be helpful to you as we walk through some of this. I wanted to start by just pointing to this document. This, you remember, Whitney Smith was the ski patroller that arrived and wrote this report that day. A little bit later, Mr. Owens could not recall an important fact. This is the witness section at the bottom is not filled out. Mr. Ramon did not come forward and say, this is what happened. Let me tell you about it. Whitney Smith would have written that in there if he did. She also pointed to, we also pointed to the fact that she did not write an X at that concussion and head boxes where she could have noted possible injury. She's, to use one of Mr. Sykes' phrases, she has no dog in this fight. She would have put
Nice.
X's there if she was concerned about that. She didn't.
use Mr. Sykes' phrase.
You also heard her talk about mild disorientation in her report, and that shows up here. And I think you've seen that the point. Gosh, I'm sorry. This thing can be finicky. You've seen it. I'll just move forward for the sake of time. There's those mild disorientation notes, right? And she explained that she didn't see that as indication of concussion. She just saw it as being kind of rattled from a ski collision. And that's relevant to damages because Mr. Sanderson is claiming that he had a concussion, and all of the symptoms that have come from the collision relate back to that concussion. I think there's considerable doubt that he even had one. He may have, and you could certainly find that, but you might find that he didn't have a concussion. I think, though, that I want to kind of frame this with a certain theme. Maybe you've seen a pattern over the course of these last couple weeks, or the last 2 weeks. On the one hand, you have real events, and then on the other hand, you have embellishments. On the one hand, you have objective tests, and on the other hand, you have subjective reports. On the one hand, you have what happened in the past, and then on the other hand, you have perception of what happened in the past. The realities of life, sometimes difficult realities, and on the other hand, you have anxious exaggerations. I think Mr. Ramon took the reality of the collision and spun it into an attention-grabbing story for friends about dramatic injuries and celebrity. He was talking a lot about that. Ms. Smith overheard it as she was caring for Mr. Sanderson. And then there were those comments that we found in the middle of trial where he talked about it. And you heard him explain that he'd been talking about it with friends. He knew a lot about Ms. Paltrow. He's very interested in this. I think he took that reality of the collision and embellished that what happened, what he saw. And Mr. Sanderson's taken the reality of his aging body and he's turned it into a profound injustice perpetrated by Ms. Paltrow. It isn't that. The facts show that his health challenges started long before the collision, and they've progressed in a predictable way. I think you heard Dr. Hesh yesterday say, if you look at his medical records, you look through the history, you take the collision out of that timeline, it reads coherently. The prior stuff would predict the next stuff. You don't need the collision to explain what happens afterwards. It's not to say that he didn't have injuries in the collision. Nobody disputes the broken ribs. And those were certainly painful. They did heal. And then the concussion, if he had one, was very brief, as you heard multiple experts say yesterday, and had very mild symptoms that may have even resolved within that day. So even if you find that Ms. Paltrow caused the accident, I think you only have sufficient evidence to find damages that relate to those broken ribs and the concussion that resolved very quickly. The slow degeneration of bodies is hard to accept, and mental health challenges are hard to face. It's obviously human. to want a concrete explanation for these
Bringing in the
difficulties.
empathy.
But
That's
as
good.
the court has instructed you, Mr. Sanderson should not receive the money he asked for if you find that his perceptions do not match reality. The law requires that he convince you that more likely than not, he has suffered real harm, that Ms. Paltrow is and that Ms. Paltrow is the cause of that harm, and he has not done that. Through the course of the trial, you've seen that Mr. Sanderson does have genuine problems, and I don't want to minimize that. Experts from both sides have talked about his anxiety and depression and the trouble he's had with family and relationships before and after the accident. We've seen brain scans. Dr. Black came in here, and he was the only expert, I believe, that took you through all of them and explained how they, were back in 2009, look very similar to what you've seen going forward. They're connected to abnormalities related to aging and other conditions that might explain his problems. But Mr. Sanderson's argued that you should believe his experts because they evaluated him personally. The problem, I think, with that argument is that, as you've learned these past 2 weeks, these experts didn't carefully review his medical history, and they relied heavily on his unreliable reports about it. They also want you to believe what they've been calling the before and after witnesses, the family and the daughters, the friend, and then the girlfriend. And I think that you've learned these past 2 weeks that they didn't know Mr. Sanderson's health as well as they thought they did. And he was actually, they had, I think, acknowledged that he's good at hiding some of those issues, maybe totally understandably, and reluctant to share his troubles. So you have objective facts and then subjective reports. And the law requires you to find evidence, reality, not just the perception of problems. From our experts, you've heard a consistent, compelling account that Mr. Sanderson had these problems before that the concussion occurred, potentially, again, very briefly, if at all, and that those conditions that he's experienced afterward that he attributes to Ms. Paltrow are the predictable consequence of that prior history. You heard them all yesterday. I guess you had Dr. Edgley the night before, but you heard them all, and it's a coherent, consistent story. I think you got a sense that they've read the records carefully, the objective records of treaters who have, again, no dog in this fight, just reporting what is going on for many years before and after the collision. Your Honor, I have till 25?
Yes.
Okay, 5 more minutes. I got a lot. I'm not going to get to all of it, but I'll try to get to the helpful stuff. Mr. Owens went through the various evidence about loss of consciousness and the different witnesses that have, I hope, persuaded you that Mr. Sanderson did not get knocked out for multiple minutes. But Dr. Eastfold gave you some interesting testimony yesterday. She said that the medical records after the accident are actually inconsistent with serious concussion injury. There was the cognitive assessments she pointed to that were normal. There was the balance assessment that was normal. You wouldn't expect it to be normal. And then there was the alcohol intake that actually increased, even though a concussion would reduce your tolerance for alcohol. Again, careful looking at the events in question, which I don't think you heard plaintiffs' experts do. Mr. Sanderson's perception is different, obviously. He not only thinks he was knocked out for minutes, but he said he had a profound cognitive trouble during this time with Ms. Smith, who said he was cognitively intact, could speak to him. He was writing articulate posts about her, could carry on conversation for hours. So you got careful evaluation on the one hand, and then you have extreme exaggeration on the other. And the law requires you to be careful in your evaluation. Mr. Sanderson sees the time immediately following the collision as a grim period that began a spiral, began spiraling his life out of control. I think he described the bright side before and then the dark side afterward. And I think it's important to recognize that, as we've probably told you too many times, a few weeks just prior to this collision, he was reporting some of the symptoms and the concerns he's saying connect to the collision, right? He's said he was getting old all of a sudden, he couldn't do things that he used to do. get preoccupied with paperwork and other little things. And that's difficult. And I don't mean to make light of that kind of reality that aging brings upon all of us. But it's important that at that time, there was no litigation. He's just reporting. And you heard from experts that point to that as a telltale sign of the kinds of things you would expect after the collision that he's attributing to Ms. Paltrow. Mr. Sanderson's told you that the collision forced him to be a recluse. And if we had time, I would pull up those pictures. We went through a lot of them, and I hope that wasn't overboard. You got a sense of just how much he has done since the collision, traveled more than some people have traveled in their whole lives. And I think it's that this $3 million, I don't know where the board is, $3 million claim, I think doesn't acknowledge that reality. Mr. Sanderson is better than he realizes that he is. And it's not that he doesn't have problems, it's just that he is better than he realizes he is. And it's hard for him to accept some of the decline that he's experienced. And he's, again, grabbed onto this collision as an explanation for it. You've heard from Dr. Hesh and Dr. Edgley about how litigation contributes to problems like he's had, and you heard even from his own expert, Dr. Goldstein, that he's obsessed with this case and it's not good for him, that moving on would be helpful for him. And I think that we all want resolution to this case. Mr. Sanderson's asking to be compensated for a ski injury that the evidence shows that he himself caused. And the evidence also shows that his life is not the mess he perceives it to be. Ms. Paltrow wants him off the mountain too, but she should not be responsible for the cost of that. And so we leave you with that argument. Hope that you can, of course, hope you're persuaded, and thank you for listening.
That's good ending.
Thank you, Mr.
Yeah.
Egan. Mr.
Yeah.
Sorensen?
Ending with some empathy, which was good, showing that he's like, hey, look, he's got problems. He's gone through some pain, but she's not responsible for that. That's not her fault.
Thank you for being here.
Oh, Pete, I have this. Sorry.
He's better than he thinks he is. I thought that was good too.
That was also good. He is better than he thinks he is.
We appreciate the time and attention that you've spent with us the last couple of weeks going on kind of this journey. There's been a lot of fanfare, a lot of hubbub about this. You've seen a lot of technology. Some has failed, as we've seen today, but some has worked. And through all of that, I want to remind you of jury instruction number 24. Okay, and it says, when the lawyers are giving their closing arguments, keep in mind that they are advocating their views of the case. What they say during closing arguments is not evidence. If the lawyers say anything about the evidence that conflicts with what you remember, you are to rely on your memory of the evidence. If they say anything about the law that conflicts with these instructions, you are to rely on these instructions. Now, you've heard some pretty amazing narratives, a spin on the facts, and you could probably say it cuts both ways, both sides. But I want you to remember about this case that there are two stories here. One is Gwyneth Paltrow, and you've heard her defense attorneys lay out her case. You've heard her side of the story. But there's also another side, and that is Terry Sanderson. They've done a really good job of telling you about what Craig Ramon says about how he describes this whole thing happening. And what Gwyneth Paltrow says, or what Eric Christensen says. But the two stories that are important to remember are Terry Sanderson's and Gwyneth Paltrow's. Terry remembers skiing down the mountain, hearing a scream directly behind him, and then bam, as he put it, lights out. Okay? He's knocked unconscious. He's left on the mountain figuratively, as we've talked about, trying to figure out what's going on. When he comes to, it's chaos. He doesn't really understand what's going on. On the other hand, we have Gwyneth Paltrow, who says that she's skiing along and all of a sudden she gets hit from behind. It's up to you now to weigh that evidence, to see what you remember, what you recall, not the way that the attorneys characterize the evidence, but what you see in the record. And I will tell you that what you see in the record corroborates the story of Terry Sanderson. Terry Sanderson, I just walked you through his tale of what happened, okay? His versions of facts that happened. When he's hit from behind, he has to rely on the one person, remember that, the one person that says that they saw the actual collision and saw what happened. He has to rely on that. But it doesn't mean that it's not part of his story. It means that he's relying on an eyewitness that corroborates what he said. Also, we have the meetup group post that's been talked a lot about and the comments to that post. That's contemporaneous evidence the day of that corroborates the story that these two have shared with you.
Still calling it a story. I don't
Says,
like it.
and Craig Ramon's own words says, it scared the hell out of me. It scared him. Scared what he was scared. So that might be an account that you weigh as to why he didn't step in to try to give life-saving or life-supporting measures to his friend. He's scared. He doesn't know what's happening, and the person that he's relying on to take charge of the situation comes over and starts screaming at him. It's also important to remember that Brad Falchuk, who we didn't get a chance to hear from, and Carrie Oakes both contradict in major ways.
No, they don't.
So, Your Honor,
His
he
story, his
cannot
testimony.
reference the testimony of Brad Faltrow.
He admitted, Your Honor, and that was
Just a minute.
He admitted, Your Honor, that he did not see it.
Your Honor, that testimony is not
Just a
in
minute. Just a minute. Yeah, that's true. That was a stipulated fact.
That's a stipulated fact. So
Thank you.
Oh, so he just,
Brad
but he
Falchuk
said that
did
he
not see
didn't,
it.
he didn't see the incident. That doesn't,
Yeah, it doesn't contradict
anything.
Reporting,
I didn't see it either, and I'm not
collision.
contradicting him.
But yet, right
Yeah.
afterwards, he injects himself into this chaotic event, and
Carrie Oakes also
according to
doesn't
him, takes
contradict
control. He has
Gwyneth
enough
Paltrow's
time.
version.
No,
Think
she
about
was
this
awesome
when you're
for the
weighing
defense.
believability of testimony. Okay, Eric Christensen has enough time and is all aware about the students that he's being paid to watch and to teach how to ski that are beginner students. Watch what someone's doing on the other side of the run at the same time with, as reported in the facts show, many people skiing on this run. It's a converging run that goes down to the bottom of the run where people can go and have lunch. He has the ability to pay attention to a young child who he's teaching, someone across the way, someone skiing supposedly out of control, and keep track of all this. He hears a scream and looks over and sees, as the animations that you've seen, sees him laying on the ground, or sees these two people laying on the ground. He then has enough time to be the first on the scene, supposedly, after telling Carrie Oakes, take care of the kids, watch them, because I got to go over and take care of this. And he does that all in just fractions of a second.
Well, that's all it took him to say it.
I'll leave that to you to decide. I know the way I feel about it. So this witness, who the defense has said is grandfatherly, who's this perfect witness, is not really that perfect. Again, I'll leave that for you to decide. Now, a lot's been made of what Terry Sanderson was saying or doing after the incident, right? You've heard, and I don't want your eyes to glaze over. That's why I'm not using any of the props. I'm just talking to you. But you've heard a lot about this email, right? The email Terry Sanderson sent later that night, or the first email and then the response back, okay? And I want you to remember this. The GoPro incident, or the GoPro video, I guess, we'll talk about this GoPro email, is a response from his daughter, who sat here and testified 3 weeks before she'd been in her own ski accident. She was laying there with her leg up. She was under, as I think she said, she had pain pills at the time. She was aching an injury. And there might have been kids coming in and out of her room. She didn't remember exactly why she wrote what she wrote. Nonetheless, she admits that she wrote it. And she said here in front of you that it was clearly a misunderstanding to something her dad might have said when he was on the phone with her. That's the shred of evidence.
I'm really
they want you to
struggling with the idea that they believe his story.
To try to say that Terry Sanderson
story.
did something like destroy a video of this.
He doesn't seem confident.
That's our only piece of evidence that they put on in front of you to that fact. Now, again, there are many contradictions in this tall tale and the cartoons you've been forced to watch a few times.
Yeah, you're talking about Sanderson's
and I want
case,
you to
right?
remember, okay, there was testimony that Brad Falchuk was on the mountain, but he's not in their videos. He's not in their animations. Okay? You didn't see it? But there's testimony that he was right up there close. They left him out. They left out Carrie Oakes and her testimony. We had to read it in because she also contradicts the positions of the bodies.
No, she doesn't.
After the incident.
She doesn't contradict anything.
So they've done a really good job of trying to razzle dazzle and trying to get you to look at a lot of other things that are not important. Because we told you in the very beginning, when Lawrence Buehler stood up here, you'd hear a lot of so what.
Objection. If you're going
That's
to say
what
razzle
they're saying
dazzle, you have to
about
say
Terry
it like in Chicago.
Sanderson's injuries.
Yeah,
So
he didn't
what?
even do jazz hands.
He was injured before.
I know. Almost.
His injuries
He
carried
almost
through.
got there.
So what? So sorry he's left on the mountain. We'd like him off. So what? That's what you're hearing. Now, we have shown facts that are corroborated by his medical records that show that from the day after this incident happened, there was a very serious decline. The people that knew him best testify under oath in front of all of us as to the changes that they experienced with Terry. His closest family members have seen those relationships affected. Terry's seen it affected. Again, I want you to weigh this evidence in the way that only you can. And I think that you can do it. I've seen all of you be very attentive. I've seen all you pay attention, and we appreciate that because this is a very real situation for two people. The two stories that are at play in this.
He needs a donut goatee to be Steven Seagal.
I also want you to remember, there's been a lot of talk about what Jenny Sanderson said, what Jenny Sanderson reports. But she's the one that went on one of those international trips with him. So it can't be too strained of a relationship. You're not getting the full picture when you have excerpts taken out of context from a deposition that are read to you. You're not. He has 3 daughters. They all love him. And they all said that. Unfortunately, we didn't get the chance to hear some of the positives from Jenny. But their relationship is strong. She loves her dad. And he loves her. But she even said she's seen changes. Now, yesterday you heard Terry Sanderson say it's a hard thing to bring a lawsuit against the celebrity. Said they destroy your life. And they turned around and said, it's your fault. It's your fault that this happened.
Your Honor, I object and would like a little conference unless you want me to state my objection right in here.
I think just overruled, and you can make a record later, but let's let him finish.
Thank you.
I don't want her lumped in with
Terry
other
Sanderson.
celebrities.
Thank you, Judge. Thanks. They point the finger at Terry Sanderson saying, it's your fault. You did this. You brought this on yourself.
Her eyes, her look.
Terry Sanderson believes in
She's
justice.
hating all
just
of
like you've
this.
seen
She just wants
right
to go
here.
home.
It's been waved all over. And he wants the weighing of the scales the same way that Miss Paltrow does. But Terry Sanderson believes, and I think we've shown you, that on those scales, someone has facts that are weighing, and someone has a lot of fanfare that when you really pry it, it's a so what. It's nothing. So I charge you. We thank you again.
We're not
for
thinking
your
of the
time.
same
Hearing
party
the
that you are,
evidence,
dude.
Listening to all of us, listening to the coughing, listening to the objections, listening to this, sitting through the sidebars. We thank you. But now it's you. It's on you. We invite you now to weigh the evidence, and we empower you and trust that you will weigh this evidence the way you've heard it properly and find on behalf of Terry Sanderson. Thank you.
Yeah, they just
Thank you,
don't
Mr.
seem
Sorensen.
confident in their case.
In a civil case, only 8 jurors are allowed to deliberate and reach a verdict. Because this trial was scheduled to last over this 2-week period, and because jurors may need to be excused because of an emergency or other extraordinary circumstances, 2 alternate jurors were selected in this case. Prior to going back and deliberating, the court is required to excuse the alternate jurors. Some jurors are relieved when they are excused prior to deliberations, but most are disappointed and even frustrated that they've invested their time and energy in the trial, but are not going to be able to deliberate. Those of you who are excused, those 2, thank you for your service on the jury. Remember that you're actually not being released as a juror until the verdict comes in, because there is an outside chance that one of the 8 during deliberations may be called away for an emergency. And so the 2 of you that are allowed to leave, you may be called back to finish the deliberations and to vote on the verdict form with the others. So please do not discuss the case with anyone. Please do not read anything about the case. Just keep the existing restrictions in place until further notice by the court, which will be after the verdict is rendered. Please leave your cell phone number with the bailiffs so that they can notify you when the verdict has come in and even give you the results if you'd like. Again, we appreciate your time and attention on this case. So I've got in here all of your names, and I'm just going to look the other way and pick 2 out.
I hope he's not going to read.
Or your juror numbers,
I assume he's not going to read the names.
I think he said he just used a number.
Okay.
And so the 2 that are excused are number 15.
Okay.
And number 24.
I would be bummed to be one of those people. You're like, I sat through all of this. I got
Those
invested
of you
in
who
it.
are not being excused
Now I
right
can't
now,
voice
you've
my
been given
opinion
all of
and
the
have an
evidence
impact.
and instructions on the law regarding this case. Before you retire to deliberate, I need to give you a few final instructions. First, about questions. As you deliberate, you may be tempted to seek more information. If you do have questions, please write a note and give it to the bailiff, and I will review that note and the question that you have that pertain to the case, and I'll review it with the lawyers and decide on how to answer your question if it's appropriate. However, it's quite possible, and in fact, it's probable that we will not be able to answer your question. You should understand that no further evidence can be provided to you, and the instructions given to you contain the law which you need to reach a verdict based on the evidence presented to you. What to take into the jury room? Let me first say that you cannot take your cell phone and you can't have any outside contact during deliberations. So the bailiffs will give you some time before you begin deliberations to text or call anyone and let them know, hey, I'm about to go on be blacked out here while we're deliberating. And then they'll take all of your cell phones and they'll keep them in a safe place back by your deliberation room. You may take the following things in there with you: your notes that you took, the jury instructions and any notes you took on those jury instructions, all of the exhibits admitted into evidence. They are being assembled. The lawyers will agree that, yes, we do have this is the correct exhibits with the clerk, and then they'll be brought back to you in a little bit. You're also the same with the verdict form. I have the original verdict form. It says original on top. This is the one that will be filled out, and the bailiff will bring this back to you as well. When you get to the jury room, please do the following before beginning your deliberations. Read over the instruction on selecting a foreperson and select a foreperson, and then you may begin. At this time, I'd like the clerk to administer the oath to the bailiffs.
Okay.
Interesting.
Do you swear that you will take charge of this jury and take them to some private and convenient place where they may deliberate upon their verdict, allowing no one to speak to them, nor to do so yourself unless so ordered by the court, and to return them to the court when they have reached a verdict or when so ordered? So help you God. Thank you.
You may now take the jury back. Thank you.
Okay. Well, this has been a trial. Oh We'll see. We'll see what happens. According to the poll, the results of the poll, it's in the chat. A bunch of chats have come in since then. So I took a screenshot. So 62% of the chat thinks that they'll reach a verdict by the end of today.
Thank you, counsel.
Wow.
Mr.
25%
Owens, did you
tomorrow
need
by
to make
lunch,
a record on anything on that
10% by
last
the end of the day tomorrow,
projection?
2% next week.
Yes, thanks. There was just a
come on,
reference.
dude.
It's hard to sue a celebrity. I thought that was an unfair statement given
You don't need a record for that.
it's this
Yeah.
person.
For that. Come on.
This is a person here, not a celebrity. And I thought it was unfair to sort of slime her with Hollywood.
And the court anticipated that and noted, what I was thinking about was the fact that the plaintiff basically said the same thing on the stand, and I think he was just repeating that. So as far as, well, are there any exceptions that need to be taken on the record otherwise? Okay. I wonder if there's been a motion filed by some members of the press concerning how to handle the reading of the verdict. Mr. Raymond, are you in the courtroom? Mr. Hunt, is that right? Why don't you come up and present your motion?
Was he some third-party
If you could
media
first,
intervener?
identify yourself, your bar number, and then
I
who
think Deer
it is you're
Valley,
representing.
maybe. This is interesting.
Good afternoon, Your Honor. Jeff Hunt. My bar number is 5855.
That's interesting. I've never had to say my
I
bar
represent
number in
Court
court.
TV, ABC News, CNN,
Oh,
Daily Mail, the Associated Press, and NBC News.
whoa.
Dang, bro. What's up?
I'm ready to hear your motion.
We did file a motion, Your Honor, to modify the court's electronic media coverage order and decorum order, which previously through the trial has restricted EMC coverage of counsel tables. And as the court knows, this is a case that's attracted substantial
They want to
national
show
and international
Paltrow
attention. I
during the
think it's
verdict.
actually been
Yeah.
a marvelous opportunity for the public to observe how the court reaches decisions, how cases are litigated, and we all benefit from that transparency,
Here, here.
that accountability. That is what the EMC rule that was adopted by the Supreme Court was intended to serve. And as Your Honor knows, under the EMC rule, Rule 4.401, electronic media coverage is presumed within the limitations of the rule. And subsection 6 of the rule, there's several limitations for not showing the jurors, not showing minors, not showing exhibits that haven't been admitted, etc. Counsel's table is not within subsection 6. So as the rule stands, the presumption is that there should be electronic media coverage of counsel's table. And we just simply wanted to clarify for the court that when the jury comes in and announces their verdict, that the videographer and the still photographer for the Associated Press be allowed to show the public, as everybody here in the courtroom would see, counsel's table. I mean, that is the most important part of the trial. This is what we've all been leading up to. Everybody here in the courtroom will be able to observe
Well, they see it from
counsel
the back.
and the parties when that verdict is announced. And we simply believe that consistent with the rule, unless there is an overwhelming, and the rule says a compelling interest, not to show the parties and the lawyers during the announcement, that it should be allowed and the court should modify
Interesting.
the
This
order
is
to
fascinating.
allow still camera photography and the video coverage. We've participated with Court TV in over 30 years of trials, live coverage. We've never had once a situation where the public wasn't allowed to observe the parties and the counsel when the verdict was announced. And that's for good reason. You've had 7 years of litigation, as I understand it. You've had 2 weeks of trial. And the most important people, the people that have the most interest in the outcome of this
This dude's more
litigation,
prepared for this
parties and their
motion than
counsel.
anybody was for a closing
And the
statement.
public ought to be able to observe them when the verdict is announced.
He's the
And
smoothest
again, under the
lawyer
rule,
in
Your
this
Honor,
room.
the burden is on the party seeking to.
I'm going to start
impose
crying if he
an
keeps
additional
going. This is really getting me.
Under the EMC rule, to come forward with some explanation for why that would be particularly harmful or prejudicial. And there simply isn't any reason for that. If you look at the reasons, the factors that are in the rule, all those factors weigh in favor.
He keeps adjusting that mic like he's a podcaster. They're always having to move mics around.
Of the verdict announcement.
How do you envision this happening physically?
I'm not sure where Wes would like to be positioned, the still photographer. I imagine
there to be a still camera right here.
Okay.
But without an operator, that is be remote. Is that possible?
I'm not sure if that works for still, but the video would just be as the video would normally work.
Right.
For the still.
I want him to walk up and look
there
at
was
his
a
face
still
in the
camera up here
camera.
before, Mr. Hunt, but I don't know how much control the photographer had over that camera. And it had a very big, long lens, and it was focused on one individual.
Mm-hmm.
He says he could fire it remotely from that position, the camera.
But can they? I mean, if it's
the aperture.
Well, I'm just wondering if it would be focused on one individual or be focused on both counsel tables at once. I mean, how
No, he wants to point it straight at Gwyneth.
Let's be real.
Okay. So at this point, physically, what it would require is a photographer to be standing over here and taking pictures. Is that what I'm hearing?
Yes.
Okay. Okay. And I mean, the court TV camera is very unobtrusive. I don't see it. I don't hear it. It can pan and move and do all sorts of things without anyone noticing it. I realize that right
I'll explain
now,
in a second to Glow Pop.
I mean, this will be the end of the case. So the concern of an interruption of the proceeding is different, but it's still there in terms of decorum. How can we maintain court decorum and still meet the request?
It is there, Your Honor, but we could station the photographer there in a place that's unobtrusive. The jury's here. The focus is going to be here. It's going to be very brief. It's not like we're asking.
And why can't the still photographer take stills off of the court TV feed?
I'm not.
That's low risk garbage, Your Honor. Did you see that photographer? He's a pro, man. He doesn't want to do that junk.
Have you seen the
different
thumbnails of this live stream?
both sides.
One was
There's
taken
just
from a
different
live
modes
stream. One PNG was taken
of
from a live stream, one from a
capturing the
photo.
image.
There's a difference.
The still photographer is just set up, designed just for that. The images are richer.
And in your experience or your client's experience, how have other courts handled the still photography?
We usually had the still photographer positioned in a place that's unobtrusive and for limited periods of time and not able to go in and out of the courtroom. It's just there.
Thank you. I'll hear from you again, but I just want to hear from the party.
Sure.
Mr. Sykes?
So Iglo Pop, he wants to modify the order so that they can have a camera pointed at the parties
reasonable.
during the
Right
verdict.
now, there's this tripod over here with the camera on it is covered with a black robe, like two judicial black robes here. And I think if Mr.
It's a second judge.
Bomber was to stand there, and we'll take the screen down. I think that would be fine for us. We don't think that would be obtrusive or violate decorum. So we're in favor of it.
Thank you. Mr. Owens?
He's going to say the opposite.
He hates it.
Yeah,
Maybe he'll be okay
He
this
does not
time,
want
though.
it. Yeah.
She should be able to be on camera for the verdict. Come on.
Yeah. But she, I mean, I don't blame her for not wanting to be.
Thanks, Your Honor. First Amendment's important to us.
Sweet.
There's certainly been a public benefit, I think, to having this.
But
in the public sphere, we've noted 3 violations of the decorum order. the very first day my client walked into the court, after I assured her there would be no photographers in the lobby, there was one right in her face as she went through security. Then suddenly one day another camera appeared, and then a third violation we felt. I don't know if you found a violation, but I have still photos of her being taken just yesterday. So we're all for the First Amendment.
But
The idea
It's
that
not
the public
against us.
should see what we see. The public isn't seated
That's what I'm saying.
in
He's
the
saying
well
they're in
of
the
the
back.
court. The public is seated behind Miss Paltrow.
okay.
The jurors have an interest here. This is stressful for jurors to have a still photographer standing right where that screen is as those folks come in. I think even if their picture isn't taken, I think it's strange. I think it will be stressful.
Grasping at skis on this
Mr.
one.
Sanderson actually has a privacy interest here too.
He waved
He's
it,
not
bro.
asserting that. Yeah.
I thought it was insightful of Your Honor to ask about how this would physically change. If nothing would physically change, and if they're looking at the defense counsel in its totality, defense counsel's table, we would have no objection.
Mr.
Oh.
Hunt?
They don't want the
Okay.
Zoom on her.
So the defense wouldn't have any
Yeah.
objection if nothing changes physically in the courtroom from the way it sits right now?
That's fine, but I still think it would be unobtrusive and completely consistent with court decorum to have the still photographer there for the minute or two that it took to announce the verdict. It's not going to, they'll have already determined their verdict. It's not going to add any additional stress. They have known that there's been media coverage throughout the trial. We disagree that there's been any violation of the decorum order. Counsel has not approached me about that. We're not.
I know you, but I didn't even know you existed in this case until an hour
I've
ago.
only
You don't have to
represented the media
interrupt
in Utah
him.
for 30 years.
Yeah. I know you, but I didn't know you were even involved in this case.
So we're not here about that. We're here about my motion. And it sounds
hate
like
the
we squared
interruptions
away
like
the,
that. It's
the court
so
TV, the
rude.
video. We'd ask Your Honor for the 2 minutes, unobtrusive. Mr. Sykes makes a good suggestion of moving the stand up. And we think that that can be accomplished and the public will be richer for it. We're going to have descriptions about the reaction anyway. The press is going to report that. So why not have the images and the video that actually show what the reaction is so the public can judge for itself what the reaction is. That's the most accurate way to report this to the public. Thank you.
Thank you.
I think it is
Well, given
unusual
the
to put a
fact that there is a
photographer up at the front.
presumption
Yeah.
in the rule,
See, he
and
does.
given the First Amendment, the court will grant the request as long as, for the reasons stated, for as long as that that is used to sort of stand between the photographer, the still photographer, and the jury. So we can turn that sideways. The still photographer can stand quietly, and I assume your camera makes no noise. There's no flash. Okay, you can stand next to the existing camera then, and when the verdict is read. All right. Is there anything else before we adjourn at this time?
There you go.
Can I throw out an issue that will need to be addressed at some point? Your Honor has had a protective order in place in terms of speaking with the press. After the verdict is delivered, is that protective order lifted as to speaking to the press or issuing press releases? I ask because we've received a lot of inquiries. I think the protective order and the decorum order, I think, talk about the evidence, for instance, depositions being held confidential in perpetuity. But the press issue, I think, is appropriately lifted once the verdict is delivered. So there you go.
I don't quite understand your request, your
Sure.
clarification. Are you, so
Yeah,
you're
you
asking,
just kind of
are you
rambled there for a
asking
bit.
to continue the protective order, or are you asking for confirmation that the protective order will be released?
As to the press,
As to the press,
we want it to be released. We don't want certain, for instance, depositions that were taken that were marked confidential, anything that was not, for instance, I have boxes and boxes of things that didn't come into trial.
right.
I don't want that. I want those held.
Everything that was marked confidential according to this court's confidentiality order remains confidential
Correct.
in perpetuity.
If it's been entered into evidence in this court, it's obviously not
Then it becomes
confidential.
public.
And then we do want we do want to be able to speak to the press after the verdict.
You may. Do you have any objection to that, Mr. Sykes? No. Okay. So once the verdict is read, the informal agreement between the sides that they won't talk to the press until after the case, that's then no longer there, and they can talk to the press. And the press can talk to witnesses. The press can talk to jurors if they so desire, and I'll explain that to the jury. And I'm going to ask the press to please acknowledge and respect the wishes of the witnesses and respect the witnesses or the wishes of the jurors. And if they don't want to speak to them, or if they want to wait or maybe later, please respect that. So I expect that'll happen.
Pete just mentioned, the decorum order prohibits any cameras in the courthouse. I think that should be lifted now. I mean, because it's cold out there and wet out there, and they shouldn't have to be out there, and we shouldn't have to go out there to talk to the press if we want to.
Well, I'll consider that, but it's the reason that there's a standing order that there not be press doing things other than inside the walls of the courthouse, other than through a decorum order, or special orders, is for other reasons. There's security reasons, things like that. So I'll talk with those that have some control over that and get back to you on that. Anything else before we adjourn? Not finally adjourn, but take a recess. Okay, so what I'm going to do is when I'm alerted that there is a verdict, I will let the head of security operations, Chris Palmer, know that that's happened. And he will then let all the press know that in approximately 20 minutes or longer, if we need that, at least we'll wait at least 20 minutes before we bring the jury in and read the verdict. So if the lawyers will please leave a cell phone number contact with Jody, then we'll have, we'll call you as well if you're not on premise. All right. Thank you. We're in recess.
Okay. So folks had some questions about what was going on there. So first, when the other lawyer came up, he was representing the media, asking to modify the standing order in the court regarding cameras in the courtroom, because they wanted to add a still photo for the verdict, so that when the verdict comes out, they want to be able to see or take photos of both parties, I suppose, or at least that's what they were saying. But realistically, I think that they're a little bit more interested probably in getting the facial expression of Gwyneth Paltrow. And so that was just basically what they were deciding there. Now, there was also a question about from Christina B. Can either of you explain as lawyers what court decorum is? I know the dictionary definition, but I'm curious about the judicial aspect. I mean, it's just the rules of conducting yourself in a particular courtroom. I mean, it's the reason why so many of us were harping on man bun attorney chewing gum in court as he's reading in deposition testimony the other day. That's typically like one of those things, like you're supposed to conduct yourselves in a certain way when you are in a courtroom. I don't know if you want to add anything to that, Steve.
Well, yeah. So what you see it a lot now, though, is in these media things where they issue out a special decorum thing where you can do this, you can't do that, you can't type on a computer, or you can't get on Twitter or whatever. So you see a lot of amplifications of it. So they're kind of using it in that context here as well.
Yes. Yes. Yeah. So remember in Deputy Heard, there was like no electronics at all allowed in the courtroom, no computers, no nothing. Here, it seems like they allowed some, but I think it was only for people with very specific media designations. Like when they were showing the viewers in the gallery, there was one guy with that was like texting on his phone. He had like a notepad on his lap. He probably was media. But yeah, so there will be certain rules for, and some judges have certain things that they are sticklers about, and then others maybe not. So it can vary from court to court. But there are some rules that will also like be pretty common across jurisdictions. UJ tube, I don't remember there being a photographer at the front of the court during Deputy Heard. I can't remember if there was a photographer at the very front either. I know they had cameras that were angling at them for their facial reactions throughout trial, but I can't remember if they had still photographers. Also, Kit Kat wanted to know, what is a protective order? So a protective order regards the evidence that is, it has to do with the evidence that is passed between the parties in discovery. So remember, before a case gets to trial, you've got pre-trial litigation, and that includes the phase of discovery where both sides are asking each other for all of the information that they have about this case. They do depositions, they ask for documents, they do all kinds of stuff. So oftentimes, because of the nature of the issues that are involved in the case, you can have some very private information that you kind of have to dig into in order to evaluate the case. So for example, Terry Sanderson has made an issue out of his medical status and his medical history. So all of that is fair game for Gwyneth Paltrow's side to dig into, because they have a right to be able to rebut his claims as to his medical symptoms and medical history. So a protective order is where the parties go to the court and they kind of go back and forth on maintaining a level of confidentiality and privacy of that information, because it's like, yes, the other side is entitled to it, but the entire world is not entitled to it. Sometimes you'll have cases that involve tax returns and things like that. That's just like very highly private information. But you don't necessarily want the whole world to get access to it. So that's what a protective order will do, is to limit the public's access to that information that comes out in discovery. I don't know if you want to add anything to that.
Yeah, that's it. Yeah.
Okay. Oh, here's a question also from earlier. I'm so sorry, Brett Johnson. I was sitting on this one for a while. Thanks for the super chat. Can someone sue when someone says something during testimony, for example, defamation for the Jeffrey Epstein remark? There actually is a litigation privilege when it comes to defamation. So that is one of the times where someone can make a claim against someone else. And if it's in a legal filing, if it's in different states, have different sort of like layers of protection, outside of the litigation process, but where it's said literally in court, in trial, like that's one of the most protected areas for the litigation privilege. So yeah, even though he said that and he made that inference, that suggestion that Gwyneth Paltrow might be somehow involved with Epstein Island, the fact that he said that while he was on the stand immunizes him. So interesting little tidbit. Nice catch. Timothy Kersey, thank you so much for the super chat. And I think that's all of the questions that I had saved. So let's end this poll here. It's overwhelmingly in favor of Gwyneth Paltrow. If this chat was the jury, she'd win. 95%. I asked who should win. 95% said Gwyneth Paltrow. 4% said Terry Sanderson. So what do you think?
Oh, I think that's reasonable. Nothing's 100%, but I would be in the 95% category with everybody else. I haven't seen all of it, but yeah, I think she either wins or the jury just says nobody gets anything.
Yeah, which in my opinion is a win for her.
Mm-hmm.
I mean, as the initial defendant, the defendant in the case that has the main set of like really big damages. So yeah, no, I'm with the 95%, and to the 4% that said that you're with Terry Sanderson. I appreciate you being here and voicing your opinion as well, because I love seeing people, not contradicting, but people discussing these things in the chat, and ideally in a respectful way. So I appreciate you guys being here, despite the fact that you have a difference of opinion that is not the one that I share personally. So yeah. So let's see. I'm trying to think. I think that what I'll probably do is we can talk for a little bit more. But I'll probably eventually end the stream, and then when I see that there is some kind of something on Twitter, a notice about like a verdict maybe being rendered, I'll probably pop open another live stream and we can all hop in if you guys want to. But otherwise, like, we can take a break, just like the lawyers in the room.
Yeah, I would be surprised if it's too long before they come back.
Yeah. How soon do you think it'll be?
You never know with this, but to me, everybody seems to have an opinion one way or the other in your chat. And look, it happened, it didn't happen, or whatever. And I think the jury will be the same. I think they're all going to go in there and go, I think this happened or not. It's not a murder thing where you have to sift through DNA evidence and all that. Either somebody's at fault, and they even have the option that nobody's at fault. So I would be shocked if they would spend but so long on that. I do have a conspiracy theory, which is when Paltrow's lawyer said they want to be able to talk to the press after the verdict, because some of your chatter saying maybe she won't come to the verdict, like Depp. He seemed to be really intent on, Judge, let us talk to the press as soon as we get a verdict. So maybe she does want to say something in public with her lawyer. Otherwise, why not have her just not come, and they don't care whether there's a camera on the table or not. So that's my conspiracy theory, is that she'll show up. I think she will show up for the verdict based on that.
Yeah, I have a feeling. Too. And also, well, I don't know. I guess because I was trying to think based on Owens's arguments with the media request, like if his responses, like what he was kind of saying and ultimately agreeing to the modification, if like what that indicates about the likelihood of her being there for it. Because like if she's not going to be there for the verdict, then he could be like, sure, fine.
Yeah,
whatever.
You can have 100 cameras if you want. Yeah.
So I don't know, but maybe you're right. Maybe you're right about that. So yeah, I will say closing arguments. Terry Sanderson's side, I was not impressed. I do think that Bueller was having a hard time asking the jury for the $3+ million. He definitely seemed like he was waffling, not very confident. None of those attorneys on his side came across as if they had confidence in the story of their client. They kept calling it a story instead of like, this is what happened. This is reality.
And they did say that they didn't like him either. So maybe that, maybe it influences it. I don't know. It's all been strange.
Yeah. I mean, that's not the way that I would want to portray my client. Like if I'd be like, yes, he can be very difficult to deal with, but he has a heart of gold.
Right,
I don't know.
Yeah. Put that in there.
Yeah. Just like, what you don't have time to see is what I have been able to see in dealing with this client over time. Like it's, I don't know. El Borit, thank you so much for the super chat. Says, can the jury award Gwyneth Paltrow more than $1 asked by others? No, that's the maximum, because that is the max that she has asked for. So that's as high as they can go. But attorney's fees is a different question. So, but they're not deciding that particular question, it appears. And also, Eleanor Sarah Lee, thank you for the super chat. Alita, please let Southern Law introduce himself. Yes, Southern Law, you have been here a couple times in the last few days on these streams. But for anybody that doesn't know you,
Well, okay. So yeah, I'm an attorney in North Carolina, and I've been licensed for a long time, since back when lawyers were probably first invented. And I did litigation in lots of different areas, and some of it was crime stuff. And so I have an interest in that now. But for the last part of my practice over the past couple of decades has been more corporate, as I was in-house counsel and focused on business. But I did used to represent police departments. I've done some plaintiffs' work. So I've been in some interesting things. I am old enough that I was in the courtroom. I told somebody this story the other day, and they said it was interesting. I was in a courtroom in Winston-Salem, North Carolina, when Johnny Cochran came to try and get the tapes on Mark Furman, because our firm was local counsel for the person who owned the tapes. And I mean, it was, knew the judge very well who'd made the ruling and stuff. He was overruled by the Court of Appeal. So I even had that time. I wasn't the local counsel, but I was in the firm, but I was there. So that's my brush for the famous case. That's probably one of the oldest famous televised cases like that. I saw Cochran in court, and, he's one of those guys that his charisma and presence in the courtroom was as good, I think, as it was portrayed to be. He really was an impressive guy. So there's something.
Wow. That's awesome. That's awesome. Ellen, not Sarah Lee, thanks for the super chat. I thought I recognized that accent. I'm from NC as well, Lexington. That's awesome.
Yeah. I went to Wake Forest for law school, so I went to work in that town after that.
Oh, that's cool. And the question, who's Furman again?
Furman was the detective who allegedly was racist. And I think he wasn't even the guy that found the glove or whatever. So they really needed to impeach him. And they had these tapes of him talking to somebody saying these horrible things. And the question was whether they could force the person who owned the tapes to divulge those, because they would lose their commercial value if they were played out in court, right? At least that was the argument of the person who owned them. And the judge said, no, I'm not going to make this person in North Carolina send these tapes to California. But the Court of Appeal stepped in very quickly and overruled the judge on that and sent the tapes out there, which I love the judge. And but I was personally persuaded by Cochran, even though I was on the other side of it. I thought, the guy's on trial for murder. He made a good argument. So I think the right thing happened, even if I don't agree with the result of the case. I think if you're on trial for murder, you should have access to all the things that could potentially be exculpatory.
Yeah, it makes sense. And generally, you're talking about the O.J. Simpson case, of course.
Yes,
so,
and they didn't play the tapes out loud in North Carolina. The judge went back in camera with counsel and did that, but they came out and discussed what they were. We all kind of got the picture, and of course, it was the contention that he was helping with a story. He wasn't being serious and things like that. But that's, to me, that was more for the California judge to decide that than in our great state of North Carolina.
I love it. That's so cool. That is such a cool story.
That's old school.
I love it. I love it. Girl Scout says, but then why would you take the case? You're talking about if his own attorneys don't really believe him. It could be because they thought, hey, we've got this case against a celebrity. It'll be great publicity for the firm. Or sometimes you take a case and it looks pretty good in the beginning, and then you're halfway through and you realize, oh no, I made a mistake. Yeah. That can happen. So yeah, it could be that they just they lost their belief halfway through. I don't know. Sandra Ramirez, thanks so much for the super chat. Says, we'd love to see you two do a collab on the Manson cases updates. I know it's been so long since I did anything on Marilyn Manson. And that's actually the first time that you were on this channel was we talked about, I can't remember specifically what it was, but it was something about one of those cases.
Mm-hmm.
And that was such an interesting conversation too. We should definitely do some more collabs on that case.
It's in a little lull right now, which has been extraordinary for those cases. They just have rocked on, but I'm enjoying the lull.
Yeah, I know. It's probably the quiet before the storm.
Mm-hmm. Mm-hmm. Another storm.
How it's feeling.
Yeah.
Ellen, not Sarah Lee, says, Southern Law, do you happen to know Jim Weaver? He's my uncle.
Well, I know people.
Another North Carolina attorney.
Well, I don't know because I know a lot of people with that last name, but it's not ringing a bell right now. If it's somebody in Winston, I will say I've been in Raleigh for probably 20 years now. So it's been a while, but there's a lot of Weavers in North Carolina.
That would make sense. That would make sense. Jana says, sorry, I may have missed it, but I know she's asking for her attorney's fees and that was being done separately. Can you please explain how that works? That's usually going to be on a separate motion in front of the judge, I believe. I mean, I'm not familiar with Utah specifically, but my understanding is that's going to be on a separate motion. And also, by the way, it's not just attorney's fees, it's attorney's fees and costs, but also it has to be reasonable attorney's fees and costs. So she may have spent millions of dollars on this case, and it could very well be that the judge says, yeah, but it wasn't exactly reasonable for you to spend as much time as you did. Like all of the hours that your attorneys logged on this and that, like he could totally just slash it in half, as an example. I don't know. Do you have any other insight?
No, that's right. It's not like an economic damages thing. It's not really for the jury to be looking at that, because the judge may have discretion as well, not only the reasonableness, but even whether to award them. It's a lot of weird laws on awarding attorney's fees and things.
Yeah, and that's going to be state by state. So I haven't looked at the Utah laws on that or the particular statute that I think that they're working under. And Girl Scout follow-up question. So wouldn't they encourage him to settle? They may have done that. They may have. I don't know if you know this, but Steve, I'm sure Steve knows this very well. Sometimes when you're the lawyer and you have a client, you can give them all the advice in the world and you think this is the actual best path for you. And they're like, yeah, but I want to do the opposite.
Well, and my wife asked me about this yesterday when we were out hiking and said, how's this case in trial? But it could be either way. He could be saying, I won't take less than $3 million. But also she may say, I will not pay this guy. Because, attorneys have to tell their clients nothing's 100%. So, there's always some settlement value to a case and all that. But apparently it didn't work here.
Yeah. Yeah, because remember, a settlement is an agreement between two parties. It doesn't just take one person to make a decision. He can decide unilaterally to withdraw the case, but he can't decide to just settle at a certain number or to settle at all. She also may be thinking, look, I was skiing with my family. I got hit by this guy. He's taking advantage of the fact that I'm a celebrity and he thinks that he can shake me down for some money after he ran into me. Now, if I settle with him, there could be this possibility that other people are going to try to do the same thing. So if at this point with this litigation, you can, if you're a future person considering litigation against Gwyneth Paltrow as someone in, say, a similar situation or some other kind of negligence situation, you would be looking at what she's done in this case to be like, okay, is she likely to take this all the way to trial? Because are we ready to take this kind of a case all the way to trial against Gwyneth Paltrow? It kind of becomes a little bit of like a liability shield or a litigation shield that people might think twice before suing her in the future based on that.
Another point is, I don't know about in Utah, but here, and I think most places now, the cases often are ordered to mandatory mediation.
Usually, yeah.
So the parties have to eventually get together at least long enough to let a mediator see whether they can pry out any possibility of settlement. So I'm sure it was talked about by one or both parties at some point, but they didn't get there though.
Yeah. Yeah. So yeah, for whatever reason, there was no settlement. So, okay. Well, I think I will probably close out the stream now and stay tuned. I'll probably post, I'll try to shotgun blast on all the social media platforms, about, going live again. So hopefully it'll be today. I think that would be great. So I'm going to be sticking around. I'm going to be, kind of working on other stuff while waiting on this. And then if there is news that they're just going to wrap up for the day, I'll shotgun blast that on social media as well. So, yeah, but thank you so much for being here. Thank you, Steve, for joining me for this.
Thanks
You
for
were here
having
for
me.
most of the day.
Yeah.
Yeah, this was great. And of course, thanks to Kurt, he had to dip out earlier as well. So that was really great to have Kurt from Uncivil Law here. Thanks as always to the chat for having a wonderful discussion. And of course, last but not least, the mods for doing the wonderful hard work of maintaining decorum in our own chat, and making sure that people feel welcome to bring disagreement, but in a way that is hopefully respectful and just allows people to have a comfortable space to sit and watch together and just talk about the way that they see these things. So, all right. Yeah, that for me about does it. Okay. I will see you guys in the next video.